Adjournments. Adjournments.
May I have it on 4 pillars.
Adjournments, page 1, still number 1, page 2, still number 2 to 5, page 3, still number 6 and 7, page 4, still number 8, page 5, still number 9, page 6, still number 10 to 12, page 7, still number 13 to 16.
My lord, serial number 13, my lord. Payment to the appellants, a short accommodation is pre-bound.
Payment of process fee.
Serial number 13.
First time, no?
First time.
Let's do next
We'll
time.
do the next one, my lord.
Yes. Refused. Waiting. So also, but which first orders when it comes. Page 8, syllabus 17 to 19.
My lordship, serial number 19, my lordship. My senior is not well. Missing for 1 week time.
1, 2, 4.
Yes, respondent is there.
Yeah, is it the copies?
Yes, my lord. Today only I received the
Is it
copy.
the copy?
Yes, ma'am.
When consider respondent, please admit that copies are received. Therefore, these objections to be complied. Okay, awaiting service on that. Only from
Okay.
2025. 23, 23, 26. Selected material withdrawn pending application. 6, 23, 3, number 20, 23.
Number 20, madam. I am for the appointment. The register is filed in authority. Only 1 week time, madam.
Who will represent?
I am for appellant, madam.
Appellant.
Yes, madam.
Delay condonation 4
Yes, yes.
delay is condone it to rest. Page 10, cell number 24. Like this, carbon is dismissed. That is his problem, it seems. We'll see when the matter comes. Page 10. Page 10, cell number 24 to 28. Page 1, cell number 29 to 35.
35, madam. 1 week time. For admission.
What?
I will apply.
In records, admit for records for control and all. Because TCS are already available.
These are all business.
Return at the request of appellant. Page 12, cell number 36 to 42. Page 13, cell number 43. Page 14, cell number 44 to 47. Page 15, cell number 48 to 50. Page 16, cell number 51 to 56.
Lord, see number 54, Lord, I put the land. I request for my colleagues. The MC not read the actually informed.
Petition is dismissed or what is that?
It was not, it was not partly allowed, but I'm questioning the only Lord, the part of the conversation as well as the jewelry. To that action, my lordship.
As requested by appellant, also list down because other side is 24.
Interim order kind of interim order is there, it is there, my lordship only can.
Except one. Extended. Extended. Yes. 50. 50. Yes, you appear at home. As requested by the appellant counsel, list down. Wait. Products number 1, M.V. Subramanian, P.V. Sheikh Pratu. That is IA 2 of 2025. It seems that this application is already allowed. That should be heard. Yet is not pending, it seems. Here, register has noted compliance of office subsection and IA 2 of 2025. So, correct. They have mentioned it. IA 2 is already because amendment is carried out. The order is also passed. They have seen that. IA 2, accepting the results obtained in the IA 2 is 2025. That is true. 24 4 I to include the LRs of respondent of 50 was allowed on 24/4/2025. Therefore, office subscription regarding the clients of office subscription number 2025 are unsustainable and disposed of. This is office objections raised on objections to right. Even that also IA is allowed on 24/4. Why did I mention it? That is that. Let them. What is the office subscription on IA1 also at least? No. And the counter to IA1 of 2025, what is the objection? You file. Compliance, if any, on subscription.
Logic and kindly expense the
Why?
wrestling matter and we are facing the need to learn record.
The cost was payable to whom?
Legal services.
Then you are not entitled to this authority.
No, your lordship.
When was the date?
Number request, your lordship. You can kindly listen.
8/4/2025. Actually, I can consider only on that term. At least you should file a memo for a dispensation of any memo.
At least it on record, your lordship. At least.
Parties are there.
Parties are there.
We'll pass it over. In the meantime, you file that. What is the settlement? Discretion or decision?
We are paying 6 lakhs amount, your lordship. As part of one-time settlement for all the years. No, lordship. They do not have any.
You file a memo, then we'll see. We'll pass.
Please, sir.
Pass. Still number 3. What is it? Sign and seal.
Respondent 3 minutes.
Parties are signed each page of compromise petition. Compromise petition is each page not signed by the parties. Where is it? Each page.
And for the appellant in this case.
Yes.
And the last date I have taken steps prior.
No such person.
No, sir. Let's kindly reach you. I'll furnish the proper address by today.
You furnished it, then will why no such person who is owner of the vehicle, sir?
Yes.
You are served before the tribunal?
Sir.
Was he served before the tribunal? He was represented to some counsel.
Claim petition is dismissed, Milan.
See, if it is dismissed, please start on your petition itself doesn't survive.
Please, madam. I'll furnish the proper address today.
2 weeks time is granted to the pay which appeal against respondent and standards. Is now 2 weeks. 18/6.
Much okay.
Still number 4, Dilip Kumar. The same case. Who is the inter-alia? Reliance Insurance. Represents Reliance Insurance panel advocates. Are they? They are not in the panel advocates. Marketing, HSC, shopping market, DJ, marketing, Srimati Malti TN, standing counsel for respond number 3 is requested to accept notice for respond number 3, rest of the one workers at 2 weeks copy shall be served, etc. 2 weeks is granted to do the in respect of respondent. Points. B. Pradeep Paravan. 2021. Number 6. Vijay Ravisati. STF. Is they are completed now. Some orders produced. They have allowed should be an allotment. Now we are producing. And how can you do it at the rate of 2,100 at this point? And how can you do it at the rate of 2,100 at this point? Because in 2012 earlier allotment 6. Now also if you give them at the rate of 2,100, why should they pay? Because now there will be escalation in the cost. ಕೆಲವೊಂದು changes ಕೊಟ್ಟಿದ್ದಾರೆ ಕೊಟ್ಟಿದ್ದಾರೆ 1,100 ಕಾಸ್ಟ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಆಮೇಲೆ ಕಡಿಮೆ ಇದ್ರೆ ಇವ್ರಿಗೆ ಪೇ ಮಾಡಬೇಕು ಅಂತ ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಅವ್ರಿಗೆ 1,100 order is there in the order in the records we saw that it says if the cost is about 2,100 you should pay. If it is less than 2,100 you should reimburse it to the other. Now Suda has issued
within 15 days we will do.
the conditions ಏನಿದೆ
ಗುತ್ತಿಗೆ ಅವಧಿ
10. ಹಣವನ್ನು ಈಗಾಗಲೇ ಪಾವತಿಸಿರುತ್ತಾರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಾಪಿ ಅಂತ long first order when it was passed 2007. Why they are doing like this?
ಇದು process ಆಗಲಿಕ್ಕೆ ತುಂಬಾ ಜನ ಇದ್ರು 250 ಜನ.
Driving them to file restriction contempt. Even the judges who wrote the order retired. Supreme Court retired. ಏನು ಹಾಕೊಡೋದಿಲ್ಲ ಹಾಗೆ ಹಾಕೊಡೋದ ಯಾರು you represent them. AC so and so and AC yes submit. And service allotment letter dated 29/5/25. ಎರಡು ಒಂದೇ letter dated so and so. Another letter dated 29/5/25 issued by ಅದೇ ಲೆಟರ್ ನೀವು ಕಾಣೋದಿಲ್ಲ ಅಲ್ಲ ನೀವೇನು ಹೆಂಗ ಗೊತ್ತಿರ್ಬೋದು ನಾವು ನೋಡೋದಕ್ಕೆ ನಿಮ್ಮ ಖಾತೆ ಹೀಗೆ ಚೆನ್ನಾಗಿರೋ ಹಾಕಿ treat the post like this. Site allotment letter. ಅಲ್ಲ ಇಬ್ಬರೇ ಅಲ್ವಾ ಇಬ್ಬರೇ section submits the registration of the 2 weeks right? The registration shall be positively improving and compliance will be reported based on complaint 70 years better copy is produced for Kumar P. Kumar Farah correspondent. Last time in the record editor and the is recorded in appellants. ಯಾರು ಕೊಡ್ತಾರೆ will issue notice to the claimant. They should try to advocate Minors ಇದ್ದಾರೆ. The appellants is seven. Number 8. HB Rajusian. Number 9. PVM. What happened in the eviction?
Review petition review petition is dismissed. You filed a writ appeal. This is the case where the petitioner is driven that his lands have been utilized without physician. When the matter was listed to the learned senior judge in the writ petition, we filed statement of actions based on the then existing record. That land may have been utilized. And we gave a written statement the statement of actions that we will take steps for acquisition of the land. Later we realized we are not at all pledged. In fact, there was in the record. Now the assistant commissioner has issued an order clearly stating, next year R6 has reduced the commissioner's order. He very clearly states that the petitioner's land has not been utilized at all. And therefore, it is not adequate to bring on, but we have neither utilized or there is a need to I want that affidavit. I don't know. I have gone on record telling an affidavit of the project director on the last date of hearing two days prior. This Honorable Court had directed me to fill an affidavit.
Whether it was delayed by
No,
it's
nobody.
evidence.
Either kindly have a 16.
What did you do to the officer who concealed for that?
I'm sorry.
What did you do to the officer who concealed for that?
No, the then officer went by the then existing record. The revenue records had wrongly indicated that it may have been used. So therefore, it is the state revenue department which allowed. Annexure R16 is an order issued by the assistant commissioner. Upon examination, he states, after conducting survey, he says this land has not been.
You have said it's challenged this order.
Yes.
It
is related.
Not yet closed. There are a lot of objections that are raised in the writ appeal. It is pending. Nevertheless,
But it's a dilemma. The order of the learned single judge is there is substantial delay in the writ appeal. I had advised filing of the writ appeal because
Revision is dismissed.
petition got dismissed. No, but he could not appear on that day. But the learned judge, he was not present. I mean, this is the order showing this is the order. He could not appear.
May I pass on the order of the revocation? Two copies.
The fact of the matter is the petition is dismissed.
Two reviews were filed, my lords.
But the other fact which you lordships will have to consider is that there is a order passed by the commissioner who says that this land petitioner's land neither been utilized nor acquired.
Why did they consider?
Fine, that may be an error. That may be an error to where this some point of time some authority made an error. But there is a verification of that error.
See, how do we accept, how we can accept now at this stage?
My experience would be
If I had revision and that revision is dismissed, on the same ground I have dismissed it.
dismissed.
So, on the same ground I had filed the revision.
Yes, I filed the review petition on the same ground.
That is dismissed.
My lord, I also made an attempt.
You can recover it from the state government if it has state government has utilized.
No, why? Not why would I not?
The fact remains that his land is
The direction, let me see the direction of the learned judge. The direction of the single judge is to take steps to acquire the land. Now, why would I acquire the land when I don't need it?
No, see, because
No, please have the direction. The direction which is said to be disobeyed, but is available at page number in the content petition, page number 11.
11.
In view of the aforesaid categorical statement of which is in conformity with so and so, it is deemed just to dispose of the petition by directing the fund to take necessary steps to acquire the subject land. Remember, I cannot be compared to acquire the land. I don't need it.
See, your person has memo is also extended.
True, I straight away concede that I filed an affidavit. I filed an affidavit saying that we will take steps to acquire the land. Yes.
Internal page 4, the respondents admit that certain portion of land is survey number 97, 98, 99, situated in so and so village. Been utilized for widening the.
I said this on affidavit. I said this on affidavit, but I said it on the basis of the then existing records. Those existing records have been changed by the revenue authorities. The revenue authority. Now, please have a look at annexure R16. Please have one look at annexure R16, which is one of my.
On the same ground, you find review petition.
Yes.
That review petition is dismissed on merits.
Although it has been.
What is the scope of this contempt now?
No, they cannot be an impossibility of complaints. But I can furnish authorities on that. But you don't need, it cannot be come to acquire.
But see, first you came before the court admitting that you have utilized.
Yes. But why did they say that?
You say
Based
that
on certain.
it was under the mistake. You
Yes.
didn't admit.
Yes.
You said.
Yes.
So on the same ground, you went before the judge.
Yes.
But it is dismissed.
Yes.
Petition is dismissed.
No, may I mention this, since your lordships are giving importance to the review order. The review.
The appeal is pending.
Your lordship gave me 2 minutes. And the petition was filed and it was listed. My learned friend Sangdi did not know about it, so it was an order passed without hearing him. I mentioned the matter before the learned single judge, and then the learned single judge when.
Heard the learned counsel for petitioners to peruse with the material and record.
ಇಲ್ಲ there is not.
Return the March 2020.
ಅಲ್ಲಲ್ಲ ಅದು ಮೊದಲು ಮಾಡಿದ್ವಿ ಅವಾಗ ಸ್ಟಾರ್ಟಿಂಗ್ ಮಾಡಿದ್ರೆ there is a second review which was filed.
Second will not maintainable ಅಂತ
Yeah, no. There is a second review.
Officers do all these things.
ಅಲ್ಲ ಅವ್ರಿಗೆ they went by revenue records. There is one important point which I wanted to mention.
Please, after this admission, revenue records are changed.
Yes, after
Yes.
exposure. After it.
Yes, the revenue records have been changed now, but my friend client has to question that they change in the revenue.
I will.
State government has used for what purpose?
The state government also has not utilized. The petitioner is in possession of his land, it has not been acquired. The petitioner is in possession of his entire extent of land. It will be a transfer of justice if he is being compensation for land which is in his possession.
Executing lots that I am doing.
Today also one look at part 16.
Listed with this matter, then means. Yes, what do you want to say?
That two things, Lord. One, when that second review petition was dismissed, without hearing my learned, I mentioned that order is annexure R16 was filed on 8/11/2024 along with affidavit of the project director. 8/11/2024. It was filed along with an affidavit. Annexure R16.
That is R16, yes.
Annexure R16, Lord's God. But it is an order, it is in Canada, it is an order dated 27/9/2024, passed by the Assistant Commissioner. Do that Assistant Director, ADL, Assistant Director of Revenue Records. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 3 ಲಾಸ್ಟ್ ಮುಂದುವರೆದು ರೀಸರ್ವೆ ನಂಬರ್ 93 94 95 96 ಕ್ಲೇಮ್ಸ್ ದಟ್ ಇಸ್ 96 97 98 ತಿದ್ದುಪಡಿಯ ದಾಖಲೆಗಳನ್ನು ಏನಪ್ಪಾ ಬಾಕ್ತು ಸ್ಥಳದಲ್ಲಿ ಪ್ರತಿಯಿಂದ ಪರಿಶೀಲಿಸಲಾಗಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 48ರಲ್ಲಿ ಹೋಗಿರುವುದಿಲ್ಲ. ಅದರಂತೆ ಪ್ರಸ್ತುತ ನಂಬರ್ 97 98 99ರಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಹೋಗಿರುವುದಿಲ್ಲ ಎಂದು ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ಅವಗಣನೆಗೆ ಗೌರವಪೂರ್ವವಾಗಿ ಸಲ್ಲಿಸಿದೆ. highway is not gone there at all.
May I submit the notes? Notes may kindly come the annexed R16 which they are pressing upon. This is 27/9/2024. Notes the order which I am seeking for implementation is the year 2023. Notes there was one officer who had conducted a survey in the writ petition what I had filed notes in before the learned civil judge. I have produced a joint survey report which was conducted by the surveyor of the National Highway in my presence, as well as the surveyor of the Tahsildar, attached to the Tahsildar office. And on the basis of that report, plus this order is passed. And not the concerned officer who was then the officer of National Highways. He filed a statement of objection stating that yes, the land has been acquired. Now there is a change in the office. Subsequently, I file a contempt petition. Then notes they file a review petition. Review petition is dismissed. Still this contempt is pending. Then they file one more review on the basis of this R6 report, the second review, saying that notes they have conducted a survey now in my absence. There is no notification.
You are not.
I am not a part of this R16. They conducted
challenge it. He is free to challenge it.
It is only to
Something. Now,
it is only to overcome this order. All this exercise is being done.
there is an order of the court on concession. Now you are saying concession is wrong. On that ground, we filed the petition is dismissed.
No, I mean, I did not follow the concession. What is the concession?
Your admission is there recorded.
Yes, yes, yes. But I have my now contention is
Page number 4, right?
true that admission I made based on incorrect records.
Correct.
I am withdrawing that statement. If I withdraw that statement, then that order also does not exist.
Right. But saying so, and the petitions
Yes.
are dismissed.
Yes, in fact, when
Given an opportunity, I'll read 2 lines. Their own annexure.
the review petition was dismissed, I made a mention.
That's true. How I should be made to turn on the one point. But let's make kindly see as the order is passed in 2022. But kindly come to annexure 16, which they have not filed here. I'll read only 2 lines starting the term notes.
He has refused to accept the notice when the survey, the instrument issued by the authority say, he is, not,
let him complete. I will submit.
All right, where, what?
Page 8 notes of the order notes which they are running page 8 notes. Your Lordships will find reference there. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಕಸಬಾ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 97, 98, 99 ಜಮೀನುಗಳು ಮತ್ತು ಜಂಟಿ ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಕೋರಿರುವಂತೆ ಉಲ್ಲೇಖ 2 ಅನ್ವಯ ಸರ್ವೆ ನಂಬರ್ 91, 98, 99 ಜಮೀನುಗಳಲ್ಲಿ ಜಂಟಿ ಅಳತೆ ಕೈಗೊಂಡು ನಕ್ಷೆ ತಯಾರಿಸಿ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 3 ಅನ್ವಯ ಸರ್ವೆ ನಂಬರ್ 65ರಲ್ಲಿ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಿಯಾಗಿ ಕೋಡಿಯಾಗಿ ಸರ್ವೆ ನಂಬರ್ 95, 96, 97, 98, 99, 100 ಸರ್ವೆ ನಂಬರ್ಗಳು ದುರಸ್ತಿಯಾಗಿರುತ್ತವೆ. The Lords may kindly refer to these ಉಲ್ಲೇಖs 1, item number 1, item number 2 and item number 3. Your Lordships will find all are dated subsequent to the decision. All the records are being done behind my back after the order is being passed without issuing one notice to me.
It was being submitted, he refused to participate in the list.
ನನಗೆ ಯಾವ ನೋಟಿಸ್ ಬಂದಿಲ್ಲ, ಸರ್ವೇನು ಮಾಡಿಲ್ಲ, ನನ್ನ ಪ್ರೆಸೆನ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ. On the hand, in the writ petition which I got, in the writ petition along with the survey report I have filed, but that was conducted by in the presence of the surveyor National Highway. I will produce your Lordships that
See,
survey also. Nevertheless,
step number.
it is WA number 476.
I will not oppose for an adjournment. Let that take 2 weeks adjournment. Get that written list.
That's what, again, what happens, they will not.
I am seeking I don't know how my understanding is under misconception. I am not seeking an adjournment. But if the Lord want to list the writ appeal, no, I will fix the number, which is writ appeal 476.
I wanted to list it, but when you file a writ appeal that's related, this is of the year 2022. Order is
The compliance I get it.
and now 2025.
I'll get it.
First of all, there is inordinate delay in filing the writ
Yes,
appeal.
there is.
Then you should pursue that.
Lord, all the office objections, my instructions are clear. Your Lordships have to list it. Your Lordship may direct listing along with.
but writ appeal may not be.
Huh?
It may not come before this court, Lords. Anything is.
The Lordship may pass, but
Keep it pending till then. Do you want it to be done?
I don't want to merge. I have been pursuing, Lords. It has been
Or
done.
Lordship may direct
My
Lordship may direct that matter
Review
along with this. I will request Mr. Andy to request to the
No, we will
request to the registry to obtain special orders and get it listed.
sustain it.
Lords, I would only request this, whatever them want to do, but then Lords, let me relieve of this litigation, because ಇದನ್ನ ಕಂಟೆಂಪ್ಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ ಈ ಕಂಟೆಂಪ್ಟ್ ಪೂರ್ವ ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಫೈಲ್ day 1 when the notice.
Someone who has not lost an inch of land cannot make this.
I am sorry, Lords. That is,
Lords,
I am not. I have been very. This reason.
Conduct, no, there is no question of commenting on the conduct. You
No,
should
Lord,
not comment
but
on
they have
but
to
my
look at the
submission
conduct
would be
of
on the
their
conduct.
officers
Lord,
first.
when I make my submission, I will do. Lord, his conduct, I am going to question and I lay before your Lordship.
No, no,
Your Lordships are entitled, my Lord, in a writ petition as well as in a contempt petition.
You should place us the material and then you can comment on the conduct.
The material I have already placed. I have to only make a submission, which I will do when the writ appeal is taken up.
right? See, now you are at the receiving end. Because
Yes, my lord, there is an order which directs.
so, unless you
Better. It is a better.
substantially show us that there is anything wrong, because you are now appeal is
My lord, it has to come up along with the IFR condemnation of delay.
At this stage, why do you keep fighting amongst yourself, making comment on the
ಅಲ್ಲ
conduct
ನಾನು
of
ಏನು
that's because, my lord,
making conduct?
Lordship may call the writ appeal along with this.
She so and so senior counsel. Yes, yes.
Yes, yes, I am appearing as ASG. You know, this
ASG.
central government.
ASG submits that challenging the order of the learned single judge regarding which the contempt petition is filed. Respondent number ಎಷ್ಟು? You are for?
I'm for all of them.
All of them. Or special land acquisition officer ನಿಮ್ಮ ಆಫೀಸರ್ ಆಗ್ತಾರೆ. Though is assistant commissioner.
Lords, I have one
Sir,
submission
accused
to
number
make,
1 to 4.
Lords, before your Lordships. I have one submission to make.
Yes.
Lords, if your Lordships are tagging this matter along with the writ appeal, Lords, I would say for one reason I may oppose it for this reason. Lords, the writ appeal, they have still not complied the office objections. Lords, they may take their own time to comply those objections. In the meantime, Lords, my contempt petition is adjournments, but at the same time,
You would be the only respondent in that appeal.
I am the only respondent in that appeal.
Could
But
be,
then,
because
Lords,
it's
that
not
writ appeal, Lords, they may comply at their own pleasure. But my contempt.
How, when the court directs them whether they can do it at their own pleasure?
Therefore, I would request this, my lords, your lordships, my lords, keep the contempt pending as it is. In the meantime, if they want, let them get it
That's
listed,
what
my
we
lords.
are ordering to
ಯಾಕೆಂದ್ರೆ
list the
ನಾವು
matters.
ಕಂಟೆಂಪ್ಟ್ ಅನ್ನು ಅದ್ರ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಟ್ರೆ ಲಾರ್ಡ್ಸ್ ಐ ಹ್ಯಾವ್
ಎರಡು ಬೇಗ ಆಗುತ್ತಲ್ಲ ಅವಾಗ.
ಬೇಗ ಆಗೋ ಪ್ರಶ್ನೆಗಿಂತ ಇನ್ನೊಂದು ಏನಾಗ್ತಾ ಇದೆ, ನನಗೆ ಐ ವಾಸ್ ಮೇಡ್ ಟು ವೇಟ್ ಫಾರ್ ದೀಸ್ 2-3 years ಓನ್ಲಿ ಆನ್ ಒನ್ ಆರ್ ದ ಅದರ್.
Contention ಅವಾಗ.
I would make one submission, my lords.
ಒಂದು ಬೆಂಚ್ ಮುಂದಿರುತ್ತೆ, ಇದೊಂದು ಬೆಂಚ್.
My lords, one submission.
ಅಲ್ಲ, ನಾವೇನು ಡೇಟ್ ಕೊಡೋಣ ಇಲ್ಲಿ.
That's why I will make one submission, my lords. Let your lordships record their undertaking that they will get it listed within 2 weeks. I am not opposing for adjournment. Lords, they should be in a hurry to get it listed for the reason that if they want to stall my contempt
particular day, why are you so much touched about it?
Lords,
it helps
for
you
this reason,
only.
ಈಗ ಕಂಟೆಂಪ್ಟ್ ಕೋರ್ಟ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತಾನೆ ಇನ್ನೊಂದು 4 ವಾರ ಹೊಟ್ಟೋಗುತ್ತೆ, ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು
Why do you presume that?
because this has been happening in this case for so reason. Lords, I would only say this, Lords.
Then
Why
Mr. Counsel, if that is the case, we have to infer something for this.
Lords, there is no need of any inference. ನನಗೆ ರಿಟ್ ಅಪೀಲ್ ಅವ್ರು ನಾಳೆನೆ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಬಿಕಾಸ್ ಈ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಂತ ನನಗೆ ಐ ಹ್ಯಾವ್ ಬೀನ್ ರನ್ನಿಂಗ್ ಅರೌಂಡ್ ಫಾರ್ 2 years now. Lords, let them say that they will get it posted within 2
ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕೂಡ ಹೇಳಿದ್ರು ಅವರಿಗೆ.
ನಾನು ಈಗ
ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
I have
they are listed together, we can insist them to do that, otherwise they lose it either on merits or on
ಅವರು 2 weeks ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. Let there be leisure time, 2 weeks, let them take, Lords. Let them take 2 weeks time. Let them get it listed.
Now we are dictating the order. Why are you interfering?
I am only submitting, my lords. Let this contempt be as it is, so that let them have some hurry to list that writ appeal. ಇದು ಅದರ ಜೊತೆ ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ they have been given several chances in the review.
We'll pass our order. Please allow us to pass our order. And despite we saying that there is no need to raise your voice, you keep shouting. Yes. In writ appeal number ಬರ್ಕೊಡಿದ್ದು ಯಾವುದು? So okay. It is submitted that even office objections in the said writ appeal are complied. Since these two matters have bearing on each other, place the matter before Honorable the Chief Justice for acting Chief Justice for listing both the matters, for necessary order to list both the matters together. ಆಯ್ತು ಆರ್ಡರ್ ಆಗಿ ಬಂದ ತಕ್ಷಣ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ಈಗ ಒಂದ್ಸರಿ ಲಿಸ್ಟ್ together
I am obliged, my lords.
ನಿಮಗೂ
sorry,
ಅರ್ಜೆಂಟ್ ಆಗಿ ಆಗುತ್ತೆ
No, may make this submission. Probably my learned friend was not aware of it. He kept requesting that let the respondent take steps to get it listed. But here your lordship are passing a judicial order for listing. I mean, that is the highest. What more is required when there is a judicial order?
Anxiety of both of you will be addressed by this. If both of them come together, if they fail in the writ petition, your way will be cleared. Or if they succeed, then what order ultimately.
Lordship even fix a date.
Now ಒಂದ್ಸರಿ place before ಅಂತ ಮಾಡಿದ್ಮೇಲೆ whether it goes to some.
ಅಲ್ಲ ಒಂದು 2 ವಾರ ಬಿಟ್ಟು in the meantime I will request Mr. Angadi to request the registry to get special orders passed by the Honorable Chief Justice so that it can
of Honorable ACJ. List the matter soon after the special order of Honorable ACJ. Yes. ಅದ್ರ ಮುಂದೆ ಬರ್ಕೊಂಬಿಡಿ. Law Counsel for complainant submits that the matter may get delayed. Therefore, list the matter soon after the special order of the learned ACJ.
Obliged.
ಸುಮ್ನೆ ಇಬ್ರು ಟೆನ್ಷನ್ ಮಾಡ್ಕೊಳ್ತೀರಾ. Yes.
Kindly weeks time.
127 days delay ಇದೆ ಅದ್ರಲ್ಲಿ. ಏನಂತ ಬಂದಿದೆ ಥರ್ಡ್ ಟೈಮ್. Respond number 1, whether he was he had appeared before.
Owner appeal madam.
ಅಲ್ಲ one ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ HCC advocate for R3 respond number 2 is placed ex parte.
I take steps for kindly weeks time. R3.
ಏನಾಗಿದೆ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಲ್ಲಿ.
R1 ಮೇಲೆ ಆಗಿದೆ ಸರ್.
R1 ಮೇಲೆ.
Yes ma'am. Owner of the vehicle.
ಅಲ್ಲ R1 ಏನಾಗಿತ್ತು? R1 some advocate had appeared for him. At request finally it's ಸರಿ ಬರ್ತಾ ಇದೆ ಥರ್ಡ್ ಟೈಮ್.
Yes.
2 weeks time is granted to do the needful in respect of respond number 1, failing which appeal against respond number 1 shall stand dismissed. Yes. Yes. Copies to the first respondent, first time. Okay. They are, let's see. At least 2 weeks time is granted to the lady. Yes.
For the appellant my lord.
ಇವರೇನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ರೆಫ್ಯೂಸ್ಡ್ ಅಂತ, ಅದಕ್ಕೆ ನಾನೇ ಮರಿತಿದ್ದೆ. ನನಗೆ ರೆಫ್ಯೂಸ್ಡ್ ಅಂತ ನಂಬಕ್ಕಾಗಲ್ಲ ಕೆಲವೊಂದ್ಸರಿ.
Even before the trial court, she was placed ex parte.
ಅಲ್ಲ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸರ್ವಿಸ್ ಥ್ರೂ ಮಾಡಿದ್ವಲ್ಲ. ಆಸ್ ಪರ್ ದ ಕೋರ್ಟ್ಸ್ ರಿಪೋರ್ಟ್, ಅಡ್ರೆಸ್ ಆಫ್ ರೆಸ್ಪಾನ್ಸ್ ಸಿಚುಯೇಟ್ಸ್ ವಿತ್ ಇನ್ ಹೊಸಕೋಟೆ ಲಿಮಿಟ್ಸ್. Therefore, issue notice to respond for service to the process branch of Bangalore Rural District. Hoskote Bangalore Rural District alle baruttane. Needful is done within 10 days. Have done the needful?
Please.
ಆಯ್ತು, ಟೆಲಿಫೋನಿಕ್ ರಿಕ್ವೆಷನ್ ಮೇಲೆ ತರಿಸ್ಕೊಳ್ಳಿ ನೋಡೋಣ. Registry shall secure the report of the concerned court regarding the status of service of notice on the respondent expeditiously. List on. ಇಲ್ಲ ಈಗ ಒಂದು ಹೋಗಿತ್ತು, ಅದಕ್ಕೆ 2 weeks ಬೇಕು, 10 days ಬಿಟ್ಟು 18/6.
Oblige.
ಇನ್ನು ಕಂಪನಿಯಲ್ಲಿ ಇದಾವ ಸರ್ವಿಸ್ ಮಾಡಿ ಕಳ್ಸಕ್ಕಾಗಲ್ಲ. So it is not residing in given address ಅಂತ ಬಂದಿದೆ.
No, Your Honor, it is served, Your Honor. Served through court as well as the RPID.
ಅಲ್ಲ ನಾವು ಕೋರ್ಟ್ ಥ್ರೂ ಹೋಗಿರೋದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್ವ್ಡ್ not residing in the given address ಅಂತ ಬಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. RPID didn't accept that.
No, it is delivered, Your Honor. Report. CS report is delivered.
ಅಲ್ಲ ರೀ, ಕೋರ್ಟ್ ನಿಂದನೇ ನಮಗೆ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ ಇಲ್ಲಿ not residing in the given address ಅಂತ. ಯಾವ್ದದು ನೀವು ತೋರಿಸ್ತಿರೋದು?
ಹೈಕೋರ್ಟ್ ಮೇಡಮ್.
ಅಲ್ಲ ಯಾವ್ದು ಪೋಸ್ಟ್ ಆಫೀಸ್ ಇಂದ? See, last time we had issued notice, we didn't accept.
No, it is downloaded from High Court website, Your Honor. ತೊಳಿ ಅಮ್ಮ ಇದು ಕೊಡಿ.
ಹಾಗೆ ಕೊಡೋದಲ್ಲ, ಕೊಡೋದಿದ್ರು ನೀವು ಮೆಮೊ ಹಾಕಿ
Yes,
ಕೊಡ್ಬೇಕು.
yes, your lordship. I will produce it, Your Honor.
Counsel for appeal.
It is served through court as well as the RPD, Your Honor. Both reports are there. Both are noted in the CIS, High Court website.
Additional senior civil judge Gubbi. Dismissed. Therefore, there is no.
I will furnish it through memo, Your Honor.
ಇನ್ನು ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ವಾ? ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದ ಕೊಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನ ರಿಪೋರ್ಟ್ ಇಲ್ಲವೇ ಇಲ್ಲ. ಮನೆಗಂತೂ ಒಯ್ಯೋದಿಲ್ಲ. ಬೇರೆ ಇದೆ ನೋಡಿ. ನಾನು ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಟು ರೆಸ್ಪಾಂಡ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ರಿಟರ್ನ್ ವಿತ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅನ್ಸರ್ಡ್ ಅಂತ ಇದೆ. ಆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರಿಪೋರ್ಟ್ ಇಲ್ಲಿ ಹಿಂಗೆ ಹಾಕಿದಾರ. ಮೇರೆಗೆ ನೋಟಿಸ್ನೆಲ್ಲ ಕಂಡ ಪ್ರತಿವಾದಿ ವಿಳಾಸ ವಿಚಾರ ಮಾಡಲಿ. ಪ್ರತಿವಾದಿಗಳು ಸಿದ್ದಾಪುರಹಳ್ಳಿ ವಾಸವಿರುತ್ತಾರೆ ಎಂದು ಮತ್ತು ಗ್ರಾಮಸ್ಥರು ತಿಳಿಸುತ್ತಿದ್ದ ಜಾರಿಗೆ ಅವಕಾಶವಿದೆ. ನಕಲು ದಾವಕಾಶ ಇಲ್ಲಿ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಇದೆ ಅಲ್ಲ, ಇದರಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬೇಲಿಫ್
ಅಲ್ಲ, it is the court record, Your Honor. I have downloaded from the CIS.
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್
ನಮ್ಮ ಹೈಕೋರ್ಟ್
ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲ, ಇಲ್ಲಿ ರಿಪೋರ್ಟ್ ಇದೆ ನೋಡಿ, ಅದನ್ನ ಚೆಕ್ ಮಾಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದ
I will furnish it memo, Your Honor.
ಅದು ನಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. ಆದ್ರೆ ತಪ್ಪಿದ್ರೆ ಏನದು ರಿಪೋರ್ಟ್ ಕೊಡಿ ನೋಡೋಣ. ಅವ್ರು ಅಷ್ಟು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, the item is delivered.
ಅದು ಹಿಂದಿಂದು ಬೈ ಪೋಸ್ಟ್ ಹೋದಾಗ ಇಟ್ ವಾಸ್ ಶೋಡ್ ಆಸ್ ಐಟಮ್ ಡೆಲಿವರ್ಡ್. ಅದು ಪೋಸ್ಟಲ್ ಟ್ರ್ಯಾಕ್ ರಿಪೋರ್ಟ್ that we did not accept, so we issued notice to the trial court.
Even from the court it is delivered, alva additional court.
ಅರ್ಥ ಮತ್ ನಾವ್ ಹೇಳೋದು ಅರ್ಥ ಆಗ್ತಾ ಇದೆಯಾ?
Yes, my lord.
We did not accept that. We issued another notice to the trial court.
Yes, I have taken steps, Your Honor, my lord.
Says ಅವರೆಲ್ಲ ಬೇರೆ ಹಳ್ಳಿಯಲ್ಲಿ ವಾಸ ಇದ್ದಾರೆ ಅಂತ ಬಂದಿದೆ ಅಂತ ಕಳಿಸ್ತಾರೆ.
Yes, I have given another address, Your Lordship.
ನೋಟಿಸ್ ಎಲ್ಲ ಕಂಡು ಪ್ರತಿವಾದಿ ವ್ಯವಸ್ಥೆಗೂ ವಿಚಾರ ಮಾಡಿ.
Again, steps found in last year month.
ಸಿದ್ದಾಪುರಹಳ್ಳಿ ಹುಲಿಕೆರೆ ಪೋಸ್ಟ್ ತುರುವಿಕೆರೆ ತಾಲೂಕಿನಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ ಅಂತ ಬಂದಿದೆ.
Yes.
ಅದಕ್ಕೆ ತಗೊಳ್ಳಿ ನೋಟಿಸ್ ಬೇಕಾ?
ತಗೊಂಡಿದ್ದೀನಿ, Your Lordship. Last time ತಗೊಂಡಿರೋ ಅದನ್ನೇ, my lordship. ನೋಡಿ ಒಂದ್ ಸ್ವಲ್ಪ ಕೊಡಿ, ತೊಳಿ ಸ್ವಲ್ಪ ತೋರಿಸಿ ಕೊಡಿ, ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡಿ, ನೀವು ಸರಿ ಇದ್ರೆ ನೋಡಿ.
As per the report of the trial court, as per the report of trial court, address cannot be located anta ide anta adralli.
My lord, she is maintaining another petition before the Gubbi court, Your Honor, in criminal miscellaneous 4/23.
ಹೇಳಿ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಸರ್ವ್ ಮಾಡೋದಕ್ಕೆ ಹೇಳ್ತೀವಿ ಆ ಕೋರ್ಟ್ ಅಲ್ಲೇ.
Yes, my lord.
ಯಾವುದು? What is that case?
That is criminal miscellaneous 125 proceedings is pending.
ನಂಬರ್ ಏನು? ಯಾವ ಕೋರ್ಟ್?
Number, Your Honor, 4/23 additional JMFC Gubbi.
ರೆಕಾರ್ಡ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ತೋರಿಸಿ ನೋಡೋಣ.
I have appeared myself, Your Honor, in the CIS.
ನೀವು ಏನಿದ್ರು ಸಿ ಇಲ್ಲಿ ಹಾಗೆಲ್ಲ ಹೇಳಿದ ತಕ್ಷಣ ನಂಬಕ್ಕಾಗಲ್ಲ. ಹೇಳಿದ್ರು though we know each other.
Yes, I will file memo up to that effect, Your Honor, in writing. Yes, my lord.
ಅಲ್ಲ, ಅದ್ರದ್ದು ಒಂದು ರೆಕಾರ್ಡ್ ಹಾಕಿದ್ರೆ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಟು ದ ಟ್ರಯಲ್.
One short date ಕೊಡಿ, my lordship. Next week ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ, my lordship. I will furnish everything.
ಯಾವ ಕೋರ್ಟ್ ಇದೆ?
ಸೇಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದಾರಾ?
As per the report of additional senior civil judge.
Yes, ma'am.
Additional report of the bailiff of additional senior civil judge and JMFC Gubbi. The respondent is not residing in the address furnished in the appeal memo. Now counsel for the appellant seeks time.
Your lordship, I may be permitted to serve the copy in the court itself. In the.
You first produce us material to
Yes,
show
my lord,
that
yes.
there is another case pending between the parties.
Yes, my lordship. Yes, lordship.
2 weeks time is granted to them.
My lord, serial number 16, my lord.
I have to take steps for R1. 2 days time I can.
The set request 2 weeks time is granted to them. ಅದಲ್ಲ ರೀ, ನೀವು have to produce us
Yes, I will produce it.
order copy, certificate
Yes,
copy of the order sheet, something like that.
Yes, lordship, I will produce it.
ಮತ್ತೆ ಅದನ್ನೇನು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Yes, lordship. Yes. Please, Your Honor.
My lords, I appear for the appellant in this case, my lords. My lords, there is a refusal, my lords. Service may kindly be taken as properly done and orders may.
My lord, I undertake to file
Sir,
power
undertaking
on
to
behalf
appear,
of the
sir.
respondents.
ನಿಮ್ಮ ಹೆಸರು ಬರ್ಕೊಡಿ ಶ್ರೀಮತಿ so and so Lawrence Council undertakes to appear for respondent. She shall file the wakalat in the registry. ಏನಿದ್ರೆ interim stay ಇದೆಯಾ? ಇಲ್ಲ,
My lords,
direction.
it's against dismissal, my lords. The appeal is against dismissal.
What is this
And
direction application?
my lords, the direction is for interim application for interim custody, my lords. That's been pending since the trial court itself, my lords. If next week one date is fixed, my lords, the other side may file objections.
I'll file it today, sir.
To file the wakalat in the
My lords,
in 10 days, list on. You serve the copies are served on you.
I'm
You
not
serve the
served,
copies.
my lords.
Refuse
ma'am.
ಅಂತ ಬಂದಿದ್ರೆ ಹೇಗೆ ಸರ್ವಿಸ್ ಆಗುತ್ತೆ?
Please, my lords, I'll serve.
Her name shall be shown in the cause list.
Written.
Right now, I will get it served.
File ಅಲ್ಲಿ
My lords, there is
ಇದೆ ಬಂದಿದ್ರೆ ಕೊಟ್ಬಿಡಿ.
refused ಅಂತ ಬಂದಿದೆ.
10 days ಒಂದು 2 weeks ಆದ್ಮೇಲೆ.
One date may kindly be given, my lords. There is urgency in IA, my lords. It may take.
We are fixing the date, you said.
Please,
In the pending
please, much obliged.
application for temporary custody. Trial court ಇಂದಲೂ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ ಅಲೋ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ.
Much obliged.
Appearing for R2, my lord, I'm filing wakalat on behalf of R1, my lord.
ಏನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ raised on PF. ಅಲ್ಲ ಒಬ್ಬರಿಗೆ ಮಾತಾಡ್ತಾರೆ. He says he is going to appear for only one. So you undertake to appear for respondent number 1 alone.
My lord.
Who respondent number 2 is the minor.
Yes, ma'am.
My lord,
Mother is.
Mother, my lord. Okay.
So both you have to file.
My
Mother
lord,
has to execute the wakalat for daughter also.
Please.
in the
My lord, daughter ಇದು ಅವ್ರ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದ್ದಾರೆ, my lord.
ಅವ್ರ ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದ್ದಾರೆ.
ಹಾ, ಹೌದು.
ಹಾ, ಇದು.
my lord,
custody is directed to be handed over.
no, the facts need to be clarified here.
Furnish ಆಗಿಲ್ಲ, my lord.
Facts need to be clarified here before
Why
this
have you
honorable
made the
court.
child respondent?
Pardon?
Why have you made the child respondent? Child is in your custody.
My lord, it is not so. Child was voluntarily given in custody to me.
Correct. That is all on merits.
Ah.
If the child is in your custody, you should have made the child as a appellant.
ಮಾಡಿದೆ child ಗೆ
So you have made that mistake.
respondent number 2 ಮಾಡಿದೆ ನಾನು.
ಮಾಡಿದ್ರೆ.
apropos the trial courts apropos the
Your mistake before the trial court.
Delete that.
It is your mistake before that. ಅಲ್ಲ, ನಮ್ಮ ಆಫೀಸ್ ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ತಾರೆ, ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
Otherwise you have to argue here and go this side and argue for child.
Why did you make the child second respondent? You could have made it the appellant.
No, I have made it respondent as per apropos to the trial court's order sheet.
But child is in your custody. No?
In my custody. And not practically,
If I ಮಾಡ್ಬಿಡೋಣ ಅಷ್ಟೇ.
no, you are not in de facto custody of mine.
What is the age of the child?
12,
8 years. ಅಲ್ಲ,
12
ಅವಾಗ-
years, 12 years now.
ಆಕೆ ನ್ಯಾಚುರಲ್ ಗಾರ್ಡಿಯನ್ ಮಾಡೋ ಅವಶ್ಯಕತೆನೇ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲಿ. Shri so and so council undertakes to appear for the first respondent. Admittedly, respondent number 2 is in the custody of the appellant itself.
My lord, paper furnish ಆಗಿಲ್ಲ. Please.
Therefore, since respondent number 1 had included her as petition number 2, the appellant has included her as respondent number 2. Anyway, she is a pro forma party. The council, Sri Shonsa council shall file the wakalat in the registry within 10 days.
Please.
Am I at liberty to make a submission here?
His name shall be shown in the cause list according.
The issue is the child was given in my custody from up to 2020. Pardon me, Lord?
Sir, the copies on him.
I would
Sir, the copies.
But I want to make an interim submission, Lord. Please have a glimpse at IA number 2. IA number 2 filed by me.
IA number 2 is
IA number 2 under section 151 CPC.
admitting the child to Convent Jesus Mary, Mussoorie, Uttarakhand. You are from which place?
The child was studying in the Mussoorie school. In the month of March, respondent number 1 went there. Respondent number went
The
there.
child is 12 years. Earlier, where the child was studying?
Mussoorie.
Mussoorie only.
Yeah.
My lord, past 3 years in the respondent 1 hour respondent 2 ಅನ್ನೇ ನೋಡಿಲ್ಲ my lord. Hide
Correct.
ಮಾಡಿ.
Now, whatever may be your dispute, the academic career of the child should not suffer. He says earlier also child was studying in Mussoorie.
Yeah.
Do you have any objection for admission of the child in the school?
No.
Why permission is required? He could have admitted.
Because my lord, after the respondent number, after the respondent number went to Mussoorie school in the month of March of this year, and she made a hue and cry there. Now school says.
Made allegation.
Now school says without specific court order, I would not readmit the child. Her academic year is.
The academic year starts.
It has started. It is now starting.
ಮಗು ಇದು ಹೋಗುತ್ತಲ್ವಾ ಲಾಸ್ ಆಗುತ್ತೆ
ನನ್ನ ಖರ್ಚದಲ್ಲಿ ಮಾಡಲಿ ನನ್ನ ಖರ್ಚದಲ್ಲಿ ಮಾಡಿದ್ರೆ
3 years ಇಂದ ಮಗುನೇ ನೋಡಿಲ್ಲ
same school child is studying now.
Yes.
Which class?
Now she is in third standard.
Third standard. Admission for third standard.
From second standard to third standard she has to be readmitted.
Expert ಏನಾರ ಇಲ್ಲ expert ಇಲ್ಲ is from Malaysia. Why petition was filed here? Child was here.
My lord, ನಾನು ಕಾಪಿ ಇನ್ನು ಫರ್ನಿಶ್ ಮಾಡಿಲ್ಲ.
Mount Layout, Bangalore. You were residing in Bangalore.
No, child was in.
Child, where were you residing when the petition was filed? When the petition before the trial court was filed, this 2021 petition, where the child was residing?
She was residing in Bargad of Odisha state.
Then
studying in Rotary.
See, the petition is to be filed where the child resides. Then why did you not object for that?
ಆಗಿಲ್ಲ ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಇಲ್ಲ ಇವರು ಎಲ್ಲ ರಾಂಗ್ ಅಡ್ರೆಸ್ ಗಳು ಕೊಟ್ಬಿಟ್ಟು ಕೋರ್ಟ್ಗೆ ಮಿಸ್ಗೈಡ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗೆ ಕೋರ್ಟ್ಗೆ
petition notice was issued to respondent, same was returned answered as respondent is not given residing in the given address, respondent through paper publication.
ಅದು ಯಾವುದೋ ಒಂದು ರಿಮೋಟ್ ಕಾರ್ನರ್ ದಲ್ಲಿ
we have to grant interim stay even if
ಅದ್ರಲ್ಲಿ ನಮಗೆ ಪೇಪರ್ ಬುಕ್ ಇನ್ನು ಫರ್ನಿಶ್ ಆಗಿಲ್ಲ ಫೈಲ್ objection.
Petition has to be filed where the child resides. When the petition was filed where the you have shown Bangalore address but they were not served. Paper publication ತಗೊಂಡಿದ್ದೀರಾ?
Since 2020 they had abandoned Bangalore address. All the parties.
You have no objection to admit the child to the school? ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ನಾವು ಮಾಡಬೇಕಾಗುತ್ತೆ.
School admission ಗೆ ಸ್ಕೂಲ್ ಅಡ್ಮಿಷನ್ ಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ ಕೇಳ್ತಾರೆ.
ನಿಮಗೆ ನಾಲೆಜ್ ಇದೆಯಾ ಮಗು ಎಲ್ಲಿ ಓದ್ತಿತ್ತು ಅಂತ ನಿಮಗೆ ನಾಲೆಜ್ ಇದೆಯಾ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ ನಮ್ಮ ಮಗುನೇ ನೋಡಿಲ್ಲ ಮೈ ಲಾರ್ಡ್.
ಅಲ್ಲಿ ಹೋಗಿ ಪೊಲೀಸ್ ಜೊತೆ ಹೋಗ್ಬಿಟ್ಟು ಸ್ಕೂಲ್ ನಲ್ಲಿ ಗಲಾಟೆ ಮಾಡವ್ರೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ.
Any record to show that child was studying in that school?
Which school?
This Mussoorie school earlier?
No record.
Do you have any record?
ಸದ್ಯಕ್ಕೆ ನನ್ನ ಹತ್ರ ಏನ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ.
ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ, ನಾಳೆ ಕೊಡಿ ರೆಕಾರ್ಡ್ ನೋಡೋಣ.
ಇಲ್ಲ at the present stage I don't have the record.
Then we have to adjourn the matter.
No, Virat.
ನಾಳೆ see we are going to list it tomorrow or day after tomorrow. You furnish us the record.
ಒಂದು ಕಂಡೀಷನ್ ನನ್ನ ಮೇಲೆ ಪುಟ್ ಅಪ್ ಮಾಡಿ. Within 1 week I would furnish the records.
ಆ ಕಂಡೀಷನ್ ಮೇಲೆ ಮಾಡೋದಿಲ್ಲ. First furnish the record. School academic record ಇದ್ದೇ ಇರುತ್ತೆ ನಿಮ್ಮ ಹತ್ರ.
ಅದು ಸ್ಕೂಲ್ ನಲ್ಲಿ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ. ನನಗೆ ನಾನು ಟ್ರಾನ್ಸ್ಫರ್ನು ಕೇಳಿಲ್ಲ.
ನಮಗೂ ಮಕ್ಕಳಿದ್ದಾರೆ, ಪೇರೆಂಟ್ಸ್ ಮೀಟ್ ಇರುತ್ತೆ, ಅಕಾಡೆಮಿಕ್ ರೆಕಾರ್ಡ್, ಪ್ರೋಗ್ರೆಸ್ ರಿಪೋರ್ಟ್ ನೀವೆಲ್ಲ ಸೈನ್ ಮಾಡ್ಕೊಡೋದು.
I understand.
First to second stand Mussoorie ಓದಿದ ಪೇಪರ್ಸ್ ತರಿಸಿ ಕೊಡಿ. ಆಗ್ಬೋದಾ?
Sorry, then
we are also interested to see that the child's academic career does not suffer. Yes. Right?
You show some record that child is studying in that school, will permit you to admit that.
Yes. 7th or 8th it
The counsel for the appellant submits that child was earlier studying in a school at Missouri.
Oh, 9th,
And,
9th, 10th.
Because of the protest of the respondent, the school is not admitting her for the third standard.
Third standard.
For the third standard, he seeks, he shall produce the academic record of the child of the previous year. Yes, list on. Day after tomorrow, you are going to do it?
Party is in Delhi now. I have to get it.
You can get it online. You can get it now.
I will try. I try my best. No, sir, but time leverage. 9th of the
list on.
9th.
Okay.
Paper book punishment.
I would have to furnish. I would here itself I would get.
Yes, sir. We don't know anything whether they are correct or
I'm appealing for the appellant, my lord. My lord, previous occasion stay is not granted, my lord. We are challenging ground of negligence.
TCR received in MFA 2330. There is one more connected matter.
No, my lord. I think.
TCRs are received in MFA 2330 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ. Maybe there is another connected matter. Call for trial to issue emergent notice to the respondents. Claimant ಹಾಕಿರ್ಬೇಕು. As per the registry's note, this matter is connected to, so that we can direct them to take notice if they are arising out of the same matter.
Okay.
As per the registry's note.
Notice ಕೊಡ್ತೀವಿ my lord. ಇವತ್ತೇ finish ಮಾಡ್ತೀವಿ.
This matter is connected to MFA number 2330 of 2025. List both the matters together on.
And request stay, my lord. Stay is also.
ಕೊಡೋದಿಲ್ಲ ಅದು ರೆಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಆಗಲಿ. First, we do not know why we had not granted interim stay last time.
ಸ್ಟೇ ಪುಟ್ ಅಪ್ ಆಗಿರಲಿಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಅದು ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಪುಟ್ ಅಪ್ ಆಗಿರಲಿಲ್ಲ ಅಂತ.
ಅಂದ್ರೆ ಡಿಲೇಟೆಡ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರಾ?
ಹೌದು.
ಹಂಗಂದ್ರೆ ಎರಡು ಲಿಸ್ಟ್ ಆಗಲಿ.
ಮಚ್ ಮಾಡಿದ್ವಿ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ why are you 5 6
filed the recent NOC Wakalat, my lord. Delay in 4 days, my lord. Another one connected matter, my lord. MFA 873 but 2020.
Oh, ಅದೆಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಒಂದಕ್ಕೊಂದು. Vijay Kumar and appeal against R1 is dismissed. They have not preferred any appeal?
My lord, MFA another 873 but 2020, my lord.
ಯಾಕೆಂದ್ರೆ ಇದು what is the effect of this is MEC number 491. Respondent 2 and 3 are joint clients earlier. Respondent number 3 is directed. Who was respondent number 3 before the trial court? 3 was divisional manager IFCO Tokyo. All right. When petition against R1, appeal against R1 is dismissed now. We'll see what is the effect. It is submitted that this matter is connected to MFA number so and so. List both the matters together on.
Major.
days. Recalling the order dated 27/1/2023. 27/1/2023 last year. ಹಳೆ ಆರ್ಡರ್ ಈಗಲೂ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ ಅವರು. Office of actions are not complied, hence appeal stands dismissed. Yes, appeal. ಯಾರು ಇಲ್ಲಿ ರೆಗ್ಯುಲರ್ಲಿ ಬರ್ತಿರೋದಿಲ್ವಾ ಇವರು? ವಾಸುದೇವ್ ಅಂದ್ರೆ 219 days recording. No representation for the appellant. As a precondition for precondition for consideration of I number 1 and 2 of 2023, The office objection shall be complied within 2 weeks, failing which the application shall stand dismissed. This after 2 weeks.
Second respondent. First
Recording.
respondent.
You know what is the order dated 13?
Blood on 13/11/24, they made a memo for dispensing the notice to the second respondent, and they are recalling such an order. ಅದರಲ್ಲಿ ಮುಕುಂದ್ ದೇವಗನ್ ಜಜ್ಮೆಂಟ್ ಅದೇ ಅದು ಅಪ್ಲಿಕಬಲ್ ಆಗಲ್ಲ ಬಿಕಾಸ್ ದಿ ಲಾಡನ್ weight of the vehicle, gross weight of the vehicle is more than 7,500 kgs.
Now application is filed by whom?
The appellants, claimants. Claimants have filed an application.
Okay. ಅಲ್ಲ ಡಿಲೇ ಅಲ್ಲ ಬರೀ dispensation ಕೇಳಿದ್ರು ಈಗ.
They are praying for a.
What is the award? Court liability? Appeal is by claimants only.
14,70,000.
Claimants. Owner ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. On what ground it was liability is fastened to the owner?
No driving license.
No driving license.
No driving license. No driving license to drive the transport vehicle.
ಮುಕುಂದ್ ದೇವಾಂಗನ್ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಬಟ್ ಸ್ವರ್ಣ ಸಿಂಗ್
ಲಾಡನ್ weight ಜಾಸ್ತಿ ಇದೆ.
That is only ರಿಕವರ್ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಪೇ ಅಂಡ್ ರಿಕವರ್.
ಪೇ ಅಂಡ್ ರಿಕವರಿ ಇವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕಲ್ಲ.
ಪೇ ಅಂಡ್ ರಿಕವರಿ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು. ಅದನ್ನ ಫೈಲ್ ಮಾಡಿ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ ನೋಡಿ. ನೀವೇ ಮಾಡ್ಕೊಳ್ಳಿ ಏನಾದ್ರು ಅಂತ. On what is the date of order? 13/11/2024. On the request of the appellant, so on the memo of the appellant, notice to respondent number 2. Notice to respondent number 2 was dispensed with. Dispensed with. Okay. Now the appellant claims that the misconception such notice such dispensation was sought, and it is necessary to serve the notice on respondent number 2. The record shows that liability was fastened to the owner of registered owner of the vehicle on the ground that the driver was not holding license, no license at all.
No license to drive transport vehicle.
Transport vehicle.
Lord, he was
ಆಗಿದ್ರೆ ಮತ್ತೆ ಅದು ಅಪ್ಲೈ ಆಗುತ್ತೆ.
Lord, he was holding license to drive LMV, but he was driving the medium goods vehicle.
Same class ಅಲ್ಲ ಅಂತ.
Same class ಅಲ್ಲ.
Therefore, the order dated 13/11/2024 is recalled. The appellant is permitted to take notice to respondent number 2 within 2 weeks. Okay. IA 1/24 is disposed of accordingly. Just after 2 weeks.
For the respondent, I have filed the supplication to withdraw.
Yes. What do you say?
I am for the appellant.
Correct. What is
Idರಲ್ಲಿ liability issue from claim by wife and children.
No, on what ground you have
ಅಲ್ಲ ಇದರಲ್ಲಿ liability issue.
No, on what ground you have disputed the liability?
Liability is not involved the vehicle.
Vehicle was not involved.
As per the FIR up to charge sheet. Except charge sheet, there is no number vehicle in our
complaint in the complaint number.
Charge sheet against the
charge sheet. He is submitting that in the complaint name of this vehicle was not reflected.
Initially.
Correct. But ಅಂದ್ರೆ unknown vehicle ಮೇಲೆ ಹಾಕಿದ್ರಾ?
ಅಲ್ಲ ಅದೇ ದಿನ ಅವರು ಆಂಬುಲೆನ್ಸ್ ಡ್ರೈವರ್ ಇದನ್ನ ನಾವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀವಿ.
See, if that is the case, then we will have to receive the records. No? Records ಬಂದಿಲ್ಲ ಇನ್ನು.
ಇಲ್ಲ.
Then we will consider this application. Involvement of the vehicle itself is disputed. We will consider it of the records.
Kindly call for the.
ಅದನ್ನು ಮುಗಿಸ್ಬೋದು. But records for counsel for the appellant submits that the involvement of the vehicle in the accident in question is disputed. Therefore, for consideration of I-1 of 2023, TCRs are required. Call for TCRs. List of receipt of TCRs.
The respondent statements.
Yes.
IA for suspension, my lords.
You are for
The respondent.
state. Okay, where is the? ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಕೊಡ್ಬೋದಾದಂಥದ್ದಿದೆ ನಿಮಗೆ ಒಂದು ಯಾವುದೋ ಇರೋ ಕೇಸ್ ಇಲ್ಲ 10 ವರ್ಷ ಹಿಂದೆ KC relies on section 116 regarding the cause of death to neighbors support. PW1 ಈ ಜಡ್ಜ್ ಏನು ಮಾಡಿದ್ದಾರೆ ಅಂದರೆ ಬರೀ ಇಟ್ ಇಸ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಇನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಆ ಕೇಸ್ ಅವರು 2 ಮಕ್ಕಳಿದ್ದಾರೆ ಆಗಿರ್ಬೇಕಲ್ಲ ಹಂಗೆ ದಿಸ್ ಆಲ್ಸೋ 498 ಇಲ್ಲಿದೆ ನೋಡಿ ಒನ್ ಸನ್ ಡಾಟರ್ ಇದರಲ್ಲೂ ಕೂಡ ಐ ಥಿಂಕ್ ಇಟ್ ವಾಸ್ ಎ ಕೇಸ್ ಅದಕ್ಕೆ ನಾನು ಇದು ನೋಟ್ ಮಾಡ್ತೀನಿ ಏನು ಯಾರು ಹೂಸ್ ಮಹಾಂತೇಶ್ ಬರ್ತಿರೋದಿಲ್ಲ ಇಲ್ಲಿ ನೀನು ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಎಕ್ಸಾಮ್ ಮಾಡೋಣ ಇದು ಯಾರು ಬರ ಮುಂದೆ ಹೋಗಿ ನಾ ಬರ್ಬೇಕು
Maybe taken up next week, my lord. Maybe adjourn and taken up next week.
No representation for the appellant. List on date here. ಮತ್ತೆ ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮೂವ್ ಮಾಡ್ತಾರೆ 96.
I appear in this matter for the respondent father and in 25.1 for the petitioner. This is basically both parents have filed appeals.
I'm for the appellant in the list.
My lords may just see last date's order. On the last date.
Last time some interim arrangement was.
Yes. Last time, if my lords remember, Mysore and Bangalore, the one
what
child.
happened?
It was done.
Implemented.
It was implemented. 1 month, the father took both children. Then he dropped the children to Bangalore. 1 month the mother had. I will file one affidavit because some difficulty was there in video call, in audio calls, but otherwise the visitation happened. That happened. Now, my lords, one submission I have. My lords had also asked whether we can come to some settlement, which I will definitely try with the other council and see if we can have some shared parenting arrangement. But in the meanwhile, this weekend, there is Bakrid coming up. And if my lords can just see the impugned order, the impugned order is there in both petitions. The internal page 18 operative portion of the impugned order, the printed page 18 of the impugned order, it says both petitioner and respondent shall have custody of the non-custodian children for 5 days during one of the festivals, either Ramzan or Bakrid, as per convenience. One spouse shall have custody of non-custodian child on one festival and other spouse shall have on the other festival. Basically to alternate for Ramzan and Bakrid. Now, my lords, Bakrid is coming up this weekend. And I am told that the girl who is with the mother, she has also 5th, 6th also holidays. So basically the girl has holidays for 4 days, boy has holidays just for the weekend. And just now this entire month of May, as per the interim order, the children were with the mother in the entire month of May.
Correct. In Ramzan they were with whom?
No, now last
Ramzan. Now
the previous one in April. Previous Ramzan was in April. April the son had exams and nothing happened. Both the children, neither children came. I had one request. The 4 days holidays are there. Can he take the daughter for 2 days and the other 2 days he can drop the son? 5th, 6th, 7th, 8th. Both of them can at least get 2 days. If this arrangement.
Festival day is on Saturday, no? 7th.
No, for the festival, he will drop the son there. But since the daughter has 2 more days holidays on Thursday, Friday.
She is in which class now?
She's which class?
6th grade.
5th standard. In fact, I just want to pass on even the affidavit when the children were both with him and the photo. Give one copy. One photographs, all the photographs. Basically, the children are very comfortable with both parents. There is no difficulty. Even the daughter was with him for 1 month, and the son also was with the mother for 1 month. In fact, the photos are there from page 7 onwards with his parents. And when she was here for the entire month of April, she was in Bangalore with her with the father. And month of May,
Has his parents with him?
yes, his parents are with him. He's in Mysore. He's living in.
She has her
She's
parents.
in. No. She does not have actually her parents. She's living by herself, if I'm right. She lives in Bangalore and she's working. He lives in Mysore and he's working from home, and his parents also are there.
Correct.
Now, 2 days I was thinking if Your Honor could, my lords.
They could have done it on their own. Why our intervention was
Your
required?
Lordship, I have few submissions to make in Your Lordship. Your Lordship, on first, the matter was called out before this honorable court, and on first, the daughter was picked up by the father from Bangalore, and she was taken to Mysore. And first was when Ramzan happened. Your Lordship, one more submission, Your Lordship. Last year, when Bakrid happened, 15th and 16th, the daughter is studying in a Muslim school, so they give her 4 or 5 days off for Bakrid. In that regard, 5 days were granted by the trial court last year for Bakrid, wherein the daughter went to Mysore and both the children spent time with the respondent, rightly so. Your Lordship, the appellant herein, she has not spent Bakrid with the children. She has not spent Ramzan with the children. She's only seeking for, I'm also filing my application to that extent.
Now what she is saying is,
yes,
let the child be with the mother, both children be with the mother for Bakrid.
Please,
before
2
that.
days after Bakrid.
2 days before that.
2 days
Before Bakrid, the girl has holidays because, as my friend said,
she has, Your Lordship, the vacation, the child's, all the vacations, including Bakrid vacations, end Sunday. Sunday is when it concludes.
So when her Bakrid vacation start?
Bakrid, Your Lordship, including Bakrid, Bakrid is
when it starts.
4th it starts, Your Lordship.
4th. I thought it is 5th, but it starts from 4th.
Apologies. 5th it starts.
All right, 5th even. Please. It is from 5th to 8th.
To 8th, Your Lordship.
5th to 8th. Now it was being said that 2 days earlier, 2 days she's saying
Your Lordship,
that children can be with him, and during festival children can be with her. What do you say for that?
I have no objections, Your Lordship. Lordship, the only thing is,
other party is there, ask her. If you say no objection.
Your Lordship, one more thing. The children would also have to travel. We've always had problems with travel, Your Lordship. The children have motion sickness. All of that issue is there. But the thing is, Your Lordship, one is 12 years old. Daughter is 12 years old. Son.
Mysore to Bangalore, now this fast track road is.
They have come now. This entire 1 month. They
Not talking together. We can't hear two together.
Your Lordship, my only submission is, Your Lordship, a significant amount of time was granted to the husband, to the father, on the last occasion for Bakrid, and some time was spent by him also with the children during Ramzan. We also seek, that's what.
So simply you say you are opposing it. If you
I'm opposing, please, Your Lordship, I'm opposing it. Yes.
First you said you have no objection, then
we are opposing because, Your Lordship, 6th and 7th both are Bakrid, Your Lordship.
What both of them are doing, husband and wife?
Both of them are software engineers, Your Lordship.
Both at IT.
But they are hard amongst their relationship. Software engineers.
They've had some discord. That's
in fact.
Is there any separation? I mean dissolution legally?
No, dissolution is all pending.
Lordship. It's
all pending. But in fact, if this weekend, the only issue is if this weekend can be organized, we will.
See, it's only
we will.
If they gracefully accept, because children were with him in Ramzan.
No. In fact, 1 minute, madam. 1 minute. No, that is incorrect.
Up,
no, it is incorrect. What my friend is saying is incorrect. Whole month of April, the children were with him, as per my Lord's orders.
When Ramzan fell.
No, the
first was
1 minute, madam. No, 1 minute. If I can.
We are asking you a question.
No,
when was the Ramzan?
Ramzan was in March. So in March, the children
had examinations.
His son had exams. So no exchange happened. The last
didn't have exam.
No, daughter didn't have, but the son
She
had.
did not come.
No. And the son had exams.
In Ramzan, she didn't go there.
No, Your Lordship, Ramzan was on the 1st of April, Your Lordship, and daughter was picked up on first evening.
Madam, we asked you one question, you see, go on, go around. We asked you whether in the Ramzan child, daughter was with him or not.
Daughter was with him, Your Lordship. That's my submission.
But you deny that?
No, as per the court order, 1st April, he picked up the children.
Ramzan was on which day?
No, Ramzan was the previous day, 31st. So,
Federal calendar nodi yavrallide anta.
It was on 31st. In fact, they had lot of communication back and forth saying that, yes,
Calendar.
yes, my lords can see.
Shift ಆಗ್ತಿರುತ್ತಲ್ಲ sometimes.
Yes, sometimes it shifts.
What happened this year? Be fair to us.
Sorry?
Was
No,
it
no.
on 31st or 1st?
No, it
this
was
year?
31st. I will tell my lords. In fact,
she was picked
31st,
up.
he had exams. So he said, instead of me sending the son, why don't you send the daughter? Ultimately, in their
All right,
back
now
and
on
forth.
31st, daughter, on Ramzan day, daughter was not with him.
No, no.
Then you exit for 2 days. She is not asking for festival also. 2 days previous days, preceding that Ramzan festival. Sorry, Bakrid festival.
Yes.
Your Lordship, Bakrid is on 6th and 7th, both days, Your Lordship.
Right, you admit on a child was not there in Bakrid with him.
Please.
Ramzan.
Ramzan.
2 days.
Yes. Your Lordship, I would like to file my application.
What is that application?
I wanted to seek visitation, interim custody for
They have to
Bakrid.
file it in the registry. No, don't make us the filing counter. Yes. Kiral, where you are, what are you filing? What
This is just an affidavit of the visitation that happened in the summer break. I'll file it in the I'll file it in the counter. I'll file it in the counter.
They should. Now, so far as children, if they are not in any dispute, let the children, because the siblings have to grow together.
Absolutely, Your Lordship. Please.
Let them be together.
So
Please, they have to.
They actually want to be together.
I agree with my Lord.
Estimacy so Learned Council.
Yes. If 4th evening he can pick her up.
Appearing for Shri so and so, who is the advocate on record?
I'm appearing for the father, my lords.
For Naveen Chandra. B, for respondent, submits that as per the impugned judgment, the children had to spend the time during Ramzan and Bakrid alternatively with one parent.
Please.
And she further submits that having regard to the examination of the children, the daughter who is in the custody of the respondent could not spend the time during previous Ramzan with the father. Therefore, it is further submitted that the daughter has longer holidays, that is from 5th to 8th for Bakrid.
Please.
Therefore, 2 days preceding the Bakrid festival, children may be permitted to stay with the respondent father. Now, counsel for the appellant concedes the position that the daughter could not spend time on previous Ramzan day with the father.
Your Lordship,
due to the examination.
Last Bakrid also was not spent by the son with the mother, and this Ramzan also the mother has not spent time with the minor son. With the son. That's all I want to submit.
But you didn't make that such request.
Your Lordship, I'm really bringing to this court's
Who's
notice.
responsible for that?
Your Lordship, there was an arrangement.
2 days previous, not festival day.
Yes.
Our ಜೊತೆಗೆ ಇರ್ಲಿ. Preceding the
Previous 2
festival,
days.
2 days ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅವ್ರು ಏನೋ ಗಿಫ್ಟ್ ಅದು
ಆಗ್ಬೋದು.
ಕೊಡಿಸ್ತಿದ್ರೆ ಕೊಡಿಸ್ತಾರೆ ತಗೊಂಡು ಇಲ್ಲಿ ಬರ್ಲಿ.
And with the grandparents, she can stay. Ultimately, if 4th evening I can take her and drop her back on 6th evening.
6th evening would be, Your Lordship, maybe timings may be fixed, Your Lordship.
ಆಯ್ತು. 5th morning pick up ಮಾಡ್ಲಿ.
No, 4th evening he can pick up. 6th evening he drop her.
School time after school.
After school. On 4th after school.
Your Lordship, she comes back by 4 o'clock.
Yeah, after school I'll pick her up. 5 o'clock or something he can pick her up.
The respondent is permitted to pick up the children The daughter.
Daughter,
She
daughter,
alone is
daughter.
daughter. After her school hours on fourth evening. And drop both the children.
Both the
back,
children.
To the custody of the appellant on
sixth evening.
Sixth evening.
Sixth evening. 2 days he'll get.
Seventh, eighth, seventh is
Ah,
the
seventh,
festival.
eighth is the festival. Sixth evening.
On sixth evening by 5 o'clock. By 5 p.m.
Yes.
5 p.m.
And one more request: if on Sunday, if she can drop the son back.
Your Lordship.
2 times he will have to make. 2 times he's requesting. I'll leave it up to.
What is the age of the son?
Son is
7 years. Your Lordship.
ಅವರೇ ಬರ್ತಾರೆ ಅಲ್ಲಿ ಬಸ್ ಹತ್ಸಿದ್ರೆ ಇಲ್ಲಿ ಬರ್ತಾರೆ.
No, because
one humble submission, Your Lordship.
he is also two trips.
Working. Please. So child, if he is 17 years, we remember when we were 15 years old.
No, 7 years old. Child, son is 7.
He's 7 years.
Small, yeah, he's
7.
7 years old.
Go and pick up. He shall pick up the. I'm sorry. Respondent shall pick up the son on sixth evening.
Sixth evening he'll drop, and eighth evening to eighth evening he'll drop back.
After 5 p.m.
Please.
After 5 p.m.
Yes, great.
List on son.
Let it be listed after maybe 4 weeks. Till then we'll try and do some
non-filing of acknowledgement for having served the copies.
We'll file that. We'll serve the copies and
copies are served.
Copies are served.
Final ಬರ್ಕೊಳ್ಳಿ 25(1) ನಲ್ಲಿ.
Yes.
Counsel for the respondent submits that the copies are received. Therefore, office of sections should complain. ಇದರಲ್ಲಿ ಡಿಲೇ ಇದೆ ಅಲ್ಲ ಕಂಡೋನ್ ಮಾಡಬಹುದಲ್ವಾ?
Can be condoned. Both the cross appeals are there. So it.
Madam, what do you say? Condonation of delay. 67 days delay is there in their filing.
It may be allowed, Your Lordship. With subject, it may be allowed. Condone ಮಾಡಬಹುದು.
ಅದರಲ್ಲಿ law counsel for respond fairly concedes for condonation of delay of 67 days. The same and the reasons assigned to explain the delay of 67 days in filing the appeal is condoned in the interest of justice. I 1 of 2025 is disposed of accordingly.
Your Lordship, one humble submission. Apologies. ಇದು ನಾವು ವಕಾಲತ್ ಹಾಕಬೇಕಾಗಿತ್ತು. ಇನ್ನೊಂದು ಅವರು MFA ಹಾಕಿದಾರಲ್ವಾ, ಅದಕ್ಕೆ ನಾವು ವಕಾಲತ್ ಹಾಕ್ತೀವಿ within a course of a day or two. That's all I want.
25.1 ನಲ್ಲಿ ಅವರ ಪ್ರೆಸೆನ್ಸ್ ಅನ್ನು ನೋಟ್ ಮಾಡ್ತೀವಿ. Respondent is present. What is your name?
Adya, Your Lordship. Adya.
ಬರೆದು ಕೊಡಿ. ಶ್ರೀಮತಿ so and so counsel for appearing on behalf of Shri K.C. Kamath undertakes to appear. Sorry, file wakalat in the registry within 10 days.
Please.
She is permitted to file the wakalat in the registry within 10 days. ಅದಾದ್ಮೇಲೆ ಉಳಿದ condonation of delay ಮಾಡಿ. List on
can be taken early. It can be taken early July, maybe after 4 weeks. Hopefully by then we will have some midweek. We will have some settlement talks.
Why don't you try for the settlement?
I want to try that. I want to try that. We want to try that.
The difference.
We want to try that only.
We will adjustment problem or any other. I mean,
in fact,
issues of morality.
No, my lords, there are no other major issues.
Now he has the matrimonial case is pending.
There is a domestic violence complaint pending, which she has filed.
Physical violence allegations.
No. There are
Lordship allegations unto Your Lordship. ಏನಾಗಿದೆ ಇದರಲ್ಲಿ? There's some more allegations with regard to the children as well, which I don't want to divulge at this point.
Abuse.
Please, Your Lordship. Vacation time ಅಲ್ಲಿ we got to know from the son.
Consider ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರಲ್ವಾ?
Consider ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, but then he wanted to file an affidavit to that extent, so I did not make that submission before this.
In fact, no such allegations are there.
Cases are filed.
Yes, Your Lordship. There is a domestic violence case.
Not domestic violence. Any child abuse case is filed?
No, Your Lordship.
Not at all. In fact, there are no. The children are both going and coming. 1 month they have spent. One month they have spent.
The son has told the mother about all the acts.
Don't go by the version of the children. Whether she had, when they were together, she had seen anything like that.
No, my lords, let these issues not come out. 1 month they have both spent.
See, these are sensitive matters.
No, 100%. 100%.
Lordship,
it's
if
not
I may
to
be
minimize
permitted to file
anything.
my affidavit to that extent, one opportunity ಕೊಟ್ರೆ I can.
You see, we are on trial because parties know the things properly. If such things are not there, try for a settlement between the parties. If any such serious things are there, then
yes, there are serious allegations, Your Lordship. ಅದೊಂದು ಹೇಳಲಿಕ್ಕಿತ್ತು ಅಷ್ಟೇ.
We are keen to try for some.
4 weeks, huh?
Yes, some 4 weeks, any date, my lords may give.
List on.
Yes, beginning of July, if Sunday. It's great.
Grateful, Your Lordship.
ಅದನ್ನ ಬರ್ಕೊಂಬಿಡಿ. Both counsels submit that to explore the possibility of settlement. List on.
For enhancement, my lord, kindly condone delay, 92 days delay in filing, my lord, kindly condone.
Pradeep and R1 served and represented. What do you say for condonation of delay?
Condone ಮಾಡ್ಬೋದು.
It is only for enhancement or?
Yes, my lord.
Connected company appeal is there, madam.
Company appeal ಇದೆಯಾ?
Yes.
ಅದರಲ್ಲೂ ಡಿಲೇ ಇದೆಯಾ?
Delay, no, madam.
Condone ಮಾಡಲ್ಲ. Respond number 2. The counsel for respond number 1. Like hard and performed for partition number 1 of 2024. 26 years. So he died, injured died.
Yes, my lord.
Yes, madam.
Accepting the reasons assigned to explain the delay. Some delay of 92 days in filing the appeal is condoned in the interest of justice. I1 of 2024 is disposed of accordingly. Records ಬಂದಿಲ್ಲಲ್ಲ ನಿಮ್ಮದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? It is submitted that this matter is connected to MF number so and so. List both the matters together on date. ಹೌದಲ್ಲ? ಇನ್ನೊಂದು ಬರ್ಕೊಳ್ಳಿ. I'm sorry, I didn't notice that. Since Shri B. Pradeep has appeared for R2, only his name shall be shown in the court list, henceforth for the said respondent.
What's up?
Short accommodation may be given in the next hearing that we will.
Adjourned at the request of the appellant's counsel.
Much.
ಲೈಫ್ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ. ಲೋಯರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಕಾಲ್ ಮಾಡಿತ್ತು.
ಬಂದಿದೆ ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು. ಆರ್ ಯು ರೆಡಿ ಆರ್ ನಾಟ್?
ರೆಡಿ. ಇದರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಕನ್ವಿಕ್ಷನ್ ಲೈಫ್ ಕೊಟ್ಟಿದೆ. Accused number 2 in this case, ಇದರಲ್ಲಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಸೊ ಕನ್ವಿಕ್ಷನ್ ಇದಾಗಿರೋದು. ಯಾವುದೇ ವ್ಯಕ್ತಿಗಳು ನೋಡಿಲ್ಲ, ಕೂತಾಕಿರೋದು ನೋಡಿಲ್ಲ, ಕೊಲೆ ಮಾಡಿದ್ ನೋಡಿಲ್ಲ, ಏನಿಲ್ಲ. ಇವ್ರ ಜೊತೆಲಿ ಕುಡಿಕ್ ಹೋಗಿದ್ರು, ಕುಡಿತಾ ಇದ್ದಾಗ ಜೊತೆಲಿದ್ರು ಆ ಟೈಮಲ್ಲಿ ಅಂತ ಹೇಳಿ.
ಡ್ಯೂರಿಂಗ್ ಟ್ರಯಲ್ ದೇ ವರ್ ಆನ್ ಬೇಲ್.
ಸ್ವಾಮಿ,
ಡ್ಯೂರಿಂಗ್ ಟ್ರಯಲ್ ದೇ ವರ್ ಆನ್ ಬೇಲ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇಲಲ್ಲಿ ಇದ್ರಾ? ಇಲ್ಲ,
ಬೇಲಲ್ಲಿ ಇರಲಿಲ್ಲ. ಆಗ ಏನೇ ಬೇಲಲ್ಲಿ ಇರಲಿಲ್ಲ. ಇದು ಮೆಡಿಕಲ್ ಇದ್ರ ರಿಪೋರ್ಟ್ ಬರಲಿ, FSL ರಿಪೋರ್ಟ್ ಬರಲಿ ಅಂದ್ಬಿಟ್ಟು ಬೇಲ್ ಹಾಕಿತ್ತು ಹೈಕೋರ್ಟ್ಗೆ. FSL ರಿಪೋರ್ಟ್ ಬಂದ್ಮೇಲೆ ಇದು ಮಾಡೋಣ ಅಂತ FSL ರಿಪೋರ್ಟ್ ಇನ್ನೂ ಹಾಕಿರಲಿಲ್ಲ. ಇದರಲ್ಲಿ A2ಗೆ ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾಸ್ FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ರಕ್ತ ಡಿಟೆಕ್ಟ್ ಮಾಡೋಕ್ಕಾಗಿಲ್ಲ. ಇದು ಆರೋಪಿ ಗುರುತದ ಇಲ್ಲ ಅಂತ ಈ ಪೇಜ್ ನಂಬರ್ ನಮ್ಮ ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತೀವಿ.
What was the circumstance relied against accused number 2?
2 ನಲ್ಲಿ ಯಾರು 4 ಜನ ಜೊತೆಲೆ ಕುಡಿತಾ ಇದ್ರು.
ಅಲ್ಲ, ಲಾಸ್ಟ್ ಸೀನ್ ಆಯ್ತು. ಅದು ಬಿಟ್ಟು ಮತ್ತೆ ಯಾವ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಇದೆ? So far as accused number 1, the discovery of the dead body was at the instance of accused number 1. What were the circumstances against this accused other than last seen together?
ಈ ಆಸ್ ಪರ್ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರವಾಗಿ ಕೊನೆಯಲ್ಲಿ ಊತ ಹಾಕ್ಬಿಟ್ಟು ನಾವು ಊರಿಗೆ ಹೋಗಿ ಇದು ಮಾಡಿದ್ರು, ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ಕೊಂಡ್ರು.
ಎಕ್ಸ್ಟ್ರಾ ಜುಡಿಷಿಯಲ್ ಕನ್ಫೆಷನ್ ಅವರು ಸಪೋರ್ಟ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಮಾಡಿಲ್ಲ. PW9 ಇದ್ದಾರೆ. PW9 ನೋಡಿದ್ದು ನನ್ನ ಮುಂದೆ ಹೇಳ್ಕೋದು ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ. ಸಪೋರ್ಟ್ ಅಂದ್ರೆ ಹೇಳಿದ್ದಾರೆ ಚೀಫ್ ಅಲ್ಲಿ.
11 and 10 ಅದಾಯ್ತು.
9
PW14 ವಿಟ್ನೆಸ್ ಅಕ್ಯೂಸ್.
ಈ PW9
ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ ಕೊಡಿ. ಯಾರು ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇದೆ. ಕನ್ಫೆಷನ್, ಎಕ್ಸ್ಟ್ರಾ ಜುಡಿಷಿಯಲ್ ಕನ್ಫೆಷನ್ ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
ನಾವು ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 300 ಚಾರ್ಜ್ ಶೀಟ್ಗಳು.
Who was witness? Hanumaya. CW20 was the witness for extrajudicial confession. ಅಂದ್ರೆ ಹೆಸರು ಏನ್ ನೋಡಿ, ಹೆಸರು ಹನುಮಯ್ಯನ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಪ್ರಕಾರ CW20 that is Hanumaya was the witness for extrajudicial confession. ಯಾರು ಇನ್ನೊಬ್ರು ಚಿಕ್ಕ ನಾರಾಯಣಪ್ಪನ ಅಲ್ಲ, ಚಿಕ್ಕ ನಾರಾಯಣಪ್ಪನ ಕರೆಕ್ಟ್.
ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ.
He is also shown as
ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ 19.
So out of two only one was examined. ಚಿಕ್ಕ ನಾರಾಯಣಪ್ಪ ಅವ್ರನ್ನೊಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್
ಮಾಡಿದ್ರು ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ. ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಪಾರ್ಟಿ ಸವಾಲಲ್ಲಿ ಇದರಲ್ಲಿ ನಮ್ಮ ಪಾರ್ಟಿ ಸವಾಲಲ್ಲಿ ಅವ್ರು ಏನು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ನೋಡಿ ಸರ್.
1 ನಿಮಿಷ. 133 ಅಲ್ಲ, ಚೀಫ್ ನ ಲೇಖನಕ್ಕೆ ಇದು ಮಾಡಿದ್ದಾರೆ,
ಹೇಳಿದ್ದಾರೆ.
yes supported in the chief
ಟೀಚರ್ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ, ಆರೋಪಿ ಪರವಾಗಿ ಎರಡನೇ ಆರೋಪಿ ಪರವಾಗಿ ಪೇಜ್ ನಂಬರ್ 136 ನಾನು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್
136 ಅಂದ್ರೆ 136.
ಗಟ್ಟಿಯಾಗಿ
ನಮಗೆ ಕಿವಿ ಕೇಳಿಸುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದು ಅದಕ್ಕೆ ಸಾಕ್ಷಿದಾರರು ಗಟ್ಟಿಯಾಗಿ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸೊ ನನಗೆ 88 ವರ್ಷ ಆಗಿದ್ದರಿಂದ ಕೊಲೆ ಮಾಡಿದ ಆರೋಪಿ ಹೆಸರು ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ಆರೋಪಿತರು ಈಗ ಗಡ್ಡ ಬಿಟ್ಟಿರುವುದರಿಂದ ಈಗ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನೋಡಿ ಗುರುತಿಸಲಾಗುವುದಿಲ್ಲ. ಆದರೆ ಆರೋಪಿತರು
examined on the same day, cross examination
ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಇವರು
ಡೌಟ್ ಬರುತ್ತಲ್ಲ
ಸಮಯ
ಮೊದಲು ಸಪೋರ್ಟ್ ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ
ಇಲ್ಲ ಅಂತಾರೆ. ಅಂದ್ರೆ ಆಯ್ತು, ಪಾರ್ಟಿ ಸವಾಲು
1-3-2021 he was examined in chief, then he supported. One accused number 1 and 3 cross examined on the same day.
ಹಾಗೆ ಎರಡನೇ ಆರೋಪಿಗೆ
not cross examined, he was discharged.
ಎರಡನೇ ಆರೋಪಿಗೆ ವಕಾಲತ್ ಹಾಕಿರಲಿಲ್ಲ ಯಾರುವೆ.
30-11
ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಬರ್ಕೊಟ್ಟಿದ್ರು ವಕಾಲತ್ತಕ್ಕೆ.
11 ಅಂದ್ರೆ
ವಕಾಲತ್ಗೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರು.
8 months you cross examine him.
ವಕಾಲತ್ತ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಬರ್ಕೊಟ್ಟಿದ್ರು. A1 A3 ಮೂರು ಜನಕ್ಕೆ ಒಬ್ಬರೇ
ಚಾನ್ಸ್ ಇರುತ್ತಲ್ಲ ಅಷ್ಟೊತ್ತಿಗೆ, ಅಂದ್ರೆ ಟ್ಯಾಂಪರ್ ಮಾಡೋದು
ಇಲ್ಲ, ಅದಿಲ್ಲ. ಈ ಫುಲ್ ಕಂಟಿನ್ಯೂ ನೋಡಿ ಸರ್ ಮಾಡಿ.
ಅಲ್ಲ, ಅವನಿಗೆ his age is recorded on 12-3-2021 as 84. ನವೆಂಬರ್ 10 ಹೊತ್ತಿಗೆ 88 ವರ್ಷ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಡಿಫರೆನ್ಸ್ ಏಜ್ಗಳು ಹಾಕೊಂಡಿದ್ದಾರೆ ಅವ್ರಿಗವ್ರೆ. ಫುಲ್ಲು ಎಂಟೈರ್ಲಿ ನಾವೇನು ಇದು ನೋಡಿಲ್ಲ.
He is the deceased was his nephew.
ಸಂಬಂಧಿಕ, ಚಿಕ್ಕ ಅಣ್ಣ ಮಗ ಆಗ್ಬೇಕು ಅಂತ, ತಮ್ಮನ ಮಗ ಆಗ್ಬೇಕು ಅಂತ. ಸೊ ಇದು
according to him
ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಬಗ್ಗೆ ಒಬ್ರದು ಇವ್ರ ಬಗ್ಗೆ ಯಾವುದೇ ತರವಾಗಿಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ. ಚೈನ್ ಲಿಂಕ್ ಇಲ್ಲ. ಚೈನ್ ಲಿಂಕ್ ಆದ್ರೂ ಸ್ವಾಮಿ ಕುಡಿಕ್ ಹೋಗಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ಡಾಕ್ಟ್ರು ಸತ್ತ ವ್ಯಕ್ತಿಯ ದೇಹದಲ್ಲಿ ಯಾವುದೇ ಕುಡಿದ ಅಂಶ ಇಲ್ಲ, ಅವತ್ತು ಕುಡಿದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ ಅದು ತೋರಿಸ್ತೀನಿ ಡಾಕ್ಟ್ರಲ್ಲಿ. ಇವರು ಕುಡಿ ಕೂತಿದ್ರು.
ಇದ್ದಾಗ 3 ಜನರು ಅಲ್ಲಿಗೆ ಬಂದು ಸಾಗರನನ್ನು ಹೊಡೆದು ಮರಣವನ್ನು ಹಾಕಿದ್ದೇವೆ ಎಂದು ಹೇಳಿದರು. ಅವರು ಐಡೆಂಟಿಫೈ ಮಾಡಲಿಲ್ಲ. But he only says 3 persons in the chief examination also. He doesn't specify accused number 1 to 3.
ಆರೋಪಿತರು ಅಂತ ಹೇಳ್ತಾರೆ.
Even in the chief, no. ಎಲ್ಲ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ, 20ನೇ ತಾರೀಕಿನಂದು ಸಹ ನಾನು ದೇವಸ್ಥಾನದ ಬಳಿ ಇದ್ದಾಗ 3 ಜನರು ಅಲ್ಲಿಗೆ ಬಂದು ಸಾಗರನನ್ನು ಹೊಡೆದು ಮರಣ ಓಣಿಯಲ್ಲಿ ಹಾಕಿದ್ದೇವೆ. ಯಾರಾದ್ರೂ ನಮ್ಮ ತಂಟೆಗೆ ಬಂದರೆ ಅವರಿಗೂ ಸಹ ಅದೇ ಗತಿಯನ್ನು ಕಾಣಿಸ್ತೇವೆ ಎಂದು ಹೇಳಿದರು. ಅಷ್ಟೇ.
Lord, PW11 also, my lord. Last seen witness.
ಅಲ್ಲ PW this witness PW 19
19.
PW 9 I'm sorry
9.
ಅವ್ರದ್ರಲ್ಲಿ ಐಡೆಂಟಿಫೈನೇ ಮಾಡ್ಸೋದಿಲ್ವಲ್ಲ ಅಕ್ಯೂಸ್ಡ್
ಅಕ್ಯೂಸ್ ಯಾರದೇ ತರವಾಗಿ ಕೋರ್ಟಲ್ಲಿ ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಪೊಲೀಸರು
who is the other witness
ಈಗ ನಮ್ಮ
11 my lord, last seen witness. He has supported.
ಇಬ್ಬರನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಇಬ್ಬರನ್ನ ತೋರಿಸಿದ್ದಾರೆ ಅವರು.
ನಮ್ಮ ಆರೋಪಿನ 8 ದಿನ ಆದ್ಮೇಲೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಯಾವುದೇ ವಿಟ್ನೆಸ್ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿ ಈ ವ್ಯಕ್ತಿ ನೋಡಿದಿರಾ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ.
But in the charge sheet this PW11 is not shown as extrajudicial witness. Extrajudicial confession witness ಅಂತ ತೋರಿಸಿಲ್ಲ ಅವ್ರನ್ನ. And where you have said about extrajudicial confession? ಅಲ್ಲ ಅದು ಹೇಳಿಕೊಂಡು ತಿರುಗಾಡುತ್ತಿದ್ದ ವಿಚಾರ ಗೊತ್ತಾಯಿತು ಅಂತ ಹೇಳ್ತಾರೆ ಹಿಯರ್ಸೆ.
ಹೌದು
ದಿನಾಂಕ
ಹೌದು
21
ಗೊತ್ತಾಯ್ತು.
2018 ಆರೋಪಿಗಳು ಕೊಂಡುಕೊಂಡಾಗಲೇ ಆಲದ ಮಾಲೀಕರು ಸಾಗಣೆ ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೂ ಸರಿ ಅಂತಂದು ಹೇಳಿಕೊಂಡು ತಿರುಗಾಡುತ್ತಿದ್ದ ಪೇಜ್ ನಂಬರ್ 142 ನಲ್ಲಿ ಹೇಳಿಕೊಂಡು ತಿರುಗಾಡುತ್ತಿದ್ದ ವಿಚಾರ ಗೊತ್ತಾಯಿತು ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರ ಮುಂದೆ ಮಾಡಿರೋದಲ್ಲ ಕನ್ಫೆಷನ್. ವಿಲ್ ಕಂಟಿನ್ಯೂ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್.
ಅದರಲ್ಲಿ ಡ್ರಿಂಕ್ಸ್ ಮಾಡದೆ ಅನ್ನೋದು ಡಾಕ್ಟರ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರಪ್ಪ. ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಒಂದು ಇತ್ತಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಇವರಾ? ಇಲ್ಲ 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 ಇವರು ಅಡ್ಮಿಷನ್. ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ವಪ್ಪ ಅಡ್ವೊಕೇಟು? ಇದಾರ ಹೊರಗಡೆ ಇದ್ದಾರಾ? ಕರೀರಿ. ಸರ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದಲ್ವಾ? ರೆಡಿ ಇದೆಯಾ? ಸರ್ ಈಚ್ ಪೇಜ್ ಸೈನ್ ಆಗಿದೆಯಾ ಅದು? ಏನಪ್ಪ ಹಂಗೆ ಇದೆ. ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ನೋಡ್ಬೇಕು ಬರ್ತಿ. ಹಾ ಅಷ್ಟೇ. ರೀಸನ್ಸ್ ಟು ಫಾಲೋ ಬುಕ್ ತೆಗೆದು ನೋಡು. ರಿಸರ್ವ್ ಬುಕ್, ರೀಸನ್ಸ್ ಟು ಫಾಲೋ, ಅದ್ರೊಳಗೆ ಡಿ ಫೈಲು ಏನೋ ಕೆಬ್ಬಿಲ್ಲೋ ಅಂತ ಇದ್ದೇ ಇರುತ್ತೆ. ಏನ್ ತರ್ಲೆಗಳಪ್ಪ. ಅಲ್ಲ ಈ MGS ಕಮಲ್ ಚೇಂಬರಿಂದ ಅದು ಯಾವ್ದೋ ಫೈಲ್ ಕಳಿಸ್ಬಿಟ್ಟು ಇದೆಲ್ಲೋ ಯಾವ್ದ್ರದ್ದು ಮಿಸ್ ಆಗೋಗಿದೆ ನೋಡಿ ಅಂತ. ಏನ್ ಮಾಡೋದು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೆ. ಏನ್ ತರ್ಲೆಗಳಪ್ಪ ಅಂತ. ಹೌದು ಹುಡುಕ್ಬೇಕು. ಯಾವ್ದಂತ ಹುಡ್ಕದಪ್ಪ? ಕೆಬ್ಬಿಲೋ ಫೈಲು. ತರ್ಲೆಗಳು.
Submission. Serial number 46. Kindly have it on next week, madam.
46.
Yes, ma'am.
Our other side, KV Shyam Prasad.
Informed, madam. Already informed.
You have informed.
Yes, ma'am.
But 46. As requested by appellant sponsor, list on
12/6.
12/6.
Much of.
Pastor matter, seal number 2, Mithun GA, B Ravindra.
Settlement. Memo ಕೊಟ್ಟರು. Where is that settlement? ನೀನು ತಿರುಗಿ ತಗೊಂಡಿದ್ರಾ?
ಸೈನ್ ಮಾಡಿ.
ಸೈನ್ ಮಾಡಿ ಈಚ್ ಪೇಜ್. ಅಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ರೆ.
Such a decree is drawn in favor of Registrar General High Court of Karnataka.
Just a minute. We'll see what are the terms of settlement.
Please.
Both suit. ಅದರಲ್ಲಿ ನೋಡಿ it was chill. About sleep against. ನೀವು ಅದನ್ನೇನು ಓದೋ ಅವಶ್ಯಕತೆ ಇರೋದಿಲ್ವಾ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ವೇರ್ ವಾಸ್ ದ ಸೂಟ್ read para 2 of your memorandum of settlement.
Both parties submit the judgment as well as opposed suit against the respondent.
ಎಲ್ಲಿದೆ ಸೂಟ್
ಯಾವ suit number?
Where is the suit here?
Apologies.
Miscellaneous.
Why did in favor of registrar central? ಅದರಲ್ಲೇನು ಚೌಕಾಸಿನ
ಇಲ್ಲ as per the instructions of seeing because there are few pending cases that are there from one before the
ಏನು ಇಲ್ಲ ಆರ್ಡರ್ ಆದ್ರೆ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಆದ್ರೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವನ್ ಇಫ್ ಶಿ ಕಾಂಟೆಸ್ ಅದೇ ಮೇಂಟೆನೆನ್ಸ್ ರಿಕವರಿ ಇರುತ್ತೆ ಅಷ್ಟೇ. Then this is disposed of.
Only one pending case.
Maybe this
there's one
Only one.
there's 128
Only.
128 proceedings or recovery proceedings, sir?
that is an appeal file your recovery
Recovery.
Criminal miscellaneous 32 of
please
the criminal revision petition is the disposed. Then ನನಗೆ ಕೇಳ್ತಿರೋದು 32 of 2019.
it's still pending your
It is a pending.
also for execution.
What is that case 128 recovery proceedings ಏನು ಬೇರೆ ಇಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದಾರಲ್ಲ ಮತ್ತೆ if any of them refuse to withdraw ಇದ್ರದ್ದು ಅನ್ಸುತ್ತೆ there was a need for ಅದರಲ್ಲಿ ಚೌಕಾಸಿ ರಿಜಿಸ್ಟರ್ ಸೆಂಟ್ರಲ್ ಅಲ್ಲಿ ತಗೊಳ್ಳೋದು what they are doing ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಇಬ್ರುನಾ
he was working as an author writer and drafting the bamboos
bamboo business what she is doing
she's a housewife
Since I was wife.
ಯಾರ ಜೊತೆಗೆ ಯಾರು ಬಂದಿಲ್ಲ ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಅವ್ರ ಕಡೆ
ಇಲ್ಲ ಅವರ ಸಿಸ್ಟರ್ ಒಬ್ಬರು ಬಂದಿದ್ದಾರೆ ಸರ್.
ಎಲ್ಲಿದ್ದಾರೆ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್ಗೆ 6 lakhs ಅಷ್ಟೇನೆ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ ಟು ರಿಲೀಸ್ ದಟ್ ಅಮೌಂಟ್
please
ಏನ್ ಹೆಸರದು ಎಸ್ ಶಶಿಕಿರಣ್ ವಾಟ್ ಇಸ್ ಮಾಲಿನಿ ದೇವಿನ ಹೆಸರು so it was ex parte dismissal was also ex parte
please
Please.
It is transfer certificate of respondent, transfer certificate exhibit P10 and 11 before the trial court.
ಏಜ್ ಡಿಫರೆನ್ಸ್ ಇದೆ ಅಂತ ಅಷ್ಟೇ ಸುಮ್ಮನೆ.
ಅಲ್ಲ ಅದೇನೋ ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಇದೆ ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಅದಕ್ಕೆ ಏಜ್ ಪ್ರೂಫ್ ಸ್ಕೂಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಟಿಸಿ ಇಲ್ಲ ಟಿಸಿ appellant respondent and both counsel of the respective counsel of the parties are present. Parties are duly identified by the respective counsel. Parties submit. ಇದು 23(3) ಆಗಬಾರ್ದು, ಇದ್ರ ಜೊತೆಗೆ 13(1)(b) ಆಗ್ಬೇಕಾಗುತ್ತೆ ಅದ್ರ ಜೊತೆಗೆ ಅಲ್ವಾ. 23(3) ಅಲ್ಲ 13(1)(b) ಆಗ್ಬೇಕು ಅದ್ರ ಜೊತೆಗೆ ರೀಡ್ ವಿತ್ ಅಂತ. ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಡೈವರ್ಸ್ ನೌ ಇಟ್ ಇಸ್. ಎಷ್ಟೆಷ್ಟು ವರ್ಷ ಮಾಡಿದ್ದೀರಿ? ಹೌ ಮೆನಿ ಇಯರ್ಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಯು ಹ್ಯಾವ್ ಪುಟ್ ಇನ್?
2 years.
2 years.
Read with 13B and
You are ineligible to appear before the family court. Yes. ಅವರು ನೀವು ಎಷ್ಟು ವರ್ಷ ಮಾಡಿದ್ದೀರಿ?
20 years.
ಮತ್ತೆ ನೀವು ಮಾತ್ರ ಹೇಳ್ಬೇಕಲ್ಲ.
ಅಬ್ಸರ್ವ್ ಮಾಡಿ.
ಬೇರೆ ಬೇರೆ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕು, ಬೇರೆ ಬೇರೆ ಪಿಟಿಷನ್ಸ್ ಹಾಕ್ಬೇಕು.
ಹಿಂದೆ ಹಾಕಿದ್ರೆ ಕಾಮನ್ ಪಿಟಿಷನ್ ಆಗುತ್ತೆ, ಆದ್ರೆ ಇದ್ರಲ್ಲಿ 13(1)(b) ಅಂತ ಬರೀಬೇಕಲ್ಲ.
13B ಅಲ್ಲಿ ಬರುತ್ತೆ.
The parties present the petition under section 23(3)
13B
compromise petition under order 23(3) CPC and 13(1) capital B of Hindu Marriage Act. Heard the parties on the compromise petition. Parties admit ಎಲ್ಲಿದೆ ಡೆಪಾಸಿಟ್ ಮಾಡೋದಕ್ಕೆ DD ಅದರ ನಂಬರ್ ಇಲ್ಲಿದೆ.
ಇಲ್ಲ ಅದೇ ಡೆಪಾಸಿಟ್ ಇದು ಮಾಡಿ.
ಇಲ್ಲ they have not even deposited it. ಕೊಡಿ ನೋಡೋಣ. ಮೆಮೊನು ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಇದೊಂದು ಕೊಡ್ತೀವಿ. ಮೆಮೊ ಕೊಡಿ.
ನೀವು ಪ್ರೆಸೆಂಟ್ ಅಂತ ಬರಿತೀವಿ ಇಲ್ಲೇನೆ ಮೆಮೊ ಹಾಕೊಡಿ.
ಪ್ಲೀಸ್ your lordship. It's ready your lordship.
ಅದು ಅದನ್ನ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿದಲ್ಲ ಅಲ್ಲ he files compromise petition along with the demand draft for rupees 6 lakhs drawn on bank of dated 29/5/2025 drawn on ಇದಕ್ಕೊಂದು ಮೆಮೊ
ಕೊಡಿ.
drawn on Bank of Baroda, Chikaballapura branch in the name of Bank of India. Bank of India, Chikaballapura branch in the name of Registrar General High Court of Karnataka. Again, memo along with DD ಕೊಟ್ಟು ಅದನ್ನ ನಿಮ್ಮ ಹತ್ರನೇ ಇಟ್ಕೊಳ್ಳೋಣ. ಇದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
I'll place it on record. I'll place it in the record.
There should be all seriousness in matrimonial cases. ಇದೇನಿದು? Signature are the parties on the compromise. Parties admit voluntary execution of the compromise petition and the terms of the same. The terms of compromise read as follows. When I extract more from body. Parties admit that they are living separately since 2014, and it's not possible for them to live together in future also. Satisfied that the compromise is lawful and admissible under law. Further satisfied that the marriage of the petitioner, appellant and respondent is dead. Appellant admits that he has no objection to release the amount deposited before the Registrar General by way of the DD. Respondent admits ಎಲ್ಲ ಕೇಸ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೋಬೇಕು. ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ? admits that she has agreed to receive rupees 6 lakhs in full settlement of her claim for any maintenance, and she withdraws. The case is pending between her and the appellant. The parties have further agreed that henceforth they will not file any cases against each other.
DD
The writers are the compromise slash the petitioner section 13(1)(b) is recorded. The impugned judgment and decree in MC number 76 of the appeal is allowed. The appeal is allowed in terms of the compromise petition. The impugned judgment and decree in MC number 76 of 2015 on the file of additional senior civil judge and JMFC Chikkaballapura is hereby set aside. The petition in MC number 76 of 2015 is allowed in terms of the compromise petition. The marriage of the appellant and respondent solemnized on 16 synopsis solemnized on 16/2014 at Lakshmi Venkatramana Swami Temple, Ganibanda village, Srinivas Rayalpad village, Srinivasapura Taluk is hereby dissolved by mutual consent. Draw decree accordingly. Sign ಮಾಡಿಸಿ. ಅಲ್ಲ ಈ ಸರಿ ಬಂದೆ. Registry shall release the amount deposited under the DD referred above to digitally ಅಂತ ಮಾಡಿ digitally release ಅಂತ ಮಾಡಿ in favor of the respondent and furnishing required documents. ಇದನ್ನ beginning ನಲ್ಲೇ ತಗೊಂಡ್ಬಿಡಿ. Appellant has submitted memo for waiving the cost imposed by this court by order dated 8/4/25. ಇದು ಕೆಳಗೆ ಬರ್ಕೊಂಡ್ಬಿಡಿ ಮಾಸ. Since the parties have entered into the settlement, the order dated 8/4/25 imposing the cost of this 5,000 is hereby recalled.
Party signature. Number 28, Ramlingegowda HA, HCGP. ಅಲ್ಲಿ ಕಳಿಸ್ಬಿಡಿ. ಆಮೇಲೆ ಹಿಂದೊಂದು ಯಾವುದೋ ರೆಕಾರ್ಡಲ್ಲಿ ಒರಿಜಿನಲ್ ಇರಲಿಲ್ಲ ಅಂತ DD ಕೊಡ್ತಾರಲ್ಲ ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಕಳಿಸ್ಬಿಡಿ. ಅಲ್ಲ ಯಾವುದೋ ಒಂದು ಕೇಸಲ್ಲಿ ನಾನ್ ರಿಜಿಸ್ಟರ್ ಎಡಿಷನ್ ಇರುವಾಗ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೇಫ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇರಬೇಕಂತ ಹೇಳಿದ್ರು. ಈಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಈಗ ಕೊಟ್ರಲ್ಲ ಇಲ್ಲ ಇತ್ತಲ್ಲ ಜೆರಾಕ್ಸ್ ಅಲ್ಲ ಬೇಡ ಇಲ್ಲಿಂದ ಕಳಿಸ್ಬಿಡಿ. ಇಲ್ಲಿಂದನೇ ಕಳಿಸ್ಬಿಡಿ. ಅದನ್ನ ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ ರಿಜಿಸ್ಟ್ರೇಷನ್. DD ಕೊಟ್ರ ನೀವು ಒರಿಜಿನಲ್ ಎಲ್ಲಿದೆ ಅದ? ಇಲ್ಲ ನನ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಮತ್ತೆ ಹೊಳಿ ತಗೊಂಡ್ರ? ಅದ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇಲ್ಲೇ ಕಳಿಸ್ಬಿಡಿ. ಇಲ್ಲಿಂದ ಇಲ್ಲಿಗೆನೆ ಸರಿ. ಅದ ಹೆಂಗ್ ಬರ್ಕೊಂಡು ರಿಜಿಸ್ಟ್ರಿ ಶಾಲ್ ರಿಯಲೈಸ್ ದ DD and digitally release the same to the respondent and furnishing the record documents. ಅದು ಎಷ್ಟು ಚೌಕಾಸಿ ಮಾಡ್ತೀರಿ? ಅವ್ರ ಹೆಸರಲ್ಲೇ DD ತಗೊಂಡ್ಬಂದು ಇಲ್ಲೇ ಕೊಟ್ಬಿಟ್ರೆ. See, there is a clause in the petition that she should not file. Even if she files, it should be presented with this order should be presented ಅಂತ ಎಲ್ಲ ಹೇಳಿದೀರಾ. ಮತ್ತೆ ಅದರಲ್ಲಿ ಒಂದಿಷ್ಟು Number 28, Ramlingegowda.
Referent is really ಕೊಲೆ ಮಾಡುವಷ್ಟು ಜಿದ್ದು ಇಲ್ಲ ಅಂತಾನು ಕಂಪ್ಲೇಂಟ್ ಹೇಳಿದ್ದಾರೆ ನನ್ನ ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ. ಪೇಜ್ ನಂಬರ್ 101ರಲ್ಲಿ ಪ್ಯಾರಾ 18 ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ನನ್ನ ತಮ್ಮನನ್ನು ಕೊಲೆ ಮಾಡುವಷ್ಟು ಜಿದ್ದು ಆರೋಪಿತರಲ್ಲಿ ಇಲ್ಲ ಎಂದರೆ ಸರಿ. ಮರು ಹೇಳಿಕೆ ನೀಡಿರಲಿಲ್ಲ. ಅದು ಅದೇ ತರವಾಗಿ ಸತ್ತ ವ್ಯಕ್ತಿ ಅಪ್ಪನು ಸಹ
ಮೋಟಿವ್ ಆಯ್ತು. ದಟ್ ಈಸ್ ಅಬೌಟ್ ಮೋಟಿವ್. ಇದರಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಜುಡಿಷಿಯಲ್ ಕನ್ಫೆಷನ್ಗೆ 2 witnesses were cited. One is ಯಾರು ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ
ಮತ್ತೆ ಇವರು
ಅಂತಪ್ಪ. ಅವ್ರು ಇನ್ನೊಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್
ಮಾಡಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 136. ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ ಹನುಮಂತಪ್ಪ ಅವ್ರು ಎಕ್ಸಾಮ್ ಮಾಡಿಲ್ಲ, ಆಗಿಲ್ಲ.
He did not support. What were the other circumstances? That's all.
Sir, ಅದೇ ಇವರೇ ನಮಗೆ ತಮ್ಮನ
Confession was at the instance of accused number 1.
ಒನ್ ಅಷ್ಟೇ ಸರ್.
Any other recovery from this accused?
ದಿಸ್ ಅಕ್ಯೂಸ್ ಅಲ್ಲಿ ಬಟ್ಟೆ ಅಂತ ಸೀಜ್ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ.
His own clothes.
ಅವ್ರು ಯೂಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Accused himself, not deceased. ಅವ್ರದ್ದೇನು ಬಿಲಾಂಗಿಂಗ್ಸ್ ಏನಿಲ್ಲ.
ಇಲ್ಲ.
Incriminating ಏನಿದೆ? Incriminating
ಅದೇ ಲಾಸ್ಟ್ ಇನ್ ವಿಟ್ನೆಸ್, ಲಾಸ್ಟ್ ಇನ್ ಟುಗೆದರ್.
So why that in the trial court bail was not granted?
ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಇವ್ರು ಯಾರೇ ಮೂವ್ ಮಾಡೋಕೆ ಸ್ವಲ್ಪ ಹಿಂದುಳಿದ ಜನಾಂಗ ಆರೋಪಿಗಳು.
ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ದೊಡ್ಡಬಳ್ಳಾಪುರ. I think it's a case to grant suspension because at his instance there is no material. Yes. And his antecedents were also not clear. Deceased, he had so they have elicited that he had other enemies also. Admit agilva. This appeal is admitted already. Orders in 2025. Generally murder cases ಇವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನಾನು ರೆಕಾರ್ಡ್ ಬಂದಿದೆ, ಬಟ್ ನಾವು ಮಾಡೋ ನಂತರ he also has produced the records. ಅವರೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. This was filed on which date? 20th March 2025 ಹೇಳಬೇಕು.
ಫ್ರಮ್ ಬಿಗಿನಿಂಗ್ 21 ಅಲ್ಲ 28/4/2019 ಇದ್ದಾರೆ ಆರೋಪಿ. 7 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಆಗ್ಬಿಡ್ತು.
Which were the documents? ನೀವು ಹೇಳಬೇಕು. Which were the other circumstances against him?
Yes, my lord. 10 and 11 are the last seen witnesses, my lord. And there is a recovery. Blood-stained clothes were recovered. That has been supported.
Whether the blood grouping of the deceased was done? What was the use of that? I mean, how that was connecting the accused to the crime? Clothes FSL ಮಾಡಿದ್ರಾ?
FSL ಅಲ್ಲಿ ಯಾವುದೇ ಗ್ರೂಪ್ ಈ ಆರೋಪಿದು ಡಿಟೆಕ್ಟ್ ಆಗಿಲ್ಲ ಸರ್. ಕಂಡಿಡಿಯಕ್ಕೆ ಆಗಿಲ್ಲ. ಇದರಲ್ಲಿ 47 ಎಕ್ಸಿಬಿಟ್ 47 ಅಲ್ಲಿ
ಪ್ರಾದೇಶಿಕ ವಿಧಿ ವಿಜ್ಞಾನ ಪ್ರಯೋಗಾಲಯ
ಪೇಜ್
363.
ಸ್ವಲ್ಪ ಕೊಡ್ತೀವಿ. ಬ್ಲಡ್ ಸ್ಟೈನ್ ನಾಟ್ 363 ಪೇಜ್ ನಂಬರ್ 363 ಒಪಿನಿಯನ್ ಅಲ್ಲಿ 10, 11, 12.
There were many clothes. 8 to 9 one underwear, one shirt, one pant. Serial number 10 to 13.
Serial number ಯಾರು?
10 to 12.
10, 11 and 12 ನಮ್ಮ ಆರೋಪಿಯಿಂದ ಬಟ್ಟೆ ಸೀಜ್ ಮಾಡಿದ್ವು ಅಂತ.
11 and 12 A2
A2 ಬಗ್ಗೆ ಸೀಜ್ ಮಾಡಿದ್ವು. ಡಿಟೆಕ್ಟ್ ಆಗಿಲ್ಲ.
11 and ಯಾವಾಗ ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ. ಹಿಯರ್ ಅಂಡ್ ದೇರ್ ಅಂತ ಇದೆ. ಡಿಟೆಕ್ಟ್ ಆಗಿದೆ. If you but were not sufficient for serological analysis
ಇದೆ.
ಸೊ ಇದು ಬಿಟ್ರೆ ನೋ ವೆಪನ್
ಯಾವುದು ಇಲ್ಲ. ವೆಪನ್ ಗಿಪ್ಪನ್ ಯಾವುದು ಸೀಜ್ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ಅವರೇ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ, ಪೊಲೀಸರು ಹೇಳಿದ್ದಾರೆ ಅವನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಯಾವುದೇ ವ್ಯಕ್ತಿಗೂ ಈ ವ್ಯಕ್ತಿ ಅಂತ ತೋರಿಸಿಲ್ಲ, ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡ್ಸೇ ಇಲ್ಲ. ಇವನ್ನೇ ಹೇಳಿದ್ದಾರೆ. ಕ್ವಶನ್ ಕೇಳಿ
Orders in number 2025. Delay condonation last one. The above appeal is filed by accused number 2 in SC number 10,014 of 2019 on the file of 4th additional district and session judge Doddaballapura, Bangalore Rural District. By the impugned judgment and order, the appellant, along with accused number 1 and 3, is convicted for the offences punishable under section 302, 201, read section 34 IPC. For the major offence, that is 302 IPC, all the accused are sentenced to imprisonment for life and fine of Rs 25,000. The charge against the accused was that due to some ill will between accused number 1 and victim Sagar, he conspired with accused number 2 and 3 to commit murder of Sagar. It is further alleged that in execution of such conspiracy, on 19/4/2018, the accused inducing 24/2018. At about 10:30 a.m., the accused inducing Sagar of getting him alcoholic drinks, took him to a bar and make him drunk at 2:30 p.m. Near Honnagatta Kacha Road. They picked up quarrel with him, assaulted him. ಇಲ್ಲೇನು ವೆಪನ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇಲ್ವೇ ಇಲ್ಲ.
ಇಲ್ಲ, ಇದು ಕಲ್ಲು ಅಂತ ಹೇಳಿತ್ತು ಅವ್ರು. ಕಲ್ಲು, ಇಡಿಗಾತ್ರದ ಕಲ್ಲು ಅಂತ.
ಕೈಯಿಂದ ಹೊಡೆದು ಆಮೇಲೆ ಎಳ್ಕೊಂಡು ಹೋಗಿ ಅಂತನಾ? Assaulted him by their hands and legs, dragged him to a nearby creek. There assaulted him with stone. MO ಮಾರ್ಕ್ ಆಗಿದೆಯಾ? ಸ್ಟೋನ್ ರಿಕವರ್ ಆಗಿದೆಯಾ?
ಕಲ್ಲು ರಿಕವರಿ ಆಗಿದೆ.
ಕಲ್ಲು ರಿಕವರಿ.
It's not recovered.
ಕಲ್ಲು ರಿಕವರಿ ಆಗಿದೆ ಸರ್.
MO
ಹೇಳ್ತೀನಿ.
ಕಾಣೋದೇ ಇಲ್ಲ ಇದರಲ್ಲಿ. MO1 ಮಾದರಿ ಅಂತ ಏನು?
ಕಾಡು ಕಲ್ಲು, ಕಲೆ ಆಗಿರುವ ರಕ್ತದ ಕಲೆ ಆಗಿರುವ ಕಾಡು ಕಲ್ಲು.
MO1
PF ನಂಬರ್ 71
committed his murder. Assaulted MO1 and committed his murder. To screen the evidence of offense, they buried him in a pit. Next paragraph. The case was based on exclusively on the circumstantial evidence. So far as accused number 1, the dead body was discovered at his instance.
ಪ್ರಮೋನಿಂದ.
So far as the other circumstances relied were motive, that is ill will between accused number 1 and the deceased. As against these accused, there was no motive.
ಇಲ್ಲ, ಮೋಟಿವ್ ಏನಿಲ್ಲ ಸರ್.
Against there was no motive.
ಇವರು ಹೇಳಿದ್ರು ಫ್ರೆಂಡ್ ಅಂತಾನೆ, A1 ಫ್ರೆಂಡ್ ಅಂತ.
There was no motive was attributed. Though it was alleged that blood-stained clothes of The appellant was recovered. The FSL report indicates that there was nothing to connect the appellant to prima facie indicator. There was nothing to connect the appellant to the crime. The witness for the extrajudicial confession has not supported. The prosecution version in the cross-examination. Prosecution version against the present appellant in his cross-examination. The records also indicate that deceased also was not having good antecedents, and it was elicited that he had other enemies also. The appellant is in custody already since 2019.
19, but 20 April 2000.
Ultimately, is,
28 April 2000.
he is
28
arrested.
ನಾಲ್ಕು.
ಇದರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅವರು ಅರೆಸ್ಟ್ ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದ್ರಷ್ಟೇ 28 2019 ಅಂತ ಹೇಳಿದ್ದೆ ನಾನು if at all ultimately the impugned judgment is reversed and till then appellant is continued in the custody, his liberty cannot be reimbursed. Therefore, it is a fit case to grant suspension of sentence and bail. Hence, the application is allowed. The impugned order of sentence passed against the appellant is hereby suspended and is granted bail in the above case subject to the following conditions. So, the fine deposit model in model. He shall 25,000 he shall execute personal bond in a sum of rupees 50,000 and furnish two sureties in the like sum to the satisfaction of the trial court. He shall appear before the he shall deposit the fine amount before the trial court. Next, he shall appear before the court whenever required. Next, after 2025 ಅಲ್ಲ after 2 weeks ಪೇಪರ್ ಬುಕ್ ರೆಡಿ ಆಗಿದೆ ಏನಿಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ ನಿಂದ ಅಡ್ಮಿಟ್ ಮಾಡೋ ಪೇಪರ್ ಬುಕ್ ಮಾಡಿರ್ಬೇಕು ಆರ್ಡರ್ ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ವಾ ಅಡ್ಮಿಟೆಡ್ ಆನ್ 25/4
ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಿದೆ ಪೇಪರ್ ಬುಕ್ಕಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆ ಪೇಪರ್ ಬುಕ್ಕಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆ ಪೇಪರ್ ಬುಕ್ಕಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆ
ಅಲ್ಲ ಬರೀ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ ಕರೆಕ್ಟ್ ಯು ಆರ್ ರೈಟ್ and the registry shall prepare the paper books in 6 weeks list of the receipt of paper
ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಬೇಕೇನೋ ನಮ್ಮ ಕೇಸಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಆರ್ಡರ್ ಆಗಬೇಕೇನೋ
ಮಾಡಿದ್ವಲ್ಲ
ಆಯ್ತು ಮಚ್ಚಪ್ಪ
Seal number 29, Suresh Lathur, Padma Sutur for Artu.
My lord, the claim petition was dismissed, my lord. Kindly condone delayed 56 days.
56 days delay. Who is the other side? Padma.
Lords, I represent the respondent number 2.
56.
Lords, may kindly condone the delay of 56 days.
Case of 33 years. Case of injury.
Yes, my lord. Case of injury, my lord.
Why it is dismissed? ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಆಕ್ಸಿಡೆಂಟ್ ಅಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತನಾ ಇಲ್ಲ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಇಸ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ಅಂತನಾ ಇಂದ ನೆಗೆಟಿವ್ ಅಂತ ಇದೆ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ವೆಹಿಕಲ್ ಅಂತ ಆಯ್ತಲ್ಲ ಹಂಗಂದ್ರೆ but for the respondent respond number 1426 respond number 2 ವಕಾಲತ್ ಇನ್ನೂ ಹಾಕಿಲ್ವಾ
ಇನ್ನೂ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ
6 time to file wakalat she shall file the wakalat in the registry within 2 weeks. Orders on I1 of 2025 considering the reasons assigned to explain the delay of 56 days in filing the appeal is condemned in the interest of justice. I1 of 2025 is disposed of accordingly. Admit call for TCRs. List of the receipt of TCRs.
Seal number 30, KT Gurudev Prasad.
CD 176. Notice of ಯಾರು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾರಿದ್ದಾರೆ? ಇಫ್ಕೋ ಟೋಕಿಯೋ ಇದ್ದಾರಾ? ಇಫ್ಕೋ ಟೋಕಿಯೋದವರು
ಪ್ರದೀಪ್ ಮೂರು ಇದ್ದಾರೆ.
ಪ್ರದೀಪ್ ಇದ್ದಾರಾ? ಯಾರೋ ಅವ್ರ ಕೊಲೆಗೆ ಇದ್ರಲ್ಲ ಇಲ್ಲ?
ಸರ್ ನೀವಿದ್ದೀರಾ ಅಶೋಕ್ ಇನ್ಫೋಟ್ ಇಫ್ಕೋ ಟೋಕಿಯೋ
ಇಲ್ವಂತೆ ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ ನಿಮ್ಮ ಹತ್ರ ಲಿಸ್ಟ್ ಇಲ್ವಾ?
ಪ್ರದೀಪ್, ಪಿ ವಿಜಯ್ ಕುಮಾರ್, ಎಸ್ ವಿ ಹೆಗ್ಡಮಲ್ಕನ್, ಸಿ ಶಂಕರ್ ರೆಡ್ಡಿ, ಓ ಮಹೇಶ್, ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ, ಬಿ ಸಿ ಶಿವಣ್ಣೇಗೌಡ, ಮುರಳೀಧರ್ ನೆಲ್ವಾಲ್, ಇ.ಐ. ಸನ್ಮತಿ, ಪಿ ಎಚ್ ಜಗದೀಶ್.
ಮುರಳೀಧರ್ ನೆಲ್ವಾಲ್ ಕೂಡ ಮುಂದೆ ಬರ್ತಿರ್ತಾರೆ ಅವರು. ಮುರಳೀಧರ್ ನೆಲ್ವಾಲ್ ಬರ್ತಿರ್ತಾರೆ, ಜೂನಿಯರ್ ಇದ್ದಾರೆ. ಶ್ರೀ ಮುರಳೀಧರ್ ನೆಲ್ವಾಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 is requested to accept notice for respond number 1. ಉಳಿದೆಲ್ಲ ಬರ್ಕೊಂಡ್ರೆ issue notice to respond number 2. Please down 497.
Cell number 31 Nayak Krishna Venkatraman.
Case of death, my lord. So appeal is for enhancement, my lord.
Which is the insurance company.
Yes, my lord. Respond number 2, Liberty General Insurance Company. Already insurance company filed the appeal, my lord.
They have preferred appeal. Who has preferred?
Ravi Samprati, my lord.
Ravi Samprati. Ravi keep ಅಂತ ಕಾಣಿಸುತ್ತೆ. Sri Ravi B. Samprati, last standing counsel for respond number 2 is requested to accept notice for respond number 2. What about respond number 1?
Kindly notice may be dispensed with, my lord.
Memo ಕೊಡಿ.
Yes.
Now counsel for the appeal service memo for dispensation of notice to respond number 1. Contest ಮಾಡಿದ್ರಾ? Expert.
Expert.
Respond number 1 had not contested the matter before the tribunal. Under the impugned award. ಅವ್ರಿಗೆ ಮಾಡಿದಾರ ಅಂದ್ರೆ ಪೇ ಅಂಡ್ ರಿಕವರ್ ಅಂತ ಮಾಡಿದಾರ?
ಇಲ್ಲ only contempt challenge ಮಾಡಿದ್ದಾರೆ.
The impugned award, the liability.
Yes.
Pay compensation is personal against respond number 2. Therefore, notice to respond number 1 is dispensed with as paid for. It is submitted that this matter is connected to MFA number 07 of 20. So and so list both the matters together on date ಹೇಳಿದ್ರು. Stay application ಅವರೇನು 19 stay ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಅದು withdrawal ಗೂ ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
ಆರ್ಡರ್ ಆಗಿದೆ.
ಹಾ.
ಎಷ್ಟು? 19/6.
ಪ್ಲೀಸ್.
32 ಅಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ಸರ್. ಓನ್ಲಿ ಕಾಂಟೆಂಪ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಆಲ್ರೆಡಿ 50% ಅಮೌಂಟ್.
both the matters together after 2 weeks ಅಂತ.
ಪ್ಲೀಸ್.
Cell number 32 P Dhananjaya.
2025.
But 454 days delay ಇದೆ.
ನ್ಯಾಷನಲ್ ಅವರು ಇನ್ನು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿಯವ್ರಿಗೆ ವೆಕೇಶನ್ ಮುಗಿದಿಲ್ಲ. ಯು ಆರ್ ದೇರ್ ಫಾರ್ ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ. ಕೃಷ್ಣಸ್ವಾಮಿ
ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ.
ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 is requested to accept notice for respond number 1. What about 2 and
Office objection, my lord. With regard to the date of the accident 5/11/18, my lord. In issues ನಲ್ಲಿ 15/11 ಆಗಿದೆ ಅದೊಂದೇನೆ.
note the office objection notice that office date of accident stated in page 3 of the trial court judgment.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ.
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಬರುತ್ತೆ? ಅವ್ರದಾಗ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ರೆಸ್ಪಾಂಡ್
ಡೆತ್
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಲಯಬಿಲಿಟಿ ಯಾರ ಮೇಲೆ ಇದೆ? ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ಸಿನ್ಸ್ ದ ಮಿಸ್ಟೇಕ್ ಇಸ್ ಆನ್ ದ ಪಾರ್ಟ್ ಆಫ್ ದ ಟ್ರಿಬ್ಯುನಲ್ ಆಫೀಸ್ ನೋಟಿಸ್ ರಿಜೆಕ್ಟೆಡ್ ಮಾಡಿ ನೋಟಿಸ್ ಟು ಸೊ ಅಂಡ್ ಸೊ ಅಂತ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಶಾಲ್ ಡೆಪಾಸಿಟ್ ಅಬೌವ್ ಸಮ್ ವಿದಿನ್ 2 months.
ಸಣ್ಣ ಇದು ಸ್ಪ್ರೇ ಹೊಡೆದಿಲ್ಲ ಅವರು.
ಯಾಕೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮಾಡಿಸ್ಕೊಳಕ್ ಆಗಲ್ವಾ ಇದರಲ್ಲಿ?
50 lakhs is arpanad. Only 32 and add is given.
ಹಾಗಲ್ಲ ಇದರಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಅವ್ರ ಏನಾದ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿದಾರಾ?
ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಇನ್ಸೂರೆನ್ಸ್ ನವರು ಹಾಕಿದ್ದಾರೆ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು
ಸೀತಾರಾಮ ಶಾಸ್ತ್ರಿ is appearing on behalf of the respondent. 1 minute.
ಅವ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ದ
ಡೈರೆಕ್ಟ್ ಆಗಿ
ಹೇಳ್ಬೇಕು ಇಲ್ವಾ? ನಾವು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಹೇಳ್ತಾ
will
ಇದ್ದೀವಿ.
serve the copy ಪಂತಿ.
Correct, you say somebody else has filed appeal, not Mr. Krishnaswamy. ಇಲ್ಲ ಅದಷ್ಟು ತೆಗೆದು ಬಿಟ್ಬಿಡಿ. ಆಫೀಸ್ ನೋಟ್ ರಿಜೆಕ್ಟೆಡ್ ಅದನ್ನ
ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಬರ್ಕೊಡಿ.
It is submitted that this appeal is connected to MFA number ಹೇಳಿ ಅದು ಯಾವುದು ಅಂತ? MFA ನಂಬರ್
ಕನೆಕ್ಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಪೀಲ್
ನಂಬರ್ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ?
ಕೊಡ್ತೇನೆ.
ನಂಬರ್ ಅಲ್ಲ ಅದು ಬೇಡ ಬರಲಿ ನೋಡೋಣ ಪ್ಲೀಸ್ both the matters together
12, 11 of 24, my lord.
please both the matters together after 2 weeks.
Seal number 33, Satish Shetty.
Claimant appeal for announcement. Second respondent insurance company also filed one more appeal. Kindly list.
Which is the advocate?
2187/23. N. Krishnaswamy.
Krishnaswamy ಅವ್ರ colleague ಇದಾರೆ ಶ್ರೀ N. Krishnaswamy large channel counsel for respondent is requested to accept notice for respondent to what about respondent on notice?
Issue notice. I take steps.
Issue notice to respondent it is submitted that this matter is connected to MFA number
2187/23.
Please both the matters together on
Same number. 2187 bar
23.
same. ಇದು ಇವ್ರದಾ?
late
14/7.
14
For admission, seal number 34, Ashok N. Patil.
minor ಇದರಲ್ಲಿ respondent number 2 and 3 minor ಇದ್ದಾರೆ and their guardian has not turned up. You may have to see.
There is a connected appeal filed by the claimant, my lords. I'll give that now.
They have filed.
ಹೌದು 1939 of 2020, my lords.
2018 ಅಡ್ಮಿಟ್ ಮಾಡದೇನೆ ಇದು ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅದು ಕನೆಕ್ಟ್ ಮಾಡಲಿ ಆಮೇಲೆ 2018 as it is
ಹೌದು
ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಅದೇ ಬರುತ್ತೆ ಸೀನಿಯಾರಿಟಿ
liability I have question.
ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಅದೇ ಬರುತ್ತೆ hard admit it is submitted that this matter is connected to MF number so and so. Please both the matters together on date is ಬರೆದು ಕೊಡಿ ನಾ
Speaker 10/6.
longer date
24/6. Seal number 35 adjourned. Seal number 36, Ramurthy HK, Shripad V. Shastri, Prarvan.
both side absent 50% ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡೋದು ಹೇಗೆ ಶಾಸ್ತ್ರಿ ಅವ್ರು ಯಾವಾಗ್ಲೂ ಇದ್ರಲ್ಲಿ ಆನ್ಲೈನ್ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ರಲ್ಲಿ ಬೆಳಿಗ್ಗೆಯಿಂದನೂ ಇಲ್ವಾ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ವಿ LIC ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಇವ್ರಿಗೆ ನನ್ನ ಅಪಿಯರ್ಸ್ 2021 ಇದು ಶಾಸ್ತ್ರಿ ಅವ್ರು ಇಲ್ಲೇ ಅಪಿಯರ್ ಆಗ್ತಾ ಇರ್ತಾರೆ ಅವ್ರು ಆನ್ಲೈನ್ ಅಲ್ಲಿದೆ ಬಟ್ ಹಿ ಈಸ್ ಹಿಯರ್ ಇನ್ ಜುಡಿಷಿಯಲ್ ಈಗ ನನ್ನ ಅಪಿಯರ್ಸ್ ಅಡ್ಜೆಂಟ್
Seal number 37, Udayan, SPP.
I am for the appellant. But offences, my lords, are my lords 302, 201, 397, 120B. I am accused number 1. My lords, I have been acquitted, my lords, of all the charges, my lords, except 302. Conviction, my lords, now life has.
302 you are acquitted.
Alla, 302 conviction agide. 397, 120.
302 you are acquitted.
Other offences, my
So
lords.
accused number 1. How
So,
many?
my lords, there were 2 accused.
One is dead.
One is dead, my lords, just prior to my lords charge sheet. She expires. My lords, the case of the prosecution, my lords, purely, my lords, relies on, my lords, the circumstantial evidence.
Records are there, yes.
Records are there, my lords. My lords,
There is recovery of robbed articles.
no, my lords. My lords, the prosecution's case is, my lords, ಚಿನ್ನದ ತಾಳಿ ಮತ್ತೆ ಒಂದು ಮೊಬೈಲ್ ಫೋನ್ ಅಂತ ಹೇಳ್ತಾರೆ. Those 2, my lords, are recovered, my lords, under exhibit P9 and P10, my lords. Now, my lords, before I, my lords, would venture into, my lords, that part, this case, my lords, solely relies on, my lords, the circumstantial evidence. There are absolutely, my lords, no eyewitnesses. And secondly, my lords, the prosecution, my lords, miserably fails to, my lords, place on record any material to, my lords, either, my lords, prompt my arrest or, my lords, my implication in this case. Again, my lords, in all fairness, my lords, I would just, my lords, say CW15, my lords, is the only person. She has not been examined, my lords. For reasons best known to the prosecution, she has not been examined. She is the only person, my lords, that would say that, my lords, accused number 2 ಜೊತೆಗೆ ಯಾರೋ ಒಬ್ರು ಅಪರಿಚಿತರು ಆ ದಿನ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. Now, my lords, that lady has not been examined at all. And, my lords, apart from her,
In circumstances.
no, ಅಲ್ಲಿ ಯಾರು TIP ನೂ ಮಾಡೋದಿಲ್ಲ ಈ ಕೇಸ್.
ಅದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ ಅಂತ
No, that has not been, my lords, that has not been done. That has also not been done. Charge sheet, my lords. This entire case, my lords, is, my lords, filled with, my lords, investigation lacunas I may be, my lords, permitted to, my lords, just read, my lords, the cross examination of the IO.
Just a minute. First, we wanted to know whatever the circumstances relied by the prosecution.
Please, my lords.
Last scene ಬಿಟ್ಟು ಮತ್ತೆ
Last scene prove ಆಗಿಲ್ಲ. Last scene ಹೇಳೋದೇ ಇಲ್ಲ ಯಾರನ್ನು.
Correct. Circumstances prosecution rely ಮಾಡಿದ್ದು ಯಾವ್ದು? Last scene.
My lords, my lords.
For the witnesses for the last scene theory.
There are no witnesses to the last scene theory, my lords.
Charge sheet ಅಲ್ಲಿ ಯಾರು ಇಲ್ವಾ?
ಇಲ್ಲ. Except CW15.
ಮತ್ತೆ ಯಾರು ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, CW15 would say ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ. And my lords, I admittedly, my lords, do not reside in that place. I admittedly do not have a rental agreement. And PW5 would positively say, I never resided in that place.
This is What is the name of this accused?
Lords, I am accused number 1, my lords.
No,
Rajshekhar.
Rajshekhar. PW8 is the last scene witness, Marian.
No, my lords, he is the jeweler, my lords.
ಅಲ್ಲರಿ PW8 ಮರಿಯನ್ ಇವರು ಕೃತ್ಯ ನಡೆದ ವಟಾರದ ಮನೆಯ ಮಾಲೀಕರಾಗಿದ್ದು ಆರೋಪಿ ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರು ವಾಸವಿದ್ದು ಕೃತ್ಯ ನಡೆದಿರುವ ಬಗ್ಗೆ.
No, Mariana is the building owner.
Landlord.
Yes, my lords, landlord.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಯಾರು ಲಾಸ್ಟ್ ಸೀನ್ ವಿಟ್ನೆಸ್
ಯಾರು ಇಲ್ಲ
ಸೈಟ್ ಮಾಡಿಲ್ಲ.
ಯಾರನ್ನು ಸೈಟ್ ಮಾಡಿಲ್ಲ. And my lords, even the impugned order, my lords, is recorded only in, my lords, 39 pages. 38th paragraph ವರ್ಗುನು ಬರೀ ಎವಿಡೆನ್ಸ್ ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಲಾಸ್ಟ್ one paraದಲ್ಲಿ they just say principle is relied on by the accused are not applicable. Prosecution has proved the case. ಅಷ್ಟೇ. My lords, I read it, my lords, 4 times the entire judgment. I could not, my lords, find the reasonings, my lords, to convict me, my lords. 39 pages.
During that, right?
Lords, I was, my lords, in custody throughout, my lords, trial.
Why?
Lords, first two, my lords, prior to charge sheet, I filed bail. I did not, my lords, succeed. Thereafter, my lords, at the fag end, my lords, I filed one more bail. Court said no. Lords, in this case, my lords, I just want to, my lords, bring on record, my lords, one lacuna that the prosecution has, my lords, that has been spoken out.
Recovery is PW ಎಷ್ಟವರು?
PW8, my lords, is the jeweler.
Where is evidence?
And exhibit P11, my lords, is the document that they propose to mark.
See,
P11 is a
charge sheet
register.
does not indicate that last scene circumstance ಗೆ ಯಾರಾದ್ರೂ ಇದಾರೆ ಅಂತ. ಏನಾದ್ರೂ ಯಾವ್ದಾದ್ರು CCTV footages ಏನಾರ ಇದೆಯಾ?
No.
How is that? PW8.
PW8, my lords, is the jeweler.
P11 means the recovery in P11.
Yes, lords, exhibit P11 ಬಗ್ಗೆನೇ ಹೇಳಬೇಕು. It does not contain my signature.
First we'll see the evidence of PW8.
Yes, my lords.
Exhibit P11 is the recovery mahazar.
No, exhibit P9 and 10, my lords, are the recovery mahazars.
Recovery of this jewelry.
Jewelry is P10, my lords. Exhibit P10.
ಆರೋಪಿತರು ನಮ್ಮ ಅಂಗಡಿಯಲ್ಲಿ ಚಿನ್ನದ 2 ತಾಳೆಗಳು ಹಣ ತೆಗೆದುಕೊಂಡು he implicates both of them.
Joint recovery, my lords.
Nishani P10 number 10 and 11.
Please.
So accused number 2 has signed on that. So his 164 statement was recorded. This,
yes.
PW8.
Yes, yes, his 164 is also recorded, and my lords, it is marked, my lords, as exhibit P21.
P21 ಅಂತ.
ಅಲ್ಲಿ ಏನು ಹೇಳೋದೇ ಇಲ್ಲ, exhibit P21.
How did you impeach the evidence of this witness? ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಲ್ಲ ಅವ್ರಿಗೆ. 10/7/2021 5 ಗಂಟೆಗೆ ಇಂದ್ರಮಳು ನಮ್ಮ ಅಂಗಡಿಗೆ ಬಂದು ಒಡವೆಗಳನ್ನು ನನಗೆ ನೀಡಿ ಇವು ತಮ್ಮ ಒಂದು ನನಗೆ ಸಾಲವಿದೆ ಅಂತ ಎಟ್ಸಿಟ್ರಾ ಅಂತ
ಬಾಡಿಗೆ ಕಟ್ಟಿಲ್ಲ, ಕರೆಂಟ್ ಬಿಲ್ ಇಲ್ಲ ಎಂದು ಹೇಳಿದ್ರಿಂದ ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ನೀಡಿದ್ದೇನೆ. Now my lords, the next part is very relevant.
Oh, that's statement you will
Yes, yes, that has been my lords asked. The next statement is my lords very relevant.
You yourself conducted that, right?
No. The last part, my lords, it is only accused number 2 who had, my lords, come to the pawn shop.
CCTV.
And my lords, exhibit P11, my lords, does not contain my signature, my lords. And the signature is forged, my lords. In fact, I want to, my lords, just request this court to make a comparison.
ಪೆನ್ಸಿಲಿಂದ ಬರೆದಿದ್ದಾರೆ. ಹೇಳಿದ್ದೇನೆ, ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ ಇಲ್ಲ. 1ನೇ ಆರೋಪಿ ನನ್ನ ಅಂಗಡಿಗೆ ಯಾವತ್ತೂ ಬಂದಿರಲಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ ಅಂತಲ್ಲ. It's with P21. Were neighbors, accused and deceased.
Accused number 2 and deceased were neighbors, my lords. Not accused number, the appellant was not a neighbor.
Which is his place of residence?
Lords, his place of residence, your lordships will find at, my lords, exhibit P17, my lords.
Magli Road, Bangalore ಅಂತ ಇದೆ.
Jai Bhuvaneshwari Nagara ಅಂತ ಇದೆ.
Scene of offense?
Scene of offense is, my lords, Gnan Bharati police station limits.
CW1 and 14 says that one person will come and go to the accused number.
CW1
that identify ಮಾಡಿದವರು ಲಾಸ್ಟ್ ಸೀನ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಇಲ್ಲಿ ಯಾವುದು ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡುವಾಗ nothing is seen.
No.
Anybody has identified him?
My lords, one more aspect, my lords. This occurred, my lords, during COVID period. My lords, PW7, my lords, I'm sorry. He is an independent witness. ಏನಕ್ಕೆ ಈ ಮಹಜರ್ಗಳಿಗೆ he is one of the independent witness. He would say throughout, my lords, the accused wore a mask. Aden batte kerchief ಅಲ್ಲಿ ದೊಡ್ಡ mask ಹಾಕ್ತಾರೆ. He never identifies, my lords. Even, my lords, in the court, he would say ಮಕ್ಕದಲ್ಲಿ mask ಹಾಕಿದ್ರು. That is one, my lords. Secondly, my lords.
Just we're trying to see exhibit
Yes, yes.
P21.
P21 is 164 statement, my lords.
P21. So even in this 164 statement, recovery was at the instance of accused number 2.
Lords, there is absolutely no reasoning, my lords. I'll just, my lords, invite your lordship's kind attention. Sorry.
It is not impeached. Nothing is. It was also elicited so that there was no quarrel amongst the witnesses.
These are all, my lords, extract of, my lords, the evidence. Page 53.
Sniffer dogs were not employed.
No, allu one the discrepancy there. PW1 would say on the date of the incident, the dog squad was invited. Kardirilla anತಾರೆ. PW2 would say illa dog squad ittu anta.
What IO says?
IO, my lords, may I request your lordships to kindly come to, my lords, cross examination of the IO. PW 11 minutes. PW 11. He would nullify the entire prosecution's case. Entire prosecution's case. May I just read minutes?
Just
Exhibit PW 11.
W11.
Lakshman Naik, police inspector.
Yes. Cross-examination.
Cross-examination.
Now, in the chief examination, he is implicated in this case on the basis of voluntary statement of accused number 2.
No, both are arrested at the same time.
No, how they rounded on?
That is, my lords. That is the question, my lords. Even I want to.
Did you ask them in the cross-examination?
Yes, I did, my lords. Illi, adikkene, my lords. May I just cross-examination, my lords, page 5, my lords. Page.
Yes.
ಪ್ರಕರಣದ ಸಿಡಿಯನ್ನು ಆಧರಿಸಿ ನನ್ನ ಸಾಕ್ಷ್ಯವನ್ನು ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ನುಡಿದಿರುತ್ತೇನೆ. ಸಿಡಿಯಲ್ಲಿ ದಿನಾಂಕ 10/7/2021 ತೆರೆದಿರುತ್ತೇನೆ. ದೂರಿನಲ್ಲಿ ಚಿನ್ನದ ಒಡವೆಗಳಿಗಾಗಿ ಕೊಲೆಯಾಗಿದೆ ಮತ್ತು ಚಿನ್ನದ ಒಡವೆಗಳು ಕಳ್ಳತನವಾಗಿದೆ ಎಂದು ನಮೂದಿಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಚಾಸ 1ರವರು ದೂರಿನಲ್ಲಿ ಮೃತಳು ಧರಿಸಿದ ಒಡವೆಗಳ ಮಾಹಿತಿಯನ್ನು ನೀಡಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಸ್ಥಳ ಪಂಚನಾಮೆಯಲ್ಲೂ ಸಹ ಒಡವೆಗಳು ಕಳ್ಳತನದ ಆದ ಬಗ್ಗೆ ಮೂಲ ನಮೂದು ಇಲ್ಲ ಎಂದರೆ ನಿಜ. ಪ್ರಕರಣ ಅನಾಮಧೇಯ ವ್ಯಕ್ತಿಗಳ ಮೇಲೆ ಕೇಸು ಆಗಿದೆ ಎಂದರೆ ನಿಜ. ಶವ ಪಂಚನಾಮೆ ಮಾಡುವ ಕಾಲದಲ್ಲಿಯೂ 1ನೇ ಆರೋಪಿಯ ವಿರುದ್ಧ ಯಾವುದೇ ಸಾಕ್ಷಿದಾರರು ಅನುಮಾನ ವ್ಯಕ್ತಪಡಿಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. 1ನೇ ಆರೋಪಿಯನ್ನು ದಸ್ತಗಿರಿ ಮಾಡುವವರೆಗೆ ಆತನ ಹೆಸರು ಅಲ್ಲಿಯವರೆಗೆ ನಡೆದ ತನಿಖೆಯಲ್ಲಿ ಎಲ್ಲಿಯೂ ಕಂಡು ಬಂದಿಲ್ಲ ಎಂದರೆ ನಿಜ. 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿದಾಗ ರಿಮಾಂಡ್ ಅರ್ಜಿಯಲ್ಲಿ ಚಾಸ 15ರವರು ನೀಡಿದ ಹೇಳಿಕೆಯ ಕುರಿತು ನಮೂದು ಮಾಡಿಲ್ಲ ಎಂದರೆ ನಿಜ. CW 15, my lords, is Preeti. She is, my lords, the wife of PW 6. She has not been, my lords, examined.
PW 6 means
PW 6 is the neighbor, my lords, upstairs neighbor. Then, my lords, ಚಾಸ 15ರವರು ಅಪರಿಚಿತ ಗಂಡಸು ಬಂದು ಹೋದ ಬಗ್ಗೆ ಮತ್ತು ಆ ವ್ಯಕ್ತಿಯನ್ನು ಗುರುತಿಸುವ ಬಗ್ಗೆ ನನ್ನ ಮುಂದೆ ಹೇಳಿದ್ದರು ಅಂದರೆ ನಿಜ. 1ನೇ ಆರೋಪಿ ದಸ್ತಗಿರಿ ಮಾಡಿದ ನಂತರ ಚಾಸ 15ರವರ ಮುಂದೆ ಗುರುತು ಕವಾಯತು ನಡೆಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. Next page, my lords. The next page.
ಎಲ್ಲ ಹಿಂದೆ ಮುಂದೆ ಗುರುತು ಅಂತ ಇಲ್ಲಿ ಮುಗಿದು 5.
May I just read that sentence, my lords?
Yes.
1ನೇ ಆರೋಪಿಯನ್ನು ದಸ್ತಗಿರಿ ಮಾಡಿದ ನಂತರ ಚಾಸ 15ರವರ ಮುಂದೆ ಗುರುತು ಕವಾಯತು ನಡೆಸಿಲ್ಲ ಎಂದರೆ ನಿಜ. ಕಾರಣ ಆರೋಪಿ ಪರಿಚಿತನಾಗಿದ್ದನು. Now, my lords, may I just request this court to, my lords, take, my lords, at least I'll just read it out, my lords.
ಸ್ಥಳಕ್ಕೆ ಶ್ವಾನಗಳು ಬಂದಿದ್ದು ಎರಡನೇ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗಿಲ್ಲ ಎಂದರೆ ನಿಜ.
May I continue to read, my lords? ಇದೆಲ್ಲ ನಾನು ಫುಲ್ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿ. ಸ್ಥಳಕ್ಕೆ ಬೆರಳಚ್ಚು ತಜ್ಞರು ಬಂದಿದ್ದರು. ಸ್ಥಳದಲ್ಲಿ ಗೋಡೆಯ ಮೇಲೆ ಬೆರಳಚ್ಚು ಮಾದರಿಗಳನ್ನು ಪಡೆದಿರುತ್ತಾರೆ, ಆದರೆ ಚಾಕುವಿನ ಮೇಲೆ ಪಡೆದಿರುವುದಿಲ್ಲ. ಕಾರಣ ಚಾಕು ಮೃತಳ ಕೈಯಲ್ಲಿತ್ತು. ಬಾತ್ರೂಮ್ನ ಬಾಗಿಲಿನ ಹಿಡಿ, ಟಿವಿಯ ರಿಮೋಟ್, ಕಿಟಕಿಯಿಂದ ಬೆರಳಚ್ಚು ಮಾದರಿಗಳನ್ನು ಸಂಗ್ರಹಿಸಿರುವುದಿಲ್ಲ. ಕಾರಣ ಸ್ಥಳಕ್ಕೆ ತಜ್ಞರು ಬರುವ ಮೊದಲೇ ಇತರೆ ಸಾರ್ವಜನಿಕರು ಓಡಾಡಿದ್ದರು. ಸೊ, my lords, the entire place is, my lords, tampered. ಬೆರಳಚ್ಚು ತಜ್ಞರು ಕೆಲವು ಮಾದರಿಗಳನ್ನು ಪಡೆದಿರುತ್ತಾರೆ, ಕೆಲವು ಪಡೆದಿರುವುದಿಲ್ಲ. 1ನೇ ಆರೋಪಿಯ ಬೆರಳಚ್ಚು ಮಾದರಿ ಪಡೆದಿರುತ್ತೇವೆ. 1ನೇ ಆರೋಪಿಯ ಬೆರಳಚ್ಚು ಮಾದರಿಯನ್ನು ತಜ್ಞರು ಪಡೆದ ಮಾದರಿಗಳಿಗೆ ಹೋಲಿಕೆ ಮಾಡುವಂತೆ ಕೋರಿ ಮನವಿ ಮಾಡಿರುವುದಿಲ್ಲ. ತಜ್ಞರು ಸಹ ನಮಗೆ ವರದಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಸ್ಥಳಕ್ಕೆ ಶ್ವಾನದಳವು ಬಂದಿದ್ದು 2ನೇ ಆರೋಪಿಯ ಮನೆಗೆ ಹೋಗಿಲ್ಲ ಅಂದರೆ ನಿಜ. ಬೆರಳಚ್ಚು ತಜ್ಞರು ನಾವು ಸ್ಥಳಕ್ಕೆ ಬರುವ ಮೊದಲು ಚಾಸ 14ರವರು ಮತ್ತು ಸಾರ್ವಜನಿಕರು ಕೃತ್ಯ ನಡೆದ ಜಾಗದಲ್ಲಿ ಓಡಾಡಿ ಮೃತದೇಹವನ್ನು ನೋಡಿರುತ್ತಾರೆ ಎಂದರೆ ನಿಜ. Again, my lords, the scene of crime, my lords, has again been, my lords, compromised. Then, my lords, ಸಂಜೆ 5ರಿಂದ 5:46 ಗಂಟೆ ಸುಮಾರಿಗೆ ದೂರವಾಣಿ ಮೂಲಕ ನನಗೆ ಕೃತ್ಯದ ಬಗ್ಗೆ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡ ನಂತರ ಸಂಜೆ 7:45 ಸುಮಾರಿಗೆ ಜಾಗಕ್ಕೆ ಹೋಗಿರುತ್ತೇನೆ. ಮಾಹಿತಿ ಬಂದ ನಂತರ ಸ್ಥಳವನ್ನು ಕಾಯಲು ಸಿಬ್ಬಂದಿಯನ್ನು ನೇಮಕ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಾಸ 1:14 ಮತ್ತು ಮೃತಳ ಮೊಬೈಲ್ನ CDR ವರದಿಯನ್ನು ನಾನು ಪಡೆದಿಲ್ಲ. 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳ CDR ವರದಿಯನ್ನು ನಾನು ಪಡೆದಿಲ್ಲ. ಶಂಕಿತ ವ್ಯಕ್ತಿಯ ಮೊಬೈಲ್ ಸಂಖ್ಯೆ ಪಡೆದು ಪರಿಶೀಲಿಸಿ ದಾಖಲಾತಿಯನ್ನು CDR ನ ವರದಿಯಲ್ಲಿ ಪಡೆದಿಲ್ಲ. So, the last part, my lords, again with regard to CCTV, my lords.
He says he has not collected.
Yes, but PW 8, my lords, the pawn broker would say ನನ್ನ ಅಂಗಡಿನಲ್ಲಿ CCTV ಇತ್ತು, and it is only, my lords, accused number 2 who entered.
Cross examination.
Further cross ಇದೆ. Further cross ಅಲ್ಲೂ ಇನ್ನ ಹೇಳ್ತಾರೆ, he did not, my lords, inquire regarding the spot ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು CCTV ಇತ್ತ ಅನ್ನೋದು ಹೇಳಿಲ್ಲ. Then, my lords, you would also say Suko team.
What basis they connected the accused to the crime?
That is, my lords, even, my lords,
No, I know in his chief examination what he says.
Chief allu ashte, I'll just read, my lords. It is only, my lords, 3 pages, 4 pages. I'm sorry, my lords. May I read, my lords?
He is the sole IO.
ಇಲ್ಲ, ಇನ್ನೊಬ್ರು PW 10 ಇದ್ದಾರೆ.
Who arrested these accused?
Lords, he was arrested by, my lords, PW 10 ಅಂದ್ರೆ ಇವರಿಬ್ರು ಅರೆಸ್ಟ್ ಮಾಡಲ್ಲ, they would depute one more person.
Correct. No, who connected the accused?
ಅದನ್ನ ಸ್ವಾಮಿ page 2 of the very same witness, my lords, PW 11, page 2 para 4, my lords. Page 2 para 4. May I read, my lords?
Yes.
ಮೃತಳ ಶವವನ್ನು ಮರಣೋತ್ತರ ಪರೀಕ್ಷೆಗೆ ಆಸ್ಪತ್ರೆಗೆ ಕಳುಹಿಸಿರುತ್ತೇನೆ. ದಿನಾಂಕ 11/7/21ರಂದು ಚಾಸ 32ರವರ ಮುಖಾಂತರ ಮೃತಳ ಶವ ಪಂಚನಾಮವನ್ನು ಜರುಗಿಸಿ ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಆರೋಪಿತರ ಪತ್ತೆಗಾಗಿ ಸಿಬ್ಬಂದಿಗಳನ್ನು ನೇಮಕ ಮಾಡಿದ್ದು ಚಾಸ 26ರಿಂದ 31ರವರು 1 ಮತ್ತು 2ನೇ ಆರೋಪಿತರನ್ನು ಪತ್ತೆ ಮಾಡಿ ನನ್ನ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದ್ದು ಅವರನ್ನು ದಸ್ತಗಿರಿ ಮಾಡಿ ವಿಚಾರಣೆ. Now, my lords, these my lords ಚಾಸ 26ರಿಂದ 31, nobody my lords has been examined. Nobody. ಅದು ಹೇಗೆ ನಾನ್ ಸಿಕ್ಕದೆ ಅನ್ನೋದನ್ನ till date, my lords, the prosecution has, my lords, not stated anything. And my lords, it is not a case that, my lords, my fingerprint matches, or my lords, my CDR matches, or at least my location that, my lords, I resided in this building ಅನ್ನೋದಕ್ಕೂ ಮಾಯಣ್ಣ ಕಾಂಪೌಂಡ್ ಅವರು ಏನು ಓನರ್ ಇದ್ದಾರೆ PW5, you would categorically say the agreement was between accused number 2 and myself. Accused number 1 was never visited the spot ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. Because, my lords, this was during COVID. The very, my lords, ಓಡಾಡೋದಕ್ಕೂ ಭಾರಿ ರೆಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಇತ್ತು.
ಕಂಪ್ಯಾರಿಸನ್ ಮಾಡಿದ್ದಾರೆ ಅವರೇ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅನ್ನು ಇಲ್ಲಿ para 28 acting under section 73 of evidence of comparing the signature found on exhibit P9. What is exhibit P9? What is exhibit P9?
Exhibit P9, my lords, is the spot
Panchanama.
Panchanama, my lords.
Which Panchanama?
P9, my lords, is clothes Panchanama. Clothes were recovered. And even there, my lords, I was wearing a mask.
ಇದು pawn broker ಅದೇನು signature merger witnesses have not supported.
No, they have, my lords, just said, my lords, ನಮಗೆ ಈ ದಿನ ಅಲ್ಲಿ ಪ್ರಿಂಟ್ ಮಾಡಿಸಿದ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಅಂತ ಅಷ್ಟೇ. They, my lords, because it is not revealed, my lords, in their presence.
Trial courts venture to compare the signature on
No, my
exhibit
lords,
P9.
absolutely nothing, my lords. I have, my lords, read the judgment 5 times. Not once, my lords. It ends, my lords, at the time where, my lords, evidence is extracted. Soon thereafter, my lords, the last paragraph says principles relied by the accuser, not.
That is with reference to the evidence of PW8.
Lords, my lords, one striking point I just want to bring to court's notice is, my lords, exhibit P9, my lords. Exhibit P9 ಅಲ್ಲಿ page 7, my lords.
Yes.
2 different signatures altogether, my lords. Accused number 2 though.
ಅದನ್ನ ಕಂಪೇರ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
Exhibit P13.
ಅಲ್ಲ ಅದಕ್ಕೆ ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
P9 and 10 ನಾವೇ ಕಂಪೇರ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ ಆ ಎರಡು ಸಿಗ್ನೇಚರ್ ಮ್ಯಾಚೇ ಆಗೋದಿಲ್ಲ. accused number 2 though. P9, my lords, page 7, my lords. There is an extract of, my lords, the exhibit P11 bill. Bill ಇದೆ ಸ್ವಾಮಿ, top of the page.
Number ಎಷ್ಟು?
7, my lords.
ರಾಜಶೇಖರ್ and Indramma.
ಇಂದ್ರಮ್ಮ ಅಂತ ಇಲ್ಲಿದೆ. Kindly see, my lords, the signature that has been put, that is of, my lords, accused number 2 ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. The signature also does not match. ಇದಮ್ಮ ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅಲ್ಲಿ.
But anyway,
ಅಲ್ಲ, not just that, my lords.
recovery is at the instance of accused
Number 2. Yes, my lords. Yes.
So it is instance.
And, my lords, the very
transaction was in the name of
10,000.
accused number 2 only.
Yes, my lords. Absolutely. And, my lords, pawn broker would
In these photographs, this accused number 1 is not reflected.
Lords, accused number 1 is not reflected. In, my lords, exhibit P10, my lords, is reflected. P10 cloth recovery ಅಂತ. ಆ cloth recovery ಎಲ್ಲಿ FSL ಕಳಿಸೋದೇ ಇಲ್ಲ. None of, my lords, the articles are sent to FSL.
Who is the accused there? ಇದನ್ನ ತೆಗೆದಾರಲ್ಲ ಅವರು.
ಎಲ್ಲರೂ ಮಾಸ್ಕ್ ಹಾಕಿದ್ದಾರೆ.
ಮಾಸ್ಕ್ ಇಲ್ಲದೆ ಇರೋದು. His mask is removed. No, he is not there in exhibit P9.
No, my lords. Exhibit P10 ಅಷ್ಟೇ. But ಇವರು ಸ್ಮಾರ್ಟ್ ಆಗಿ they would just write ಆರೋಪಿತರು in plural.
Yes, what do you say? What do you say? Appeal is admitted?
No, my lords, not yet.
For admissions.
LCR is called for.
ಬರೀ ಅದು ಹೇಳೋದು during it was elicited ಬರೀ ಅಲ್ಲ during the cross examination it was elicited ಅಂತ ತಾವೇ ಹೇಳ್ತಾರೆ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಹ್ಯಾಡ್ ನಾಟ್ ಕಲೆಕ್ಟೆಡ್ ದ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ಸ್ ಅಂತ discrepancies, no doubt. ತಾವೇ ಹೇಳ್ತಾರೆ there are discrepancies, no doubt. That should be an account of various factors that are natural. Where is the reasoning to connect this accused?
No, that is my point, my lords. There is no reasoning. Whether this,
You have to show us.
The owner
whether
says,
this
my lords,
reasoning sustains.
The owner says a man comes and goes.
Owner says,
A man comes and goes to the.
right, a
as
man
office.
comes means whether he had identified him, owner,
There's no
in his
such
evidence.
identification.
Who is owner?
That's PW5, my lords.
PW5.
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 Just read his exact his statement as well, my lords. He doesn't say so, my lords.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರೆಕಾರ್ಡ್ಸ್ ಅಷ್ಟೇ ಇರುತ್ತಲ್ಲ. ಒಬ್ಬ ಗಂಡಸು ಬಂದು ಹೋಗಿ ಮಾಡುತ್ತಿದ್ದರು, ಸಂಬಂಧಿಕರು ಹೇಳುತ್ತಿದ್ದರು.
And throughout, my lords, all witnesses would say one thing, my lords. Police ಅವರು ನಮಗೆ ಹೇಳಿದ್ದು.
ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಾದ್ರೂ ಐಡೆಂಟಿಫೈ ಮಾಡಿದಾರಾ?
ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ.
ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿರೋ ಆರೋಪಿಯನ್ನು ನೋಡಿ ಸಾಕ್ಷಿಯು ಇವನು 1ನೇ ಮಹಡಿಯಲ್ಲಿ ಬಾಡಿಗೆಗಿದ್ದ ಹೆಂಗಸಿನ ಮನೆಗೆ ಬಂದು ಹೋಗಿ ಮಾಡುತ್ತಿದ್ದನು ಎಂದು ಹೇಳಿದ್ದಾರೆ.
ಅಷ್ಟೇ.
ಮಾಡಿದ್ದಾರೆ.
Not on the date of, my lords, the incident.
No, we asked you whether he had identified this accused.
No, my lords, ಅದಕ್ಕಿಂತ ಮುಂಚೆ may I just request this court.
ನಾನು ಮಯನ ಕಂಪನಿ ಬಾಡಿಗೆ ಕೊಟ್ಟಿರಲಿಲ್ಲ. ಯಾರು ಬಂದಿರ್ತಾರೆ ನಾನು ಗಮನಿಸಿಲ್ಲ. ನಾನು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಐಡೆಂಟಿಫೈ ಮಾಡಿದೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಈ ಮಹಿಳೆ ಕೊಲೆ ಮಾಡಿರ್ತಾಳೆ ಎಂದು ಪೊಲೀಸರ ಮೇಲೆ ನಾನು ಕೇಳಿದಾಗ ಹೌದು ಎಂದು ಹೇಳಿದೆ. ಆಮೇಲೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಾಕ್ಷಿ ಹೇಳಲು ಬಂದಾಗ ಮೊದಲ ಬಾರಿ ನಾನು ಆರೋಪಿಯನ್ನು ನೋಡಿದ್ದೇನೆ ಎಂದರೆ ನಿಜ.
That is, my lords, I wanted to point out this, my lords, for the first time, my lords. And rental agreement.
Defense has been taken, my lords, whether the same person is been defense ತಗೊಂಡಿದ್ದಾರೆ ಅಲ್ವಾ ಗೊತ್ತಿಲ್ಲ ಅದರಲ್ಲಿ.
ವಿಟ್ನೆಸ್
ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಲ್ವಾ ಗೊತ್ತಿಲ್ಲ accused.
ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಐಡೆಂಟಿಫೈ?
The person identifies as the same person or the other person.
ತಗೊಂಡಿದ್ದಾರೆ, ಕೇಳಿದ್ದಾರೆ. ಕ್ರಾಸ್
Last
ಎಕ್ಸಾಮಿನೇಷನ್
question, my lords.
ನಾನು ಮೊದಲನೇ ಬಾರಿ ಆರೋಪಿಯನ್ನು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನೋಡುತ್ತಿದ್ದೇನೆ ಅಂದರೆ ನಿಜ ಅಂತ ಹೇಳ್ತಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ he says that this accused ಇಷ್ಟೇ ಹೇಳ್ತಾರೆ. he was the one who was visiting his tenant ಅಂತ ಹೇಳ್ತಾರೆ.
Particularly they could have made a question that was he the person who was visiting.
ಕೇಳಿದ್ದಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. why they should put such questions? ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ನೋಡ್ತಾ
ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು.
maybe offense is very serious, but ಆ ಸೀರಿಯಸ್ನೆಸ್ ಬೇಕಲ್ಲ ಇವ್ರಿಗೆ ಅವ್ರನ್ನ ಕನೆಕ್ಟ್ ಮಾಡೋದು. ಅಫೆನ್ಸ್ ಇಸ್ ಸೀರಿಯಸ್, ರೈಟ್? ಇಲ್ಲ, ಬಟ್ ಆಲ್ರೆಡಿ ಕನ್ವಿಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿದೆ ನೋಡಿ ಅಂತ ಎವಿಡೆನ್ಸ್ ಮೇಲೆ. But complaint was against unknown person. And yavat date of offense is?
Verse 10/7/2021.
When these people were arrested?
11/7/2021.
Next date, sir.
Next date. And, my lords, one aspect, my lords, remand application there. My lords, remand application, my lords, does not even, my lords, bear any excerpt of, my lords, CW15 statement that, my lords, on that particular day A2 ಜೊತೆಗೆ ಯಾರೋ ಒಬ್ಬ unknown person ಹೋಗ್ತಿದ್ದ ಅನ್ನೋದು ಬರ್ತದೆ.
The case is based on the evidence of the landlord. And so far as connecting the
yes,
last seen circumstance ke landlord is the only witness.
He doesn't say, my lords, on that day he saw anta helala. He used to come and go, his, my lords.
Even as per his 162 statement.
Yes. To that extent, my lords, he would state that, my lords. But on the date of incident, the
but admit ಅಂತ ಮಾಡೋ admission ಗೆ ಬಂದಿರೋದಲ್ಲ. Third admit matter request detail consideration admit call for TCR ಬಂದಿದೆ. TCR
is not there.
Admit TCR ಬಂದಿದೆ, correct. Paper book shall be prepared within 6 weeks. Orders on I1 of 2025 challenging the judgment and order of conviction and sentence passed against him. Accused number 1 in SC number 195/2022 on the file of
71st additional civil and session judge, Bangalore, has preferred this appeal. She died even before the charges were framed.
No, before charge sheet was framed. Lords, she died on 1/10/2021.
And COVID.
No, the COVID ಗೊತ್ತಿಲ್ಲ, while in custody, my lords.
Custody.
In custody, it is reported in the order sheet as well. 1/10/21.
So charge sheet, awaited charge sheet ಅಂತಾನೆ ಹಾಕಿದಾರಾ?
ಹೌದು.
The charge against the appellant is that accused number 2 was a neighbor of deceased Ranjita. And accused number 1 was the acquaintance of accused number 2. Accused number 1 and 2 were the financial cases. Ranjita had they were aware of Ranjita possessing valuable jewelries. Therefore, they conspired to rob the jewelries. They conspired to commit murder of Ranjita and rob her jewelries. In execution of such conspiracy on 10/7/2021 at 10 a.m. ಅವಾಗ ಅದು trespass ಆಗುತ್ತಲ್ಲ, ಮತ್ತೆ ಅದಕ್ಕೆ ಮಾಡಿಲ್ವಾ 448 offense?
No, my lords.
If they get into her house with an intention to commit murder, then that amounts to trespass.
But charge itself is, my lords, not framed for that offense.
The accused. Then how they committed her murder? Stabbing her.
Stabbing her.
Entered into the house of the victim. Startled and died.
Stab injury in the neck.
Tried to rob her jewelry and she resisted. They throttled her neck and accused number 1 stabbed her with a knife and committed her murder. Then they sped away with the robbed jewelry. Accused number 2 died even before the charge sheet was filed. Accused number 1 ನೋಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು. Is that correct? She died before charge sheet was filed.
1/10/2021.
ಅಲ್ಲ, ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಇಲ್ಲಿ ಇವ್ರು ಹೇಳಿದ್ರಲ್ಲ ನಾವು ಬರೆಯುವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ ರಾಜಶೇಖರ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಹೇಳ್ತಾರೆ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ.
Order sheet, my lords. Order sheet 1/10/2021 records the death of accused number 2.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಒಂದು ಕಾಲಮ್ ಇರುತ್ತಲ್ಲ,
that should have been, my lords, reflected, my lords.
Just we'll check that ನೋಡ.
ಇಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಬರಿಬೇಕಿತ್ತು, ಬರ್ದಿಲ್ಲ ಸರ್.
It is submitted that the accused died even before the charge sheet was filed. Okay, next one. The case was based on circumstantial evidence. The circumstances relied on that the accused number 1 and 2 were found by PW8 or
body. My lords, PW1 and PW4, my lords.
PW1 and 4.
Husband and, my lords, brother-in-law.
No, they are not the last seen circumstance.
No, body found.
Last seen circumstance.
CW15, my lords. CW15.
PW ಹೇಳಿ.
She is not examined, my lords. Your lordships are asking about the owner.
Owner of the house, landlord, ಅವ್ರನ್ನು ಹೇಳಿಸಿದ್ದಾರೆ ನೋಡಿ.
Owner is, my lords, PW5, my lords.
ಅವ್ರ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ನೀವು
5, my lords. Five.
PW5 found
Mayanna.
the accused entering the house of the deceased soon thereafter she was found dead. There was recovery of the jewelries of the deceased from PW pawn broker PW8.
8 my lords.
8. The pawn broker at the instance of the accused. PW5. The records at least show that. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ ಸೀನ್ ಅಂತ ಕೊಟ್ಟಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ
ನಾನು ನೋಡಿದೆ.
In the charge sheet.
PW5 CW This is it. PW5 is Marianna.
19 my lords. CW 19. Marianna. ಇವರು ಕೃತ್ಯ ನಡೆದ ವಠಾರದ ಮನೆಯ ಮಾಲೀಕರಾಗಿದ್ದು ಆರೋಪಿತರು ಮತ್ತು ಫಿರ್ಯಾದಿದಾರರ ತಮ್ಮ ಮನೆಗೆ ಬಾಡಿಗೆಗೆ ವಾಸವಾಗಿದ್ದು ಕೃತ್ಯ ನಡೆದಿರುವ ಬಗ್ಗೆ ಮತ್ತು ಹೆಣವನ್ನು ನೋಡಿದ ಬಗ್ಗೆ ನುಡಿಯುತ್ತಾರೆ.
PW5, the records produced show that PW5
records are produced, the records are already received. Show that PW5, though in the chief examination stated that he found accused number 1 and 2 entering the house of the deceased. In the cross examination stated that he is seeing the appellant, accused number 1, appellant for in the court for the first time. CW18 who was cited as witness for last seen circumstance was not examined. According to PW8, the pawnbroker, the jewelries were pledged by PW, pledged by accused number 2. Even in his 164 statement allo hage helidare.
ಹೌದು.
Even in his statement of section 164 of CRPC, exhibit P21. He has not implicated the present appellant, though he claims he states that his business premises has the CCTV. The IO has not collected the CCTV footages. The appellant is in judicial custody since
11/7/2021.
21. Since more than 4 years. About 4 years.
Yes.
4 years. Since about 4 years. If at all the judgment is reversed and he is made to stay in the judicial custody, the question becomes irreversible. Any criminal antecedents vere enaru ideya? It is submitted that he has no other criminal antecedents. Under circumstances, it is a fit case to grant suspension of sentence and bail. Hence, application is allowed. The appellant is granted. Then impugned order of sentence against the appellant is suspended and he is granted bail in the other case subject to conditions. He shall execute 50,000 bond, 2 sureties. Shall deposit fine amount before the trial court. He shall appear before the court whenever required. List after the preparation of paper books.
Let's admit. Let's admission.
Admitted paper books order madam.
Yes, grateful.
Number 38, Mahesh Chandra PN, Harish PN.
I'm appearing for the respondent. Lord, my lords, I pray for 2 weeks time to file objections, my lord. Yesterday I have received the wakalat, my lord. I will file it in the counter tomorrow.
My lords, kindly a week's time, my lords. My lords, for the reason that there is an IE that has to be taken into consideration, my lords, which is the request. Any date next week, my lords.
What about other orders are not challenged? There was
Lord, the other orders with respect to the divorce which is granted, that we are filing an appeal for that as well.
not yet filed.
We are filing tomorrow. Tomorrow we'll be filing the appeal, my lord.
Can I admit by record as requested by response counsel list on Indian Warden?
If I may request for next week, better some other next week, one
Kindly,
week
my
time
lords,
to
next
file
week, my
objections.
It is opposing to custody matter alva idu.
My lords, kindly next week, my lords. 11th. Grateful, my lords.
Number 39, Sunita
File is in
PC.
his custody. Our kಡೆಯಿಂದ
Great.
execution. Do you undertake that you will not file execution? Then we'll grant you time.
11/6.
Huh?
11/6 I'll file objections before 11/6.
All right.
Great.
Still number 39, Sunita PC.
I will pay for the appliance.
Our custody will execution upon first.
My lord, husband has filed a petition for divorce, my lord, for Indian divorce under Indian Divorce Act. Divorce has been granted, my lord, on the ground of cruelty and desertion, my lord. Vice petitions, my lord.
Contested.
Please, my lord, she has contested, my lord.
Admit call for TCS. Issue notice to the respondent. Interim stay of the impugned judgment and decree. Judgment and decree till further orders. I1 of 2021 to dispose of.
Please,
Now list on notice on
14/7. Still number 40, Geeta R.
I appear for appellant, my lord. It is an insurance company appeal, my lords, challenging the liability, my lords.
On what ground? Liability.
My lords?
Liability is challenged on what ground?
Lords,
License or involvement of the vehicle or what is that?
Involvement of the vehicle, my lords. Here the accident is caused by the driver of the tractor and trailer, my lords, and I am the insurer for the trailer, my lords. And the tribunal holds that accident is caused by the driver of the tractor and trailer, my lords. But while compensating the
Admit call for TCS. Issue notice to the respondents. Interim stay of execution of the impugned award till further order, subject to appellant depositing 50% of the award amount with accrued interest before this court within 4 weeks from the date of the receipt copy of this order. Records call for ಮಾಡ್ತಿದ್ದಲ್ಲ ಅದೇನು ಕಳ್ಸೋದು ತರಿಸೋದು ಹಿಂಗೆಲ್ಲ ಆಗುತ್ತೆ ಅದು ನಾನು ಮೊದಲು ಹಾಗೆ ಮಾಡ್ತಿದ್ದೆ ಈಗ ಡಿಜಿಟಲಿ ರಿಲೀಸ್ ಮಾಡ್ತಿರೋದ್ರಿಂದ ತೊಂದರೆ ಆಗೋದಿಲ್ಲ.
14/7. Still number 41, VR Kishore Kumar.
New India Insurance Company. CS Junior ಪ್ರದೀಪ್ ಅಲ್ಲ ಕೃಷ್ಣಸ್ವಾಮಿ ಯಾರು ಇದ್ದೀರಾ ನ್ಯೂ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿಯವರು?
PIN number 43 I am appearing for, madam.
ಯಾರು?
SV Hegde Mulkund ಇದ್ದಾರೆ ಮೇಡಮ್.
ಇದಾರಾ? ನ್ಯೂ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್. ಶ್ರೀ SV Hegde Mulkund ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅವ್ರು ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ ಅಪೆಲೆನ್ಸ್ ಕೌನ್ಸಿಲ್. This request assurance. Access notice for respond number 4. ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. ಎಲ್ಲ ಪಾರ್ಟ್ಲಿ ಅಲೋ ಆಗಿದೆ ಅದು ಏನು liberty is reserved to respond to insist respond number 1 insurance to deposit the compensation. And deposit the compensation. Owner liability ಏನೋ recover pay and recover ಅಂತ ಮಾಡಿದ್ದಾರೆ. And admit call for TCS, issue notice to respondents 1 to 3. List on
14/7. Still number 42, Harish NR.
Case lawyers
Appellant is the wife of the respondent. She filed a divorce petition on the ground of cruelty and desertion. That petition was decreed, divorce was granted, but my lord, there were adverse findings were recorded that she was living adulterate life with one other is previous employer.
You are challenging the decree in its entirety.
Also, finding my lord, recorded, even though the my lord, para number 13, the advocate for respondent my lord, considered for divorce. Findings 7.
So you sought divorce on the ground of cruelty.
Cruelty.
Desertion.
Desertion.
Where is that observation you say?
Observation para number
What's
20.
the reason for making such observation?
22, 24, 25.
Like ಯಾಕೆ ಅಂತ why that occasion arose?
Please. Para number 24.
Police complaint. So now you have not sought interim stay, only interim maintenance you have sought.
Maintenance sought, madam. Because,
Notice
my lord, application IA number 9 was filed, my lord, for seeking permanent alimony. Application was rejected.
On the ground that you are leading adult trust life.
Please, my lord, that is on road, that road, my lord.
What is the
And my lord, my request is, my lord,
Just issue notice to the respondent.
like appellant has a child, my lord, he's a special child. She has to take care of the child, my lord.
We'll see, hope barley, records to barley. Ex parte interim maintenance cannot be awarded.
14/7. For framing of charges.
What is it? On the 1 month,
30th, 36.
the framing of charge and custody.
For framing of charges, seal number 43, Raghava P. K.S. Ravi Kumar, party person.
My lord,
The complainant in the matter, my lord.
Why amicus curiae was appointed in the Supreme Court?
my lord,
Why amicus curiae was appointed in the Supreme Court for you?
Supreme Court, I had approached the Supreme.
You appeared personally first. Your appeal was dismissed with cause. Subsequently, for waiver of that cost, amicus curiae was appointed. Why?
Yeah, no, the Honorable Supreme Court passed an order imposing another 30,000 as cost.
Right, that's
Thereafter,
what we are saying. Why the amicus curiae was appointed?
yes, my lord, contempt notice was issued to me. In the contempt proceedings, I said I cannot appear before the court.
Why?
I'm in Bangalore, I cannot travel to Delhi. So therefore, I sought for a.
Virtually appeared.
My lord?
You could have virtually appeared. It was not.
Yes, that's what
It was not in contempt. It was in that SLP only.
No, contempt notice was issued only thereafter when I say I cannot appear, my lord, my lordships, honorable.
2025, 21/3/2025. Yes, other side, whether you are aware why amicus curiae was appointed, who is for the other side here?
My lord, the main thing, the main ground why Supreme Court dismissed whatever order was.
Not asking about dismissal. Why amicus curiae was appointed? Where is the material to show that you submitted that you cannot appear?
No, Supreme Court itself said that we will appoint.
Probably you were not
initially,
able to assist the court.
Amicus curiae was appointed by the Honorable Supreme Court.
Correct. Why?
Because I don't have the money to travel to Delhi.
You could have appeared virtually.
Yeah, I was virtually on. I was on the. My lord, the main thing, the case is about
Raghava.
I'm appearing online, my lord.
Had you appeared in that, it appears I had not appeared. Notice was not sent to
I have not appeared in the proceedings before the Supreme Court, my lord.
Previous 2 hearings he has not appeared. He was directed to appear in person. He's been appearing through VC because he has filed a false. This is a false case. He has lied, made perjury.
See, now the scope is very limited. You have failed up to the Supreme Court. The case is listed today for framing charges. We have to frame the charges.
No,
Indeed, my lord.
In the first place, according to Rules 10, I am allowed to file reply affidavit. I have filed reply affidavit, and I have several grounds.
For framing of charges and
The complainant and his counsel has made false statements in the petition, making perjury that the association is registered. It is
My lords, my humble request, this honorable court may kindly proceed with the framing of charges. The simple reason is that
when the other side is submitting, you are again intervene. Then
Allah,
you have to
let
say
me
you do not
complete.
let the court. See, we asked you the case is listed for because we had seen the order sheet. It was listed for framing of the charges.
Yes, my lord, I'm ready to, if trial is going to be conducted, I'm ready for that. But Supreme Court has, Honorable Supreme Court has recalled the order.
Not in this case. There, it was there.
Yes, that means that
Indeed, my lord.
whatever this the learned single judge has made several errors. Moreover, my lord, moreover,
Not open to when the learned single judge's judgment is confirmed. It is not open to you to question the correctness of the single judge's order.
no, this judgment itself was fraudulently obtained, and the Honorable Supreme Court.
Whether he is competent to address the court and the ಕೇಳ್ತಿರೋದು.
Milords, he has been making such submissions all throughout the proceedings, Milords. It is my humble request to kindly proceed with the framing of charges against him, because on one or the other pretext, the matter has been getting adjourned on his request.
That's what we were trying to see. We had seen the order sheet. Date order, the date 25 to 2025.
He is a practicing advocate, Milords, and he claims that he is an indigent.
Framing of the charges ಅಂತ ಇದು ಆಗಿತ್ತು ಅವತ್ತು. ಇಲ್ಲ hearing before charges ಆದ್ಮೇಲೆ ಅದು framing of charges ಅಂತ because 40 days ಆಗಿದೆ 23 ಇಂದ. ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ IAS ಎಲ್ಲ ಡಿಸ್ಕಸ್. IA1 of 2024. What is that IA1 of 2024? ಅವರನ್ನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿಲ್ಲ. Supreme Court also tried to institute contempt against him of the judgment of What is IA1 of 2024? You argue on that. We will consider the next matter. IA1 of 2024.
My lord, this honorable court had directed the respondent counsel to appear and give an
We are asking you, what is IA1 of 2024? You tell us first what is
IA1 is seeking documents, my lord, in order to ascertain whether this association, complainant association, of
IA1 of 2024. Don't have it correct.
IA1, my lord, is about these documents will, that I have sought certain documents, which documents will show that it is a registered association. It is not a registered association. They don't have the authority.
One second, learned counsel, let him complete his submission on IA1 of 2024, then we'll consider your submission.
My lord, the association is running illegally, has been obtained illegally, and there is an FIR registered against the.
You had taken up all these contentions in the writ petition.
My lord?
You had taken up all these contentions in the writ petition.
Yes, I have in my reply.
That was rejected.
In my reply affidavit.
No, he had taken up all these contentions. Suraj Govindra ಅವರದ್ರಲ್ಲಿ.
I have taken contention in my reply affidavit, which was submitted.
Right, now that's all on your IA1 of 2024?
My lord?
That is all on your IA1 of 2024? That's all your submission on IA1 of 2024?
My lord, there is one more memo dated 7, wherein this honorable court, wide notification or a circular, said that if there is a proprietary concern, partnership, company, association, society, it has to be verified even before admitting the case. So therefore, even the IA number 1 points to that. If these documents are available, only then it becomes a registered association. Only then they can demand maintenance. They don't have the authority to seek maintenance. And the person who
You are the owner of the flat?
Hello?
You are the owner of the flat?
Yes, my wife is owner.
No, you see, that is all open to maintenance is sought from who? From you or owner of the flat?
Owner of the flat.
Then what?
No, the association itself is fraud.
That's all. Yes. Yes, sir. What do you say on IA 1 of 2024?
Miloj, first of all, Miloj, the application is not maintainable at this particular stage, Miloj. As the matter of the non-payment or non-compliance of the orders passed by the learned single judge, and the same has been confirmed by the Honorable Supreme Court as well, Miloj. And it is interesting to note that the Honorable Supreme Court has passed a stricture against him. They have passed an order not to commit such a thing once again, and it is a warning that has been passed against him. It says that, however, we have cautioned the petitioner case Ravi Kumar of being careful in future. Now again he comes back to this before this honorable court and raises the same contention of the association being not registered. Now, the first of all, the application itself is not maintainable in view of the fact that the matter for consideration is only with regard to the compliance or non-compliance, Milaj. However, the amount that is to be paid is 25,000 as directed by the learned single judge by way of the writ petition, and supposed to have been complied by the accused. That he has not been doing. He makes all claims of being an indigent. He claims that he is a practicing advocate and he wants to take shelter under that particular profession, Milaj. Therefore, Milaj, it is humbly requested that the IA may be dismissed as it is not at all maintainable, and this honorable court may kindly proceed with the framing of charges against him, Milaj.
Milaj, the very reason why he has filed this petition is because he is a registered association. There is nothing else, no other power which allows him to file this complaint. And at para number 2, he has made blatantly, even in the writ petitions, it is fraudulently obtained by making false statement that the association is registered. And my lord, the
registered association.
Allow me to speak. The learned.
He is arguing. Why are you interrupting? After that, you can.
ನನಗೆ ತುಂಬಾ ಅನ್ಯಾಯ ಇದೆ.
ಅಲ್ಲ, ಅವರದು ಆದ್ಮೇಲೆ ನೀವು ಹೇಳೋರಂತೆ, ಅವತ್ತು ಮುಗಿಲೇ ಅದು. Yes, that's all on your submission on IA 1 of 2024, Mr. Counsel for the complainant. That is all.
Milaj, yes, Milaj. Yes, Milaj.
Yes, hearing. Yes.
Milaj, current to in this whole city, there is only one authority and one law which allows disconnection of electricity. That is BESCOM. Whoever is the service provider, no other person can disconnect electricity to my flat or anybody's flat.
Can you argue on the merits of the case? You have to argue whether the contempt can be maintained or not. You have failed now. All these contentions were rejected by both courts.
Supreme Court said that it is false.
Where is Supreme Court? A judgment is here. Supreme Court has rejected your all contentions and imposed cost on you.
No, cost was recalled. Ades order na.
Recalled, but
yeah, it has been recalled.
These contentions, you cannot. You mind your language. You cannot use your language in this court. It's not a college campus.
Allah, it was recalled. The very order which imposed cost was recalled, knowing very well that it is false.
Complainant presented the complaint. Show me that order. Where is that order? Status in the matter and the
Milaj, all these are false submissions, Milaj.
Even earlier the judgment admission stage first time. So how do they clarify?
Subsequent order ಬೇರೆ ಅಲ್ಲ, ಈ ಫಸ್ಟ್ ಆರ್ಡರ್ ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆರ್ಡರ್ ಇಲ್ಲಿ ಕಾಪಿ ಇದೆ, ಅದರಲ್ಲಿ they had not appeared. ಅದೇ ಅಲ್ಲ ಅಲ್ಲ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಇವರು they should clarify because they are not appeared. When what transpired between the court and these people are not ಅದರಲ್ಲಿ ಬರೋದಿಲ್ಲಲ್ಲ. Visitation right ಇರ್ತಿತ್ತಲ್ಲ. What was the order dated 3/3? 3rd March same. The contempt notice is recalled on Karnataka. What is 35? No, what is trying to say is, the contempt notice is recalled on urgent discharge. As in the case in the discharge ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Where is that? Notice against contempt against petitioner is discharged ಅಂತ ಇದೆ ಅಲ್ಲ. He is trying to say that this notice. ಅದರಲ್ಲಿ ಎಲ್ಲಿದೆ Supreme Court order? And what he had challenged that and that is 21 order dated P3/2023. P3/2023. ಅಲ್ಲಿ ಯಾರು because ಅವ್ರು ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ because they have not appeared before the Supreme Court of
The court has said
ಇಲ್ಲಿ applications ಇಲ್ಲಿ ಇಷ್ಟೇ ಹೇಳಿದ್ರು considering the above special petition stands dismissed, we impose further cost of this 30,000 while dismissing the special petition. The quantified cost should be deposited before the Supreme Court within 4 weeks from today ಅಂತ ಇತ್ತು. This was on 3/3. The further order is passed on 21/3. Whether before this 21/3 Supreme Court had issued any contempt notice to you?
Yes.
Supreme Court had issued.
Yes.
So that notice is discharged there.
No. The order, very order 3/3/2023.
Where is that notice? Supreme Court contempt
Notice
for not deposit of the amount, no?
I did not get that.
That was ordered to be deposited within
4 weeks.
4 weeks. 3/3 in the
What happened after this
happened.
order?
This was the order.
3/3/23 is the order.
My lord, Swami, at page number 119 of the petition filed by the complainant.
119. That is
Supreme Court.
Supreme Court the order of 2020.
This order is dated 3/3/2023. This order was recorded. That means that
Not entire order is recalled. It says only this cost and contempt notice is discharged ಅಂತ ಹೇಳ್ತಾರೆ. So whether a contempt notice was issued to you after 3/3/2023 from the Supreme Court?
Yes, sir. There is a contempt notice to you.
contempt note, I will bring it in the.
You have that copy?
Yes.
Supreme Court contempt notice.
Show us that copy. Then you produce that notice copy, we'll see what
Yes,
is the order.
I will bring it tomorrow itself. Day after tomorrow.
Milords, this is the kind of submissions he has been making, Milords. And just to drag on the proceedings, just to escape the liability, he has been making such submissions.
The court asked you to clarify what happened. You were asked to appear, but both the orders show that you had not appeared. Even before your appearance, those matters were disposed of. Now he says that contempt notice was issued and he seeks time to produce that. Let him produce that, then we'll consider this IA1 of.
Milords, I was not a party to that proceedings before the Supreme Court, Milords.
That is what we are saying, because we don't have any material before us.
Sure.
One last submission at page number 5 of the.
Right, we'll consider your IA1 of 2024. You produce that copy of that contempt notice, then we'll consider.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅದೇ ನಾನು ಇದೊಂದು ಅವ್ರ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 2 ಒಂದು I'll just read that. Petition, our petition alle page number 5.
Page number 5.
It is submitted that the complainant is a resident welfare association represented by so and so. The said association is established and registered under the provisions of.
Correct. See, to consider all these things, now you have filed IA1 of 2024.
One submission enandre, because of this, he gets the authority to file this.
That will consider later whether
Please,
that can be considered at this stage or
please.
not. You said you did not comply this 2023 order of the Supreme Court, therefore.
I will get it. Day after tomorrow, ನಾನು ತರ್ತೀನಿ ನೋಡಿ.
The accused is physically present. Counsel for the complaint appears virtually. Accused submits that for not depositing cost of 30,000 by virtue of the order of Supreme Court dated 3/3/2000. Order dated 3/3/2023 passed by the Honorable Supreme Court in special leave petition into bracket criminal diary number 40,397 of 2022. Contempt notice was issued to him, and that notice was discharged by order dated 21/3/2025. He seeks time to produce the copy of the said notice. Or further proceedings in this was filed in 2024. This miscellaneous application.
Yes.
Or at least to produce the copy of the miscellaneous application. He shall produce the copy of produce.
ಸ್ವಾಮಿ ಕೋರ್ಟೆ ಸುಮೋಟೋ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಅದು. ನಾನೇನು ಹಾಕಿಲ್ಲ ಅದು.
Produce the copy of miscellaneous application number 1971-1973 of 2024 in SLP into bracket criminal number 3191-3193 of 2023, and the contempt notice issued to him by the Honorable Supreme Court. List on ಎರಡು ಹೇಳಿದ್ವಲ್ಲ, ಅವ್ರ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. ಇಲ್ಲ, ಈಗ ಎರಡು ವಾರದಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಆಗುತ್ತೆ. 2 days, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕಾಪಿನ ಕೊಡಬೇಕು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿದಂತ ಕಾಪಿ ನೀವು.
No,
ಅದೇ ಸುಪ್ರೀಂ
that
ಕೋರ್ಟ್
contempt notice, you see the order, that SLP miscellaneous application copies, right?
Order sheet signature.
Order sheet.
For final hearing, serial number 44, SB Hegde
List on 5.
6.
Today I have filed a memo of appearance for R1 and R2. As per the
Of appearance, why? Why
R1 and R2.
signature ಮಾಡೋಕೆ ಬಂದಿದ್ರು R1 and R2 are the claimants. Why memo file ವಕಾಲತ್
Insurance company appeal.
correct. Why memo of appearance file ವಕಾಲತ್?
As per the High Court of this Honorable Court direction, today I have filed.
When was the direction issued?
Criminal appeal ಆಯ್ತು.
High Court Legal Service. You are the counsel for High Court Legal Services. ಮತ್ತೆ ಅದು ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು. I have filed memo of appearance ಅಂತ ಹೇಳಿದ್ರೆ ಏನು, what is your name?
Jayashree Kulkarni.
Srimati Jayashree Kulkarni, the panel advocate of High Court Legal Services Committee, submits that she has filed memo of appearance for
R1 and R2.
respond number 1 and 2 in the registry. You have filed it already.
Yes. Today only I filed.
Registry shall verify and if found correct, show her name in the cause list accordingly. There were only 2 claimants.
Yes, madam, only 2 claimants, wife and mother of the deceased.
The appeal is already admitted. Okay,
Yes,
I will let her file. Then we will consider 2015 matter either.
Yes.
2015 matter. My lord, the continue.
You have gone through the file? You are ready for hearing?
Today only I have taken the file from HCL. Legal Service.
As requested, I have list on. ಓದ್ಬೇಕು ಮುಂದಿನ ವಾರದೊತ್ತಿಗೆ, ಯಾಕಂದ್ರೆ 2015 ಮ್ಯಾಟ್ರ್. List on 996.
Number 45.
ಗಟ್ಟಿಹಳ್ಳಿ ಗೀತಾ, SPP.
Could the accused too, please, my lords? Could the appeal before this honorable court, my lords? There's a paper book also, my lords.
Who is R2 then? Oh, the POXO case ಇರೋದಂತ
Yes, my lord.
Then we have to appoint some amicus curiae because she served unrepresented.
My lord, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ my lord? POXO case ಅಲ್ಲಿ he's been convicted for 10 years and he has completed the entire term, my lord.
Then if that is the case, he will be released.
Yes, my lord. ಇನ್ನೊಂದು section ಹಾಕಿದ್ದಾರೆ, section 3 subsection 2 subclause 5.
SC/ST-PA Act.
Yes, my lord. Now my lord can kindly see what that provision is.
Correct. See, even under section 15A of the SC/ST-PA Act, now there are the judgments that if they fail to appear, we have to give them free legal aid. We'll appoint somebody here as a amicus curiae. You can serve the copies on them if you want.
Notice ಕೊಟ್ಟಾಗಿದೆ, ಅವ್ರ acknowledgement ಬಂದಿದೆ.
Correct. Law. Are you aware of the legal position or not? Then whether you or us can we, exceed that?
Actually, it's a simple question of law, my lord. Nobody can challenge that. For a minute, my lord. ನೀವು ದಯವಿಟ್ಟು section 3 subsection 2 ನೋಡಿ ಮ್ಯಾಮ್.
ಇದು amended ಹಾಕಿದಾರಲ್ಲ, ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡೋಣ, ಯಾರನ್ನ ಅವ್ರ 10 ವರ್ಷ ಆದವ್ರು ಕ್ರಿಮಿನಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಅವ್ರು ಮಾಡ್ತಾರೆ ನೋಡಿ. ಎನಿ ಕ್ರಿಮಿನಲ್ ಪ್ರಾಕ್ಟೀಷನರ್ಸ್ ವುಮೆನ್ ಇಲ್ಲ ಕಾಣ್ತಾ ಇದಾರೆ ಹಿಂದೆ. ಹೂ ಆರ್ ದೋಸ್ ಲೇಡೀಸ್? ಯಾರಾದ್ರೂ ಕ್ರಿಮಿನಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದವ್ರು ಇದ್ದೀರಾ ನೀವು? ಇದ್ದವ್ರು ಇರ್ಬೇಕಲ್ಲ. ನೀವೇ ಆಲ್ ದ 3 of you, have you completed 10 years? Have you?
The court is talking to you. Please stand up. ಯಾರಾದ್ರೂ ಇದ್ರೆ ಅಮಾಯಕ ಮಾಡಿದ್ರು. 10 years ಆಗಿದೆಯಲ್ಲ.
ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದಿರಿ?
10 years ಆಗಿದ್ರು ಮುಂದೆ ಬನ್ನಿ.
ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದಿರಿ? which side you have practiced? 10 years. ಕ್ರಿಮಿನಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದಿರಾ? ಕ್ರಿಮಿನಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಸೆಷನ್ಸ್ ಕೇಸ್ ಟ್ರಯಲ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದಿರಾ? ಯಾವ ಅಫೆನ್ಸ್ ಅದು? ಬರೀ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕೊಟ್ಟಿದಾರಂತೆ.
ಎಷ್ಟು ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್?
ಬೇಡ ರೀ, ಇವ್ರು ಇದಾರೆ, ರೋಹಿತ್ ಮಾಡ್ತಾರೆ ಕ್ರಿಮಿನಲ್. ಅದೇ ಅವ್ರು ಮಾಡ್ತಾರೆ.
HCGP
ರೋಹಿತ್ HP ಶಂಕರ್. Respond number 2. Those served as unrepresented. ಅವ್ರೇನೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಹೆಸರೇ ಕಾಣ್ತಾ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. ಏನದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಹೆಸರು? ಶ್ರೀಮತಿ ಧನಲಕ್ಷ್ಮಿ. ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ಹಾಕಿದೀರಾ?
ಹಾಕಿದೀವಿ ಮೇಡಮ್.
ಇದು ಕಾಣ್ತಾ ಇಲ್ಲ. ಬರೀ ಅಮೆಂಡೆಡ್ ಇದನ್ನ ಒಂದೇ ಪೇಜ್ ಅದು ಹಾಕಿದ್ದಾರೆ. ಅದನ್ನ ಅದಕ್ಕರ ಸೇರಿಸಿಡಿ, ಯಾಕಂದ್ರೆ ಅವ್ರು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದು ಓದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದು who has carried out this amendment?
Myself I can.
ಅದೇನು ಓದಕ್ಕೆ ಬರೋದಿಲ್ವಲ್ರಿ?
ಇಲ್ಲ, ಒಂದು ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಹಾಕಿದೀವಿ ಸರ್.
ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದಿರಿ, ಅವ್ರು ಅದನ್ನ ಪ್ಲೇಸ್ ಮಾಡಿಲ್ಲ. have produced only first page of the typed copy. ಅದರಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ರಿಪ್ಲೇಸ್ ಮಾಡಕ್ಕೆ. ಏನು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2. Those who is unrepresented, the matter involves the respond number 2 is complainant.
Yes, my lord.
Dhanalakshmi. Who is the victim?
Her daughter. Her daughter, my lord.
ಅಲ್ಲ ಅವರ ಎಷ್ಟು? PW ಎಷ್ಟು?
PW2 is the victim. PW1 is the complainant.
ಹೆಸರು ತೋರಿಸಬಾರ್ದವ್ರು, ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ. The matter involves the offences under the POXO Act and SC/ST-PA Act. Adopt the judgment in view of section 15(1)(a) ಅಲ್ಲ, SC/ST-PA Act 15(a) Act. ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವುದು? ಲೀಗಲ್ ಫ್ರೀ ಲೀಗಲ್ ಏಡ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅನ್ನೋದು ಯಾವುದು? ಜಡ್ಜ್ಮೆಂಟ್ ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ರೀಕಲೆಕ್ಟ್. ಮಾಡಿದ ಅಲ್ಲ, ಅದು POXO Act ಗೆ ನಾವು ಮಾಡಿದ್ದು. POXO Act, ಇವನ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ವಾಟ್ ಇಸ್ ದಟ್ ನೇಮ್ ಆಫ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್? ಸೊ ಅಂಡ್ ಸೊ ಇಲ್ಲ, SC/ST-PA Act ನಲ್ಲೂ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ. ನೀವೇ ಆ ಸೈಡ್ ಬರ್ತಿರೋರು ಜಾಸ್ತಿ, ನಿಮ್ಗೆ ಗೊತ್ತಿರಬೇಕು. ಹೇಳಿ ಜಡ್ಜ್ಮೆಂಟ್. ರೆಸ್ಪಾಂಡ್ ಸರ್. Free legal aid has to be given to respond number 2. Therefore, Shri S. Shankar, initial H.S. Shankar, learned counsel, is appointed as amicus curiae to represent respond number 2. Notice ಹೋಗಿತ್ತಲ್ಲ ಅವ್ರಿಗೆ, ಕಾಪಿ ಕೊಡಿ. ಇಲ್ಲ, ರಿಜಿಸ್ಟರ್
ಹೋಗಿದೆ, ಅವರು ಅಕ್ನಾಲೇಜ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ.
ಅಲ್ಲ, ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇರೋದಿದೆ ಅದು. ದಿಸ್ ಇಸ್ 2012 ಅಲ್ಲ, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇದೆ ಅದು. ಅಲ್ಲ, ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಫ್ರೀ ಲೀಗಲ್ ಏಡ್ ಇದಲ್ಲ. ರೈಟ್ ಅದು ಬರ್ಕೊಳ್ಳಿ ನೋಡಿ ಹೇಳ್ತೀನಿ. ರಿಜಿಸ್ಟ್ರಿ ಶಾಲ್ ಫರ್ನಿಶ್ ರಿಜಿಸ್ಟ್ರಿ ಫರ್ನಿಶ್ ಕೊಡೋದಾದ್ರೆ ಡಿಲೇ ಆಗುತ್ತೆ, ನೀವು ಕೊಟ್ರೆ ಬೇಗ ಆಗುತ್ತೆ ನೋಡಿ.
ಅವ್ರ ಕಾಪಿ ಕೊಡೋದ
ಕಾಪಿ ಕೊಡೋದು
ಖಂಡಿತ ಕೊಡೋಣ. ಗಿವಿಂಗ್ ಟುಡೇ.
Appellant's counsel shall furnish him the copies, list on. Mr. Registry shall show his name in the process accordingly, list on. Next week. 11/6.
Day after tomorrow. Now only I will furnish the copy. Day after tomorrow.
11/6. ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಮೇಲೆ ನೀವು ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಓದೋದಕ್ಕೆ
ಕೊಡ್ಬೇಕಲ್ಲ ಈಗಲೇ
11/6.
ಓಕೆ.
Cell number 46 urgent, cell number 47 Rajesh Shetty, Shankar.
ಅಲ್ಲ 15 ಮನಿ ಏನಲ್ಲಿದೆ 15 ಮನಿ ಇರ್ಲಿ ಅದು ನೋಡಿ ಹೋಗ್ತಾರೆ. Yes, serial number
46 urgent, 47 Rajesh Shetty, H. Shankar.
Okay, appellant in this matter.
It is this TI application is pending since 2019. Records are also received. What is the order passed?
There is a matter between the husband and wife. The suit was filed for partition of the scheduled property on the ground that the property was purchased in the husband's name. Wife has said that she has also contributed for purchasing the property.
Suit is dismissed.
During the pendency of the suit, after the matter is posted for judgment, Your Honor, may kindly see page 24 of the judgment. The suit has been dismissed.
The suit is dismissed. What
Suit
you
is dismissed.
24 alien, what do you want?
Page 24, that is ink page 24. After the matter is posted for judgment, the Honorable Trial Court frames fresh issues.
Traditional issue.
Yes.
And no opportunity was
No opportunity was given for a leading evidence. While discussing the order, you have not proved this, you have not proved that.
Not been framed and issue number 1 is.
Opportunity should have been given for leading
Issue
further
number 1
evidence.
is not required.
It is not necessary, there is no necessity for, that is the finding of the court
Delete
below.
issue
But
number 1 and that is ಸರಿ ಅಲ್ವಾ? ಹಾಗಾದ್ರೆ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿದ್ರೆ they should have been given opportunity. Correct, whatever it may be. Once the issue is framed, then party should be notified about that and they should be given a opportunity to lead evidence on that ಅಲ್ವಾ? ಅಷ್ಟೇನಾ? ಇದು ರಿಮೈಂಡ್ ಆಗ್ಬೇಕಾ?
ಅಷ್ಟೇ.
But still, you ಅಲ್ಲ, is it correct? Curable? ಅಲ್ಲ, ಅದಕ್ಕೆ ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಅಷ್ಟೇ. So you consider that question that issue was framed during the course of passing the judgment. Therefore, I deem it fit to delete issue number 1 and frame the following issues. ಅಲ್ಲ, ಕರೆಕ್ಟ್ ತಾನೇ ಅವ್ರು ಹೇಳೋದು ಕರೆಕ್ಟಾ? ಇಶ್ಯೂನ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ಜಜ್ಮೆಂಟ್ ಮಾಡಿದಾರ?
ಹೌದು. After the matter was posted for judgment, these issues were framed.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಅಲ್ಲ? Issues framed on first time issues framed on 10/7 dated. ಇಲ್ಲಿ ಇದ್ರ ಹಿಂದೆ additional issue ಅದ್ರ ಹಿಂದೆ 2018. The suit scheduled property was purchased in the name of defendant out of her. This is on 1/1/2018. Additional issue.
Yes.
Judgment date? Correct. Judgment date 1/2/2018. ಅಲ್ಲ, ಈಗ ಪಾರ್ಟಿ ಶಾಲ್ ಅಪಿಯರ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಅಂತ ಮಾಡಿ ಲಿಮಿಟೆಡ್ ಅದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ ಕಳಿಸಿ ಅಂತ ಹೇಳೋದ ಹೇಗೆ? ಅದರ್ವೈಸ್ ಇಟ್ ಗೋಸ್ ಫಾರ್ ಅನದರ್ ಮೆನಿ ಇಯರ್ಸ್. That is, see, read order 14. How does she come to know that such an issue is framed? She has to answer that. Because burden of proof was on her. Whether plaintiff proves that the suit scheduled property was purchased in the name of defendant out of her savings. The plaintiff proves that defendant thrown herself and her children. Where was the need of deleting issue number 1? It was her contention that they were thrown out of the house. The trial court deletes. ಇಲ್ಲಿ deleted and judgmental ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ delete ಮಾಡಿದ್ದಕ್ಕೆ ಏನು issues ಮೇಲೆ there is no endorsement. ಈಗ ಎಂಟೈರ್ ಇದು ಮಾಡು ಇದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಬೇಕಾಗುತ್ತೆ ಅವಾಗ ಜಜ್ಮೆಂಟ್ ಅನ್ನ. ಡಿಲೀಷನ್ ಇಸ್ ಆಲ್ಸೋ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೆಟ್ ಅಸೈಡ್. No, what was the suit one? It was property was purchased in which year? No. This was 26/2/2023. Prayer in it for partition and allot plaintiff share in the suit property by meets and bounds. Any other matrimonial proceedings were pending? It is still pending.
There is a domestic violence proceedings pending before this honorable court. Subsequently, they have filed a petition for divorce. The husband has filed a petition that is before the family court.
That is still pending before the family court.
Recently, last year they have filed.
She was doing business since. What was the date of marriage?
7/3/1999.
The date of marriage. What was the date of purchase of the property? Sale agreement ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್. ಆಯ್ತು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಡೇಟ್ ಹೇಳಿ. 31/1/98 date of agreement of sale. 22/1/2005. So marriage sale deed was after marriage. Date of sale deed. All right.
Then there was
Whether
construction of house.
any amount was paid under the sale agreement? How much was paid? What is total sale consideration? Agreement is also produced. Exhibit copy of the sale deed. ಅಥವಾ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೇ ಇರಬಹುದಲ್ಲ. P1 is D1 is agreement. ಅಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೂ ಮೊದಲು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಆಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿರ್ತಾರೆ ಅನ್ನೋದಿದ್ರು.
My synopsis I have mentioned the date of the sale. Registration
ಅಮೌಂಟ್ ಅದೆಲ್ಲ ಬಿಕಾಸ್ ಮ್ಯಾರೇಜ್ ಬುಕ್ಸ್ ನೀವು ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. Exhibit P1 is the sale deed.
In 2007-8, it was a vacant site. House was constructed. 4 houses were constructed.
In exhibit P1 there is no reference to sale agreement. ಅಲ್ಲ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅಂತ ಹೇಳಿ ಅಡ್ವಾನ್ಸ್ ಕನ್ಸಿಡರೇಷನ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅಂತ ಎಲ್ಲಿದೆ ಅದರಲ್ಲಿ? ಇಲ್ಲ ಎಲ್ಲೂ ಕಾಣ್ತಿಲ್ಲ. ಇನ್ನು ಜನರಲ್ ಫಾರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅಂತ ಇಷ್ಟೆಲ್ಲ ಇದೆ. ರೈಟ್. ಎಕ್ಸಿಬಿಟ್ E1 is the sale agreement. Is it admitted or disputed?
E2 is the sale deed.
ಅಂದ ಸಾಕ್ಷಿದಾರ ಸಮಕ್ಷಮದಲ್ಲಿ ಕ್ರಯದ ಪೂರ್ತ ಮೊಬಲವು 83% ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. What was the property then? ಇದೇನಿದೆ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿನಲ್ಲಿ ನಿವೇಶನವನ್ನು ವಿಂಗಡಿಸುವ ಪಟ್ಟಿ. ಸೊ ಸೈಟ್ ಇಟ್ ವಾಸ್ ಸೈಟ್.
It was a vacant site. Subsequently
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾವಾಗ ಆಗಿದೆ? ಯಾವ ಇಯರ್ ಅಲ್ಲಿ?
2007-8. 2007 and 8. Between 2007 and 8, the construction took place.
Why for such a long time sale deed was not taken? 83,000 is the Sale consideration under exhibit D1. As per the sale deed, the sale consideration is 84,000. 1,000 ಜಾಸ್ತಿ ಆಯ್ತು. So by the time the sale deed was executed, the house was not constructed.
No, no. My specific contention is that he is a handicapped person. He is a blind. So I have done the business and she was this tender coconut business.
All these things are not there.
Yes.
Anyway, now because this was not framed. ಡಿಲೀಟ್ ಮಾಡಿದ್ದು ತಪ್ಪಲ್ಲ. ಅಪಾರ್ಚುನಿಟಿ ಕೊಡ್ದೇನೆ ಇಶ್ಯೂ ಡಿಲೀಟ್ ಮಾಡಿದ್ದು ತಪ್ಪಲ್ಲ. Order 14. Before deleting the issue, she was not heard by the trial court. Before deleting issue number 1.
After the judgment, all these issues.
Order 14 rule 5, na?
And
Amendment of the issues.
All these things were done after the matter was posted for judgment.
That court may at any time before passing the decree amend the issues or frame additional issue on such terms as it is fit, and all such amendments or additional issues as may be necessary for determining matter in controversy shall be so made. The court may also at any time before passing the decree strike out or where is that issues ನೋಡಿದ್ರೆ ಅಪಾರ್ಚುನಿಟಿ ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ಅಷ್ಟೇ ನಾವೇ ಮಾಡಿದ್ರೆ ಹಂಗಂದ್ರೆ after can you show us by we'll list it tomorrow 442 opportunity ಕೊಡಬೇಕಾಗುತ್ತೆ ಅನ್ನೋದ್ರ legal question order 14 ಇಂದ ಓದೋವಾಗ 14.5 it is not found there ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡು ಬನ್ನಿ ನಾಳೆ as requested list tomorrow ನಾಳೆ ಡೇಟ್ ನಾಳೆ ಅಷ್ಟೇ ಆದ್ರೆ ಮಾಡ್ತಾರೆ ಮೀಟಾಕ್ ಹೋಗ್ತಾರೆ ಸರ್ ನಾವು ಪಾಠಾಡ ಅಂತ ಮಾಡಿಲ್ಲ ಅಂದರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಇರ್ತೇನೆ ಫಸ್ಟ್ ಮೆಥಾಡ್ಸ್ ಇಲ್ಲಾಂದರೆ ಹಾರ್ಡಿನ ಪಾರ್ಟ್ ಅಂದರೆ ನಾವು ಬರುತ್ತೆ ಮೇಲೆ ಬಂದ್ಬಿಡುತ್ತೆ ಬಿಫೋರ್ ಅಡ್ಮಿಷನ್ ಅದೇನು ಇಷ್ಟೇ ಇರೋದಲ್ಲ ಬಿಫೋರ್ ಅಡ್ಮಿಷನ್ ಮಾಡ್ಸೋದು ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ನಮ್ಮ ಡೇಟ್ ಗಿವನ್ನೇ ಜಾಸ್ತಿ ಇರಬೇಕು ಪೊಲೀಸ್ ಸಾಹೇಬ್ರದ್ದು ಇದೆ ಅಲ್ಲ ಬೇರೆಯವ್ರ ಬೆಂಚ್ ಹೇಳಿದ್ದಾರೆ ಸಮ್ ಮಿಸ್ಟೇಕ್ ಅದನ್ನು ಅಷ್ಟೇ ರೆಕ್ಟಿಫೈ ಮಾಡೋದಕ್ಕೆ 5 ನಿಮಿಷ ಮಾಡೋದು ಅದು ಗೊತ್ತಾಯ್ತು ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಇದು ಯಾವ ಇಯರದ್ದು ಇದು 18 ಅವ ಯಾವ ಇಯರದ್ದು ಅವು ರಿಟ್ ಅಪೀಲ್ಸ್ ಇತ್ತಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ರಿಟ್ ಅಪೀಲ್ಸ್ ಸರ್ವಿಸ್ ಸರ್ವಿಸ್ ಅದು 22 ಒಂದು ಕ್ರಿಮಿನಲ್ಗೆ 17 ಸರಿ 22 so you give us those judgments tomorrow heard in part for further hearing list tomorrow yes submission we have to conclude all matters next yes Cell number 48, P.S. Shastri, Pavan Kumar Vayan.
I appear for the respondent, my lord.
Next week.
Please. Okay.
As requested, list on 12/6. 12/6. Cell number 49, Bhanu Prakash H.V. Mrs. Sitaram Rao. There other side ilvalla. List on 16/6. 16/6. 16/6 ಅಂದ್ರೆ ಒಂದಿದಾದ್ಮೇಲೆ ಅಷ್ಟೇ ಬರುತ್ತೆ ನೋಡೋಣ ಸೆಲ್ ನಂಬರ್ 50 ಗೋಪಾಲ್ ಕೃಷ್ಣಯ್ಯನ್ ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ
ಸರ್ವಿಸ್ ತಗೊಂಡಿದ್ದೀವಿ
ಒಂದರಲ್ಲಿ ಇನ್ನೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ವಾ R6 ಸ್ಟ್ಯಾಂಡ್ ಡಿಸ್ಮಿಸ್ಡ್ ಸಿನ್ಸ್ ನಾಟ್ ಟೇಕನ್ ಫೇವರಬಲ್
2331 ಅಂತ ತಗೊಂಡಿದ್ದೀವಿ
2331 ವೇರ್ ಇಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಆಗಲೇ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತಲ್ಲ
ಅದನ್ನ ರೀಗ್ರಾಂಟ್ ಮಾಡೋದಕ್ಕೆ ಪರ್ಮಿಷನ್
ವೇರ್ ಇಸ್ ದಟ್ ಅಪ್ಲಿಕೇಶನ್ Have you filed application to recall that order?
ಇನ್ನೊಂದ್ಸತಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಮೇಡಮ್.
ಮತ್ತೆ ಹಾಕೋಬೇಕಲ್ಲ. No, it's already dismissed. Released on date 17/6. Cell number 51, Rajat.
I appear for the appellant.
Ramesh Sharbi.
I'm on instructions
I appear
to
for the
withdraw the
respondent,
appeal.
You
I'm on
want to
instructions
withdraw
to
the appeal?
please, my lords, I want to withdraw the appeal because, my lords, the appellant wife is not interested to pursue the matter. There is a stay operating in this case. Lords, may I request, my lords, to kindly permit me to withdraw the appeal and dismiss the.
No, you have to file a
Please,
memo or
my lords,
application.
I'll file an application and a memo. My lords, may give a date, my lords.
5/6.
Obliged, my lords.
Obliged, my lords.
Cell number 52. ಅಲ್ಲ ನೀವು ಮುಂದಿನ ವಾರನೇ ಹಾಕಿ.
My lords, my lords, may I request for next Monday, my lords, Monday or Tuesday.
10/6.
Obliged, please.
Cell number 52. Sharat Kumar Shetty.
Desertion 13 years. So after delivery of a lady, female girl, so he is deserted from the day one cross-examination.
No, what was the petition before the trial court?
It's dismissed the petition.
No, she had filed or
She has filed.
restitution?
No, divorce.
Released on 2024, not possible.
Petition filed in 2019 you
Maybe.
responding to evidence ಮಾಡಿಲ್ಲ, just cross-examination, argument ಮಾಡಿಲ್ಲ.
19/6.
Obliged.
Cell number 53, 54 adjourned. Cell number 55, Nagaveni. Case Harish.
Serial number 55 appearing for the respondent in this case, my lord.
2025. ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ 2025?
ಅಲ್ಲ ಸೆಟ್ ಅಸೈಡ್ ಕೇಳಿದ್ವಿ ಸೆಪರೇಷನ್ ಇದೆ kindly pursue that.
We have 2014-15 matters, matrimonial cases, appeals. You come before the court in 2025 and you seek priority list after 2 weeks. Yes.
Cell number 56, Subhas CS, Gajendra Vasuke.
My lord, I am appealing for appellant, my lord. This is second of litigation, my lord. 2001 filed, my lord, one was MC also, my lord.
What happened in 2001? It was dismissed.
Possibly reunion, it's dismissed, my lord. As a possibly.
In 2001, your petition for divorce was dismissed.
No, my lord. Last 2008, this is second of my lord. But
So second time
from
also?
2010 is going, my lord.
Petition, original petition is of the year 2010.
So,
Only
part-
one, first round of litigation. No, is it a first round of litigation? Second round of litigation?
Yes.
He again filed. List after 2 weeks. 2 weeks, no urgency. Hereditary dismissal. ಕ್ವಶನ್ ನಾವು ಅಷ್ಟೇ ಇರೋದು ಸೈಟೇಷನ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ ಅಲ್ಲೇ ಮಾಡಿ.
List after 2 weeks. ಇದು ತೋಳಿ ಮೇಡಮ್.
Madam, date ಏನಾದ್ರು ಕೊಟ್ಬಿಡಿ.
ಮೇಡಮ್ ಇದೊಂದನ್ನ ಬರ್ಕೊಟ್ಬಿಡಿ ಇದು ಥರ್ಡಿನ್ ಪಾರ್ಟ್. ಸರ್ ಇದೊಂದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಬೇಕಂತ
List after 2 weeks ಅಂತ.
ಅದೇ ಕೇಳಿ
ಡೇಟ್ ತಗೊಂಡು
ಸುಮ್ಮನೆ ಹೆಂಗ್ರು ಅಷ್ಟೇ ಕಣ್ಣಲ್ಲಿ ಅವಾಗ
ಒಂದೇ
ಕೇಳ್ಕೊಂಡ್ಬಿಡೋಣ
ಪೇಪರ್
ಅದಕ್ಕೆ ಕೇಳಿದೆ. ಇಲ್ಲ TCR ಏನ್ ಬೇಡ, ಬರೀ ಇದು ಮಾತ್ರ
ಮೇಡಮ್
ಹಳೆಗೆ ಇದೆ.
ಡೇಟ್ ಕೊಡಿ.
ಇಲ್ಲ ನಾವು ಕೊಡಕ್ಕಾಗಲ್ಲ ಸರ್. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.